good morning over in wherever you tune in from. Are you surprised? You might be. This is not how I usually look on this channel, but I got home from work minutes ago, and I thought instead of just ripping it all, changing clothes, I might this. If you met me in a professional setting, something like this would be it. All right, I will change in a good break because looking good, but comfortable. No, work is work, home is home, fun is fun. So yeah. Hello, everybody. Very, very nice to see you all. We are finally here. I've been covering this case for months and months and months. Doorbell hearings, jury selections, pre-trial motions, the kitchen sink, and the aunt. From the get-go, this has been a plus. If you are completely new here, ask my regulars in the chat, and they will tell you that this is my motto on this channel. Yeah, and I know the court has gathered now in the morning. The judge told them on Wednesday before Thanksgiving that 8:30 Monday morning, everybody in the courtroom. Then the plan for them is to start the trial 9 a.m. Eastern time. And but we also know that this judge, when he says 15 minutes, he might mean 2 hours. So will it start 9 a.m.? Don't know. Everybody has to gather. That means all the defendants, all the lawyers, the entire prosecution team, and all the jurors and personnel. This is a huge trial. Even if they gone from 28 defendants to 6, it is an enormous trial. This is more or less a murder trial for 6 people simultaneously. And for you who don't know, this is a RICO trial. RICO is when the state wants to prosecute multiple people as a criminal enterprise. Racketeering and all of that stuff. And under the Georgia RICO Act, that's charge number 1 against all of them. No, that's the indictment for all 6 defendants. In that indictment, it is 191 charges, spanning from more or less from jaywalking to murder and everything in between. They are throwing everything in. And if you followed me for a while, you also know that my opinions about the Georgia RICO Act and how they have conducted themselves over this past year and a half, not happy. I think it's a travesty, to be frank. I'm not entirely sure why this entire case wasn't thrown out. But here we are. This is day 1. We are at... Well, this is the trial. Everything that happened pre-trial, all the motions, all the shenanigans, all that is gone now. It's gone now. Now we're at square one. Day 1, opening statements. that, according to the judge, will begin at 9 a.m. Not so sure, because as I said, there's a lot of people have to be gathering around. And as per usual, my nicotine pouches. Where's Dave? He said he would be here, but he isn't here. Can you survive without me for just a few seconds while I go and give me a few seconds. Hello again. Yep. Don't start with it, kids or adults. It's not healthy, but hey, what is? Let's see here. Catherine, how long is this trial scheduled for? It was scheduled for 6 months before the prosecution added over 200 names to the witness list. Yeah. Just went to raid a neighboring village. Oh, Helene, better than smoking. I can do an entire stream about why these are not as promoted as, the stickers and the chewing gums and stuff like that. That's another story for another day. Let's see here. First of all, thank you to Brandon, who showed up here very early. Thank you for your $2 super chat. First, yes, you were. And then, if I'm covering this trial gavel to gavel, I'm going to need to restock the booze shelf. Oh yeah, because 6 to 9 months. I personally think that this could be a year-long trial, unless because what we found out during pre-trial motion is that the defense, several of the defendants, have appealed certain decisions, and a handful of those motions are sent to the appellate court in Georgia. If one of those handful goes through, the court says, yes, this was an error. Trial stops. Boom. So we don't know. Everything can happen. Oh, thank you again. Thank you, Brandon, for your $5 super chat. While the judge wakes up, showers, throws on his robe, etc., can we get a brief recap? Maybe go through the main charged crime or all the witnesses. Oh, all 737 witnesses the prosecution wants to. No, I can't. Well, the Georgia RICO Act is. They are charging the YSL-gang, Young Slime Life, where they allege that Jeffrey Williams is the leader or co-leader of. And they are charged under the RICO Act, which is racketeering, blah, 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 blah. It's an umbrella for all the crimes they have allegedly committed for the past 11 years. Yes, the 191 charges within the indictment spans from money laundering, murder, attempted murder, armed robbery, theft. I mean, the lot. So, and in the Georgia RICO Act, every individual within that gang, if person 1 commits that crime, it means that all can be charged and convicted for it under the Georgia RICO Act. And Oh, really? My wife's got a summons for this week. I wish we lived in Georgia. Oh. Yeah. The jury selection alone took almost 11 months. And they have now selected 12 jurors and 6 alternates, which, in my opinion, is too few. Statistically, people will get sick. People might old age and everything. So will witnesses. I mean, 737 witnesses for a trial that can go on for a year. But it can also be stopped by the appellate court. And so prepare for the worst, hope for the best, prepare for the worst. How will my coverage of this be? I will stream this week. I'm streaming. Then I will alternate between streaming live, doing recaps, or streaming a bit behind, because I have work. My work schedule has to come first. That's what pays the bills so far. And so that is my schedule for this. But I have prepared myself for a year-long trial for this. I have invited guests. I will keep inviting guests over. And yeah, yeah. Basically, if you tie your shoes next to the guy who committed the crime, you get charged too. Yeah, and that I have an example of. Back in 2015, 8 years ago, Mr. Young Thug was attending a festival of sorts, a get-together, a barbecue. I'm not sure about the circumstances. A brawl broke out because somebody tried to get to Mr. Williams, Mr. Young Thug. He removed himself. A person was shot in the leg. Cops showed up, did all the interviews, and at the scene, they ruled it, and it is in the police report, that this shooting was probably justified. No charges was ever brought. No indictments, no nothing. Nothing came out of it. That charge is now in this indictment. So, in my opinion, this is a trial by sheer volume. And I'm not exactly sure why the judge allowed all of this. Because November last year, when the prosecution said we are ready for trial, they had 79 witnesses. And since then, it has grown to 10 times that amount. And for me, logically, when they say they are ready for trial, they begin jury selection. For me, sure, keep investigating, but adding on 650 more witnesses during this year, no, you were never ready for trial. And the judge allowing this to happen, I simply don't get it. And then you have the discovery phase, and the Georgia rules says the entirety of the discovery must be in the hands of the defense at least 10 years before trial day 1, as in today. For me, that includes the entirety of the witness list. For me. The final witness list was given to the defense Friday just before 5 o'clock. Kim asks, surely a trial with volume has a real potential to go against the state, especially with the jury. It might be. It might be. Yeah, and with experts like Pinch and Zoom guy and gang expert. Yeah, Pinch and Zoom guy, that's a hoot. The state wanted this person. The state wanted in as a forensic video analyst. After the Daubert hearing, which is where the prosecution and the defense proffer the expert, the entirety of his job description, what he does for the police force, for the investigators and stuff, he receives video, like body cam or surveillance cam. They make a request to him. So what he does is that he plays the video to the time they say, this we need enhanced. So he pauses, takes a screenshot to Photoshop, and then pinch and zoom the part they want enhanced. That's the entirety of what he has done for a living for the past 25 years for the Georgia police, police forces all around Georgia. At least he wasn't accepted as a forensic video analyst, but he was accepted as a video enhancement expert. My niece, age 3, knows more. I had no idea you could do that for a living. If I had known, I would have applied the ever-living frick out of that job. Imagine working as a consultant for the law enforcement, and all you do is receive videos, pause it, screenshot it, and pinch and zoom. I mean, thank you. Cleaned up. This is, if you met me in a professional environment, this is probably what you would see. Now, if you followed me for a while, you know this is not my normal look. You know that. Defense should get the expert from Edgecombe trial. That guy was good. I don't know what witnesses the defense plan to call, but on their witness list they have 59 people, and apparently that is a number that has been around for a year. So they have had everything prepared for a year for this, while the prosecution piles on, and more pile on. Hold on. Camera resolution. Yeah, it's still up. Oh, it's lighting. And the gang expert. One of them. I think there are 3 or 4 since 3 or 4 more after that guy we saw in the Daubert hearing a few months ago. And he is one of 2 people who worked at the correctional center as a gang expert. And he worked there for a solid 11 months at the time of the Daubert hearing. And the reason he is called as a expert witness is because the other person quit the job at the correctional center and moved out of state. So he was top 2 gang expert at that corrections facility, and the other one quit. Catherine asked, does each lawyer for each defendant do an opening statement? I don't know. Are they allowed to? Yes. Will they do it? I don't know. I would reckon that the state will take all day today for their opening statement, and because I'm not entirely sure if the court will read up all 191 charges under the indictment, or if he will only read the indictments. Let's see here. Morning, Indigo. Yes, Brandon. This trial is going to be somewhere between a joke and a disaster. But this is day 1. We are starting at 0. Mr. Williams et al. And with his 5 co-defendants are presumed innocent unless the state proves beyond reasonable doubt all charges under the indictment. Now they can, I'm not entirely sure if they separated all the charges, so they can convict him of 15 and not guilty on the rest. I have no idea. I would assume that, because here's the thing, the charges stems from 2012 to 2021. At the time, no charges was brought to anyone in the YSL-gang, the alleged YSL-gang. Some of the state's proposed expert witnesses have said so during the Daubert hearing. I didn't bring charges because there wasn't enough evidence. And in some cases, and at least one case, they found out that their eyewitness lied. Because that person said, I saw that person and that person in the bus stop around the time of the ending. And then they got a hold of video surveillance. And at the time, and an hour before and an hour after, there was nobody there. No one of the people they were alleging committed it were there. So, and they still have it as a charge here. No, I didn't get dressed up for this trial. I got home from work and I thought I would give my audience a chance to see me how they would probably see me in a professional setting. My regulars will tell you that not my normal look, but here I am. The defense tables will have almost as many lawyers as Sarah Boone used to have. Yeah. Yeah. There will be 6 defense teams. Some of them consist of one person. Some of them consist of more than one person. So we somewhere between 10 and 12 defense lawyers. State has a team of 5. It's the main prosecutor, District Attorney Fannie Willis. And if you recognize that name from somewhere else, it is because that is the same person who is trying to indict former President Trump under the same RICO Act. Hold on. Mr. Jingles either walked out or walked in. I don't know. We will find out in a bit. Given the trial is expected to take 6 to 9 months, would part of the jury selection been asking who can financially afford not to work for that period? Probably. Because Georgia pays between $5 and $50, depending on which county. Now, this is in the Atlanta region. I will check. $25 a day, Fulton County. $25 a day. It's ridiculous. It's a jury of, I don't know, people who couldn't get out of it, and pensioners, and homeless. I don't know. I have no idea. And having 12 jurors and 6 alternates for a year-long trial, statistically, people will die of old age. I mean, let's see here. We are currently waiting for the coverage to start. I am alternating between the law and C word, and let's see here who else is planning. Dun, dun, dun. Bum, bum, bum. Oh, I don't see anybody else than law and C word having that up at the moment. I would think that Fox 5 Atlanta would have something, but not at the moment. And good morning, everybody. By the way, good morning. Good to have you here. Yeah, I have stocked up on my nicotine pouches. I have my small pot of coffee and other things. And I will take small breaks in the middle of something, and because need to eat. But my plan is this week to cover it all day, and that's the plan at least. And as I said, my plan is for covering this gavel to gavel, either live streaming, recaps, or recaps every day, recaps every other day. Some weeks when particularly uninteresting things happen, maybe just a Friday update or Friday recap where I go through the entire week. It all depends on my schedule for my day job. But I will cover as much as humanly possible, and I do have people in the background who might be able to step in for me during my streams. Maybe. Hi, Dave. This is for you who don't want to be on YouTube's. I have everything up on Rumble as well. The link is pinned at the top of the chat. And if you have a Rumble account, please go over there and follow me so I can start to have a decent platform over at Rumble. I also think I have this on. Yes, it's live on Twitter as well. You didn't see the jet ski. What's the jet ski signal? Well, where is it? This is the Dave signal if I think I need Dave's help with something. But I also have I'm having too much fun with yeah, what you just saw, that's the peak of my ability to make something moving in a picture. Mm-hmm. Dun, dun, dun. See here, I'm looking at. Let's see here if. Okay, Atlanta first. We'll also have this on the YouTubes. Let's see if they. Oop. Nothing up there yet. Dun, dun, dun. Culperistic. What would be the closest RICO equivalent where you are? We don't have one. You can be charged on multiple crimes in the same trial settings, but not RICO as in indicting an entire group of people. That is only done with economical crimes here. Bet you $5 and his left dangly. This ends in the mistrial. Well, I would assume that the defense has absolutely no interest in doing this easy for the prosecution or the judge. They already have, I think, somewhere they have a bunch of appeals, appeal motions up at the appellate court that they already have sent. Now that can take weeks or even months for them to process it. A handful of them will effectively end the trial if the appellate court says, yeah, we agree with the defense. So, and if that happens, we might be in a double jeopardy thing, which means that everybody walks. And Miss Fannie Willis, a prosecutor, she has banked a lot, and more or less her entire career is based on being good at prosecuting under the RICO Act. How double jeopardy? The jury is sworn in. So everything that happens now during trial have effect on the ability for the state to recharge anybody in this setting. That's at least my interpretation of it. But if I get a guest on that can correct me, I will be happy to. I will be happy to do that. Still waiting. We are now 9:10 and still nothing. Now this judge is infamous or famous for not being late, but his 15 minutes can sometimes mean an hour or an hour and a half or even 2 hours. Sometimes the morning break continues until after lunch. at least during the pre-motions hearings. I hope he will be more effective during the actual trial. I really, really hope so. Yeah, or do the YouTube things. Do you know it? Thumbs up if you like it. Thumbs down if you think I'm garbage. I don't think I am, but hey, everybody for himself. If you're not subscribed yet, please do so. Helps enormously with my channel. If you have a social media account, like Twitter or X, look me up there and retweet my tweets and like them and stuff like that. Let's see if I can put that in here. There. So it's at Starow Niklas on Twitter or X or whatever you choose to call it. I wouldn't know. I don't know the guy. Of course, I don't think I'm garbage. I'm biased. Point. Yeah, point taken. Yeah, still waiting for the coverage to actually start. We are waiting. I'm checking. Dun, dun, dun. Nothing over at Atlanta News First. Dun, dun, dun. Oh yeah, one of the first things the prosecution did was to try to ban cameras. That didn't work. And I'm very glad, because without it, we would never have known about the prosecution's shenanigans in this. And it's been a bunch, especially regarding the... Hold on, well, I fill up my coffee. Especially when it comes to discovery. Back in April, the judge started to get a bit annoyed that the prosecution haven't sent over the discovery yet to the defense. So he more or less ordered it. And the prosecution said that we will pack it on 2 4-terabyte hard drives and send it over. A few weeks later, defense still haven't got it. No, they were thinking about using Dropbox to hand it over. And not sure why they wanted, until Miss Willis mistakenly blurted out during one of the later hearings about this discovery that the reason they wanted to go through Dropbox was so they could see which files the defense attorneys opened and when and how many times. For me, that says misconduct, because your job as a prosecution, as the state's representative in the courtroom, is to hand it over and nothing else. And just her admitting that they wanted to see in the order of which the files were opened is, for me, they were trying to find out the defense strategy. For me, when I heard that, I went, say what now? I'm not a judge. I will never be one. I have no interest in it. But at that admission, mistrial. I mean, even if it's not trial, haven't started yet. I mean, there's been a plethora of occasions when the judge had the opportunity to just take the case and punt it out of the courtroom. He chose not to, because he says, he goes back to the words fairness, which is weird for me, because courtroom is not about being fair to both sides. In the courtroom, the defendant is innocent in the eyes of the law. I mean, it's all over the Western world. In your constitution, in our fundamental laws, innocent unless and until proven otherwise in a court of law. Fairness should only go towards the defendant, in my opinion. Yeah. And in one of these occasions with some of the evidence that was supposed to be sent over, the defense said, two of the defense lawyers who has been the main talkers have said, the discovery said that late October they got discovery containing over 2 million files. The prosecution said, no. This was just a data dump of his social media accounts, which we may or may not use in the trial, or maybe just a few parts of it. So they started to go through that. And she put, oh, look, it's just a few pictures here. Look, it's just a few things there. And then the defense had the opportunity to speak to the court and showed that one of these files that she didn't open contained over 1.6 million entries. That would be Twitter or Instagram or, I don't know, Facebook. Definitely not MySpace. I mean, so the prosecution keeps just playing around. No, it's not that much. The defense is exaggerating. Yeah, but the defense has to go through all of it, not just the items you think are important. Because in there might be exculpatory evidence. Yeah. And this was a month before the trial starts. The prosecution chooses to hand over their discovery of over 2 million entries in the file, in different files. And when they started to show these files, the order of them were not searchable, not named, not anything. Just a cluster F of files in different folders that didn't make sense. And for me, again, shenanigans from the prosecution. And the judge wasn't happy. He gave them an earful, but nothing actually happened of it. Nothing. I wonder how much this will cost by then. Millions. Millions and millions and millions. It's... yeah, sometimes I'm just lost for words about this, because it seems so... Yeah. I mean, none of the 191 charges between 2012 and 2021, nobody was charged with them at the time. So that, for me, if you can't charge the crimes individually, then you're just using the RICO Act to prosecute by volume. And in hopes that the combined effort will give them some kind of advantage in court. And it might do so. They have done it before in the RICO trials in Georgia. And District Attorney Fannie Willis, she knows the Georgia RICO Act inside out. She knows all the nooks and crannies. She knows all the ways she can circumvent things, use things in different ways to get a trial, to get it into trial. Still nothing from... I mean... Let's see. No. Checking Atlanta news first. Oh. All right. Atlanta news first has actual coverage, so we will go there. No, is this live? Yeah. All right, here we go. Lawrence Stewart still not going. They are probably waiting for everything to actually start, but they are currently just sitting down. Yes, I put my Christmas decorations up. Sue me. No, don't do it. Yeah, that might be it. Yeah. Judge is not in robe. That's weird. I haven't seen him without robe. Again, if you prefer Rumble, The link is on the top of the chat and also on Twitter at the feed there. Remember, do all the YouTube things, like or dislike. I prefer if you give a thumbs up. Yeah, Kim. Yeah, this will be interesting. I'm very interested in hearing the state's opening statement here, because I'm not entirely sure what angle they will go with this, but they will depict them as a violent gang. We will prove, the evidence will show this and that, this and that. I'm more interested in the defense opening statement, because that's an angle that might be for you and me more interesting to hear, because what the prosecution will say is quite obvious. We will prove this and that and this and that. Nothing new there. But the defense, if it was me, my opening statement would go something in the line of saying this is a trial by volume. All these 191 alleged charges are stuff from a period between 2012 and 2021 where the state chose actively to not bring charges because they themselves said, we do not have evidence enough to even bring charges. Don't know if I would get objected to, but I'm not in the courtroom, so I don't care. Also, I would bring evidence will show, and then the example with the shooting that the cops at the scenes themselves in the report wrote, probably justifiable. That should have been the end of it. That charge should have been yeeted from the trial. But since it's still there, use it. Use every word in every report written where the cops, the prosecution said, we don't have enough. Okay, still preparing. The guy at the podium now is one of the defense lawyers. Maybe, I don't know. Will the defense go first? That would be interesting. Hi, Nanya. Oh, yeah. If you find my coverage especially astounding, you have the choice to become a member. That's $3 a month, and you will get the most members-only content in all of LawTube. That I was told a couple of weeks ago that I produce the absolute most members-only content of all of LawTube. And okay, had I known that, I might have produced half as much. But here we are. And I like producing content for my members. I really, really enjoy it. You get to see the farm. You get to see farm equipment, the renovations I'm doing downstairs. You get my morning thoughts on occasions when the sun during the sunrise, and yeah, stuff like that. So more random stuff, not just trial evidence, crimes and stuff, but more personal things. Come on, George. You said 9 a.m. It's 9:30.
missing one. All right, bro. Judge, you still missing one. Okay. Who is it? 294. 3 or 4 times. He's called her, and me and Brian called her also.
Yes, Mr. Youngstock, Jeffrey Williams. You got his hair done. Yeah, half the courtroom is the defendants. I don't know, and the rest I assume is media.
Hello? Hello?
Oh, jury instructions. Yeah. Yeah, those will be interesting. Oh yes, it stand. One of the bald guy's name is actually Mr. Short. And on the prosecution side, you have a Miss Love. The names here are epic. Names in this trial are epic.
I'll take it upstairs. I'll get upstairs.
Now, what else can we say about this trial that I haven't already said? Well, the jury selection took almost 11 months. I already said that, but a bunch of new guys have shown up in the stream watching this unfold. And 12 jurors and 6 alternates for a year that will take at least 6 months, up to a year, maybe. Because the prosecution, their witness list is 737. Half of them are expert witnesses, and half of them are layman witnesses. When they started arresting people a year and a half ago, the defendants were 28. I think 10 or 12 has taken plea deals. Some of them have taken plea deals against the testimony. Some of them have not. Some of the charges have been dropped against a few of them. And we are left with 6 defendants. Yeah, just listening for Mr. Jingles and see if he's about to make an appearance. If you don't know who Mr. Jingles is, that's my farm cat. And he likes to chew on my legs. Yeah, don't forget to change from hot chat to live chat so you don't miss anything. And if you recently joined, put something in the chat just to say hi, to make yourself seen and known. Because YouTube really likes an active chat from a lot of people. So hold on. Are people getting yeah. If you're getting ads, that is because YouTube has decided live streams. We will force you to have ads for you. And I went, I don't want them. So I tried to keep them at absolute minimum, because they are intrusive and not necessary for me. Even though I enjoy the membership, which keeps this channel afloat, and the occasional super chat, the main reason is to me learning more about the U.S. Justice system, And while I'm learning to pass on that knowledge to you in the audience via the US-based lawyers or laymen as guests. And you who have been with me for a while know there's a lot of people who has been in and out of my streams since I started this a year ago or almost a year ago. Good lawyers, decent people all around. Yeah. The white-haired lawyer looks up about 120 years. Hi, Toddler Kip. And yeah, one of the most recent motion hearings was amazing. I don't see that lawyer in this picture, but he made a Second Amendment history lesson in court for 30 minutes to try to get the gun charges off. Now, it didn't work, but it was a really, really interesting history lesson about cases from 1792 up until 1984. Really, really interesting. Didn't work, but it was really interesting. I see that Mr. Williams does not have any snacks today. During the hearings, he's always had some kind of snacks with him, but I would assume that an actual trial, that's not allowed. Or not advised to, at least, now when the jury will actually be there to see everybody. Wim, try to refresh or close down the browser and open it up again, because the YouTube chat is rubbish at times. And there's a few people over at Rumble. I will actually...
We'll see.
Hey, Tim.
Still an answer. That's it, she's still an answer.
That's what I was
Yeah.
just talking with Colonel about.
If you have the time, I have somewhere between 20 and 25 streams and videos you can choose from to see a bit of the history.
I need the address.
What happened before the trial started. Oh, hello, Mr. Pineapple.
Yeah. Yeah.
Dave just said to me that he lost his earbuds, so he can't join at the moment.
She got it.
Yeah, I mean, the echo and everything would ruin that experience, especially since we are playing audio. It would be hard to follow this trial without any audio. No closed captions available. Hold on while I check if the law and C word has closed captions. I don't know if that will actually... Yeah, I have closed captions. Write 1 for stream with closed caption or 2 if you don't care in the chat.
All rise.
Oh, here we go.
Superior Court of Fulton County now in session. The Honorable Chief Judge Juror Glanville presiding. Court call to order.
Hi, good morning, ladies and gentlemen. Please be seated.
That's accurate. Carter.
All right, ladies and gentlemen, we're going to go ahead and take roll this morning. We're back on the record in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183572. I'm going to just go ahead and take roll for the morning at this point. Mr. Stilwell, Mr. Botts, and Mr. Sharp. Good morning, gentlemen. Mr. Williams, Mr. Adams, Mr. Steele, and Ms. Renard, good morning. Mr. Kendrick, Mr. Apt, Mr. Hingerty, and Mr. Weinstein, good morning.
Good morning,
All right. Mr. Huey and Mr. Matthews, Jr. and Sr., good morning. All right. And Miss, you have another counsel with you, Mr. Huey? Good morning, madam. All right. And Mr. Nichols, Mr. Harvey, Mr. Garner, Ms. Westmoreland, good morning. And Mr. Ryan and Ms. D. Williams, good morning. All right. All right, counsel for the state, ladies, Ms. Love and Ms. Hilton, Mr. Brown and Mr. Smith, good morning. All right, counsels, we are at this point in time waiting for one juror that has still not been able to be located. I have asked our sheriff's team to go ahead and see if they can find her. And that's what we're waiting on at this point in time. So we're going to just be in pause or in recess until that time comes. And then we'll go ahead and get started once our juror gets here. Okay? So we're going to be in recess probably until I get some more indication on what our efforts are to locate that juror. So we're in recess at this point in time. You can recess in place at this point, okay? All right. Let me make a couple of announcements while I'm still on record for our folks here in the gallery on embedded media, all right? You're welcome, and we appreciate your the full and free and fair press and the benefits of the First Amendment. I would just ask you respectfully to remind you, and I know you all as seasoned journalists know this, do not take pictures of our jurors. Do not try and intercede or try and talk to them in any way. And that goes for anybody else in this courtroom. The jurors are not to be tried to be interfered with in any way or tried to talk to or anything. I know you all know that, and I know you all won't do that, but just so we kind of are all on the same sheet of music. If you have photographic or other equipment, I'd ask that you put it on your silent mode. Some of you have shutters that I can actually hear. So if you could change the setting on those, that would be great. And the last thing I'd just tell you is just please go ahead and within the dictates of your Rule 22, please go ahead and just follow that. If you have any questions, you can certainly ask me at the appropriate time, but all of you are welcome. Okay, all right, so we're going to be in recess until I find out more about whether where our juror is, and then we'll go ahead and get started. All right, so we're in recess.
Seriously, they lost a juror. I mean, here's the thing. Normally, you have a juror stays at home, drives into court. Oh, that juror will be in deep trouble. Very, very deep trouble. Now, can they continue without that? Yes, but that means they are 12 jurors and 5 alternates before the trial even started. Oh. Let's mute that for a bit. Yeah. Oh. If this is indicative for the rest of the trial, yeah. I mean, I don't understand how they know the trial will last at least 6 months. And they chose actively to have 12 jurors and 6 alternates. Statistically, people will get sick. People will get dead. People will, I don't know, get pregnant. I have no idea. And maybe jurors that simply forks off. And we know this judge will hand out punishment for jurors who try to evade. During the jury selections, I know of at least 3 jurors that was given the choice to either be in contempt of court or spend the weekend in jail. One of them had a choice. This was quite recent, that hearing at least. She, since it was so close to the actual trial, and that person was one of the final 50 or something. She had the choice 5 days in jail or to sit through 5 days of court or trial. This judge has also given out punishments to lawyers, either in contempt of court. There has been removal of lawyers because of handing over of contraband in the courtroom, allegedly. There are lawyers who have been forced to write essays about the importance of following the rules. There have been defense lawyers who have been forced to buy lunch for the other defense attorneys. So it's quite inventive by the judge in his different ways to punish people for not following the rules and doing crap. Brandon says, this is ending in a mistrial due to lack of jurors. 2, it's humanly impossible to pay attention to all this garbage. I'm betting on a short deliberations that is decided by a coin toss. Yeah, if they get that far. Now, mistrial due to lack of jurors. I mean, if they all of a sudden get too few jurors, I'm not entirely sure of the Georgia rules. Dun, dun, dun. Let's see. Oh, of course I can't access that one. Trying to find it here. If it can be either that they start jury selection again, but here's the thing: if the trial starts, what will and they get down to too few jurors, what will happen then? I'm not sure. Could it be mistrial? Well, it has to be, because they can't finish the trial. But will it be a mistrial where they restart the trial with new jury selections? Well, it took almost 11 months to get this jury in place. Or, yeah, because this is not due prosecutional misconduct, that kind of mistrial. So it can be a mistrial, but not by prejudice. Because if it is by prejudice, then it's over. Then everybody's gone. Don't they have alternates? Yeah, 12 euros, 6 alternates, so 18 euros. But in order to remove a juror, once they are sworn in, that juror must present the actual reason. They just can't bail. So as for now, the the sheriff's office is looking for the they are looking for a juror. Oh God. What a cluster F. No, the jurors are in constant, should be at least in constant communications with court as when they are actually selected. So, but I mean, it's yeah. But this, I mean, I'm not that surprised considering every kind of fork up that has happened throughout these pre-trial hearings and Daubert hearings and motion hearings. I'm not that surprised because, as I said, I started jury selection almost a year ago. Yeah, Sal says, this is the judge who constantly orders people in contempt, right? This juror is screwed. Yeah, this juror, unless there's a really, really valid reason, because they are sworn in. Severe illness, accident, whatever's. Yeah, whatever it is, they have to have an absolutely solid reason. It would be really fun and sad if that person was speeding to get there in time and was pulled over and put in jail or something. That. Oh, Gigi says, only one job I ever had paid me for sitting on a jury. Yeah, on a federal level, I think your job, there are rules that says you can't get fired during jury duty. Some businesses or larger businesses have that you can, since it's not the fault of your own, you still can get paid from work to be on a jury, even though you're not at work. But Georgia, depending on which county you're in, you're paid between $5 and $50 a day. This county, Fulton County, $25 a day they are paid. That's if you're not on an absolute entry level, that's an hour's pay for a full day. Do you get gas money? I don't think so. The euro was stuck, yeah. Gillian Maloney says, yeah, people say in chat that work usually pays, but I'm pretty sure jobs I've had didn't pay, they said in orientation. Let me just look for that, because I had it a few months ago, the same question. Not UK, what? Let's see here. Let's pull this up. Payment from employers for jury service. The Jury Selection and Service Act forbids any employer from firing, intimidating, or coercing any permanent employee because of their federal jury service. Your employer may continue your salary during all or part of your jury service, but federal law does not require an employer to do so. You should check whether your company or employer has a policy for employees serving on jury duty. So that is on federal level. Petite jurors paid $50 a day, eligible to receive up to $60 a day after serving 10 days if the presiding judge so orders. Note, employees of the federal government are paid their regular salary in lieu of this fee. Yeah. If you have a government paycheck, yeah, you're better off. Reimbursement for reasonable transportation expenses and in some courts parking fees. That's still on federal level. Subsistence allowances covering meals and lodging if required to stay overnight. Okay. But that's still on the federal level. Grand jurors, yeah, more or less the same. So that is what we have on that one. What do you mean 403? Hold on while I open VPN so I can Okay, not even on VPN. Thank you so much. Okay. Georgia. Let's see here. Hold on while I do this so you can see better. Serve jury duty. Yeah, let's just go through this while we wait for something to happen. To be eligible for jury duty in Georgia, you must be a U.S. citizen. Yeah, I would assume so. Be at least 18. I mean, you can serve on a jury, but you're not. I mean, the government says you are mature enough to serve on jury duty at 18, but you can't buy your own booze. Yeah. Be proficient in English enough to understand and discuss the case. Good choice. Be a resident of the county that sent you the jury summons. Have not served on a jury in the last 12 months. Not currently be on a grand jury or another trial jury. Not be under conservatorship. Have had your civil rights restored if you were convicted of a felony or malfeasance while holding public office. So yeah, okay. So if you're thrown out of your public office spot, you might not be able to do jury duty. And if you have been convicted of a felony, you must have your civil rights restored. So that's about this, yeah. And I receive a jury summons, not interesting. Appear in court. You must appear in person for jury selection at the date, time, and location noted on your jury summons. Bring a copy of your jury summons with you. Employees in Georgia are required to grant employees time off, though it may be unpaid to serve jury duty. Yeah, this may is probably because most US government really don't like to force employers to pay for time off. That is done through union negotiations, I would assume. Sam says, in Arizona, jurors get a pass for parking. That's very nice. Mandy Me is in South Georgia. Welcome to the show. The most interesting, yeah, for you who just joined, yeah, they are missing a juror. And they can't get hold of it. So the sheriff's office is now out looking for a missing juror. So the court is in recess until the judge has further notice. And for me, it's amazing because throughout all hearings and jury selection, if you forked up, you got punished. Yeah. Does either side ever want a dumb juror? I would assume that is more on the state's side than the defense side. I had a talk with Southern Law the other day where the question was, what would be your ideal juror as a defense lawyer? Well, my suggestion was that I want 12 Californians with degrees in gender studies. And then I would dress up my client in a dress and a wig. That would be my ideal jury as a defense lawyer. I assume that would be hard to get through, but that's a hypothetical. Wait. Yeah. During jury selection, the court and lawyer may ask you a series of questions to determine if you could be a fair, honest, and impartial jury. Yeah. Next step. If you're selected to serve on the jury, you will receive information about the trial date. You are responsible for making yourself available for jury duty for the duration of the trial. Yeah. And this missing juror, if they don't have an extremely valid reason, oh, you are in. I'll just put that banner up. Mandy me, where? Dan. All my jobs have paid me for jury duty as well as my measly $25 from the county. Oh, that's very nice. Isn't Cyber Monday a holiday? No. Cyber Monday is not a holiday. What else did we have here? If you're selected, the court will dismiss you. If you're not selected, the court will dismiss you and your obligation for this jury summons will be complete. People who are summoned for jury duty are eligible to receive nominal compensation for each day, including jury selection. Payment amount varies by county and is between $5 and $50 a day. Most counties pay around $25. Yeah, so there are counties in Georgia that pays $5 per day for jury duty. I mean, for me, this is extraordinary because if the government forces you to do something, you should never lose a day's pay over it. In my opinion. Doesn't matter if you are homeless or I don't know, Jeff Bezos, I don't care. You just say, this is my hourly salary at my current employee. This is Fulton County which includes the Greater Atlanta region. Still nothing from court. Okay, what else? Dave is going to call the court. Yeah. Don't, unless Dave is having a lot of Prosecco. Dave is funny. When he drinks Prosecco, he's getting white girl wasted. And he pocket dials courts. That was a short trial. Yeah. I mean, yeah. The court is in recess, and because they are missing a juror. That's again, I'm not surprised. Because all the shenanigans and all the cluster Fs during the year we have waited for this, I'm not surprised, because there have been a bunch of jurors who actively said, I don't want to be here. And you had one flight attendant who said, but I was doing my flight attending stuff and I didn't see the summons and stuff like that. But then they checked the communications between her and the court clerk, and yeah, she knew. So she was given the option of either you. I think that is the one who got the option of 3 days in jail or write an essay about the importance of jury duty. What is the actual name of the case? It is Georgia v. The State v. Jeffrey Williams. I think. No, this is a prior. Damn. Damn. Okay, here it is. Let me... There. Full screen. The State of Georgia v. These no? This, I think, is the original act. Yeah, this is it. This is the original. So it's the State of Georgia v. all of these. But I will send you the... I will say send a... Yeah, we can read through these for a while we wait for the court to resume. I will have sound on in the background so we will hear when it shows up. Okay. Now these are the original 28 defendants. I think. Yeah, or something of the sort. Oh, I heard a whoop. Hi, Mo.
Who?
We are waiting for a juror.
Oh, you're waiting for the jury?
Yeah, a juror hasn't shown up in time, and they can't get a hold of him, so the sheriff's office is out looking for him or her.
This is starting great.
Yeah, but this has, I mean, I have yet to hear one hearing in this, and for as long as I've covered this case, that hasn't had some kind of cluster F in it. So I'm not that surprised.
All right. Well, so these are the charging documents that we're gonna, because I guess I was kind of wondering what exactly they're all charged with that
Yeah.
would necessitate a RICO.
Oh, there's a few of them.
Well, I figured it wasn't for maybe lying on their taxes.
No. No.
Collecting COOF funds without,
Mm. Yeah. Young Thug has a song called On the Run.
Will that be used in the jurors trial?
Yeah, maybe.
I mean, that would be hilarious.
Yeah. Oh, hold on. I will. Dave, check the Twitters. Young Thug's full indictment. Coupon fraud. Well, you never know. On the Run might be a good one for a dramatic reading on a later date.
That.
For you who don't know, last week I did dramatic reading of the songs Hot and Halftime. Yeah, it was interesting.
It was oddly hypnotic, I will say.
With alternative music playing in the background. Oh, but yeah, here are the charges. Charge number 1. Conspiracy to violate the Racketeer, Influenced and Corrupt Organizations Act, the RICO Act of Georgia. Charge 2, murder. Charge 3, armed robbery. Charge 4 and 5, aggravated assault with a deadly weapon. Charges 6 and 7, possession of firearm during commission of a felony. Charge 8, theft by receiving stolen property. Charges 9 and 10, violation of the Georgia Controlled Substances Act. Charge 11, possession of a firearm. Charge 12, participation in criminal street gang activity. Charge 13, theft by receiving stolen property. 14 and 15, armed robbery. 16 and 17, aggravated assault with a deadly weapon. Charge 18, hijacking a motor vehicle in the first degree. Then you have 19 and 20, more possession of firearm during commission of a felony. 21, 22, and 23 is participation in criminal street gang. So they are returning to, yeah, it's a lot of that. Number 24, violation, drug charge. 25, possession of a firearm. 26, participation in criminal street gang. 27, another armed robbery. 28, another hijacking of a vehicle. 29. Possession of firearm by first offender, probationer. Yeah, whatever. 30. Possession of a firearm. 31. Theft. 32 and 33. Attempted murder. 34 and 35. Possession of a firearm, first offender. 36 and 37. Possession of a firearm. 38 and 39. Participation in criminal street gang. Yeah, they are down to 6 defendants in this trial. They started out as 28. For when the state said we are ready for trial, November of last year, they had 79 witnesses on their witness list. As of last week, 737 witnesses on their witness list.
Holy.
The other 22, pled, had their trial severed, and I think a few also were dismissed by the state. And I think half a dozen us we know will have done plea deals and will testify. Yeah, I mean, when if this trial goes to the very end, filling out the verdict form, I mean, we could be on verdict watch for a week.
Oh my gosh. Yes.
Oh, Jesus Christ. Where were we? Charge 40, attempted murder. 41, possession of weapon by incarcerated individual. All right, so he had a shank, I would guess. 42 and 43, participation in criminal street gang. 44, possession of weapon by incarcerated. 45, possession of a telecommunication device by incarcerated. 46, participation in a criminal street gang. 47, conspiracy to commit a crime. That's not vague, isn't it?
Okay, but are these... It's participation in a street gang. Does that mean every crime they did is an additional participation in a street gang?
Yeah,
So
this
every
is
time they did a crime, it's another
Every-
participation in a criminal street gang. So it's another add-on crime. 'Cause
I
am
think it's
confused.
an add-on crime to get it under the RICO Act, and also that is how they, if one is convicted of a crime, like for instance, you have charge 49 there, murder, and also participation in a criminal street gang, then everybody will be convicted of that under the RICO Act. Even if they were on vacation and had nowhere near, but if the state can prove that all the defendants were a part of this criminal street gang, then they all get convicted for it.
Okay.
So it's an umbrella charge, so to speak. Shall be a lot of individuals named on the left seem to be more than the 6 on trial. Yes, they were 28 defendants to start with, and now they are down to 6. Participation in criminal street gang, again, 50-51. 52, possession of firearm by convicted felon previously convicted of felony involving the use or possession of firearm. So you had a firearm, you were convicted as a felon, and now you have a firearm again. Yeah, let's make an add-on on that. That was 52 and 53. 54, possession of a firearm. 55, conspiracy to commit a crime. 56, participation in criminal street gang activity. I thought there were 191.
Yes, sir.
Here we go. They found the juror.
All right. Summon our jurors for us, please. And Deputy Review would have them, as we talked about earlier, not everybody except the last row? Okay, all right.
Hey, everybody.
Is everybody here? Everybody present?
Mr. Sharp coming here.
All right, well, okay, I don't worry about him right now, okay? But, all right.
Hi, neighbor.
I would assume that will be handled separately. Yes, they will be forced to wear a cone of shame.
Is this the judge
No.
that makes them write papers? Because
Yeah.
I need to see those papers.
Okay, here we go. Jury is entering the court. Here we go. We have waited for this for over a year. And hello everybody over at Rumble. Please make yourself known in the chat. That would really help.
All right, ladies and gentlemen, please be seated.
And thumbs up. That helps us with the YouTube and Rumble algorithms.
You got no chat?
If you have questions, have a big question mark in front of your question so I see it in the chat, or make a super chat.
I will be watching. Yeah, I'll try to be watching for questions. And yes, at Stardom, court is just starting. A juror was doing a Where's Waldo impression.
Yeah. Juror was late and gonna be located, so the sheriff's office went out to find them, him or her. Now, this will be, if we find something interesting, I will pause and then
All
resume.
right, there's present?
Yes, sir.
All right, okay. Good morning, ladies and gentlemen of the jury. Oh, come on, that sounds so lame. Come on, all right, let's try that again. Good morning, ladies and gentlemen. Good morning. Oh, much better, much better. Ladies and gentlemen, as you know, I'm Chief Judge Earl Glanville, and I'm presiding over the trial of this case. And at this point in time, I'm going to introduce my chamber staff. In the courtroom, I have my court reporter, Miss Christina Weaver. She's my official court reporter. And then to my right, your left, is Miss Violetta Omana, who's my judicial assistant. To my left, immediate left, is Mr. Wesley Kearns. He's my staff attorney. And then the gentleman who just brought you out is Sergeant Tim Ingram. So, and then I have another litigation manager upstairs, Edward Chamberlain.
Yes, he's a
And you'll meet him
cool
at some
judge.
point in time if you
So
haven't
he's
met him
having
already when
a
you were here
diamond
before.
stud.
So, as I mentioned earlier, they're here to assist me and will be happy to help you in any way you can. Your principal point of contact, should you be running late or anything should happen to you or you need to kind of reach us before the time period. I understand one of you had a car issue this morning. So that's, you all still have my cards? Okay, and if you don't, I got plenty more. We'll give you some before you leave today. If you're going to be running late or anything, please contact Ms. Umana and let her know so that I can kind of keep track of you and I can let the parties know where you are. But it is very important that you all get here on time. We were supposed to start at 9 o'clock this morning. It's now almost 10:30. So I can't do anything until all 18 of you are here. So please mind your time. Only you know how long it takes you to get from wherever you live in our great county, downtown, Fulton County, to the courthouse and all the machinations that you have to go through. So leave early. You can always come a little bit earlier and be comfortable and be seated in your headquarters or jury deliberation room, okay? All right, but at any point in time during recesses, you can approach my staff, or as I mentioned earlier, any of the people from our sheriff's department who are in the gray and black uniforms, you're authorized to talk with them. Before we get into preliminary instructions, ladies and gentlemen, I have some administrative matters to discuss with you. I've already introduced my staff, and I encourage you to approach them if you have questions. Remember, the sheriff's deputies have shown you how to get to the jury room, how you arrive here every day. Okay, so you're never to come in the front door of the courtroom. You always go in to the rear and go directly into your headquarters or jury deliberation room. And from this point on, you're not going to enter the courtroom unless one of the deputies brings you out from the jury room. After breaks and beginning of the day, when you arrive, you'll go straight to the jury room. And our deputies, as I mentioned earlier when you were here a little bit earlier, gave you the nickel tour of the courthouse. So all of you know how to get from the front entrance up here to your headquarters, is that right? Okay. We talked a little bit about meals and how you can, there's a cafeteria that's directly behind you. We talked a little bit about that. Since you were here, you like the space back there?
Yes.
It no longer looks like a dump. We painted it, got you some fresh tables, chairs, and a couple of refrigerators, a microwave, a coffee pot, and we'll make sure that we go ahead and make sure that is cleaned and maintained for your use. I want you to be very comfortable while you're in there. But as I mentioned to you earlier, it might be better just to bring your lunch or bring your comfort items, but we'll make sure that you have some place to store them and otherwise can warm up your lunch if you feel necessary. All right. I would ask that you wear your juror stickers when you're here in the courthouse, and all of you have juror stickers. Wonderful. If you don't, when you go back in there, put one on, and remember at the end of the day, take one, put it in your wallet, your purse, your briefcase, whatever you may have, and put it on when you come back in the courtroom and in the courthouse. This is so the lawyers and the witnesses can identify you as a juror. From this point on, the lawyers, the parties, the witnesses, or anyone else associated with this case, except for my staff or our sheriff's deputies, is prohibited from having any contact with you whatsoever. If you happen to encounter any one of them on the street or in the elevator, please do not attempt to communicate with them in any way and do not be offended, as I mentioned to you earlier, if they ignore you, okay? They're just adhering to their responsibilities and roles as officers of this court to not have any direct or incidental contact with you. So please don't be offended. If you should some reason have contact with one of the lawyers, or if you inadvertently overhear something about this case, please notify one of my deputies or my staff immediately. Now, this also, ladies and gentlemen, pertains to third parties or anybody else that may try and talk with you. If anybody else, other than the folks that I told you about, the lawyers, attempts to talk with you in any way, emails you, texts you, tries to communicate with you when you're going to and from, we need to know about it immediately, okay? So please tell me if that should happen. We generally hold court from 9 a.m. to about 6 p.m. or thereabouts. We'll take some short comfort breaks as needed throughout the day and a longer break for lunch. And for the sake of your fellow jurors and the parties, as I mentioned earlier, please make every effort to be on time, as we cannot begin or continue the case until all 18 of you are present. If something unexpected happens and you absolutely cannot help being late, please call my office and contact Ms. Umana, and she'll let me know and let us know accordingly. All right, ladies and gentlemen, now I'm going to cover some basic principles of criminal law. I'm going to explain my role, your role, and the lawyer's roles. And then finally, I'm going to tell you how the trial will proceed. Since many of you haven't served on a jury before, so this should help you in understanding how a trial proceeds and what is expected of you during the trial. Now, you've been selected and sworn to try the following: the criminal case of the state of Georgia versus Marquavius Huey. The Fulton County Grand Jury has indicted the defendant Marquavius Huey with the following offenses, which I'll read to you: conspiracy to violate the Racketeering, Influence, and Corrupt Organizations Act, armed robbery, aggravated assault with a deadly weapon, aggravated assault with a deadly weapon, possession of a firearm during the commission of a felony, possession of a firearm during the commission of a felony, armed robbery,
He's reading the
aggravated
charges.
assault with a deadly weapon, aggravated assault with a deadly weapon, hijacking a motor vehicle in the first degree, possession of a firearm during the commission of a felony, possession of a firearm during the commission of a felony, participation in criminal street gang activity, participation in criminal street gang activity, participation in criminal street gang activity, possession of a weapon by an incarcerated individual, possession of a telecommunication device by an incarcerated individual, and participation in criminal street gang activity. The criminal case of the state of Georgia versus DeMonte Kendrick. The Fulton County Grand Jury has indicted the defendant DeMonte Kendrick with the following crimes, which I'll read to you now: conspiracy to violate the Racketeering, Influence, and Corrupt Organizations Act, murder, participation in criminal street gang activity, violation of the Georgia Controlled Substances Act, violation of the Georgia Controlled Substances Act, violation of the Georgia Controlled Substances Act, possession of a firearm in the commission of a felony, possession of a machine gun, and possession of a firearm by a convicted felon previously convicted of felony involving the use or possession of a firearm. The criminal case of the state of Georgia versus Quamarius Nichols. The Fulton County Grand Jury has indicted the defendant Quamarius Nichols for the following crimes, which I'll read to you now: conspiracy to violate the Racketeering, Influence, and Corrupt Organizations Act, murder, participation in criminal street gang activity, participation in criminal street gang activity, possession of a firearm by a convicted felon previously convicted of felony involving the use or possession of a firearm, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon previously convicted of felony involving the use or possession of a firearm. The criminal case of the state of Georgia versus Rodeus Ryan. The Fulton County Grand Jury has indicted the defendant Rodeus Ryan for the following crime, which I will read to you now: conspiracy to violate the Racketeering, Influence, and Corrupt Organizations Act. The criminal case of the state of Georgia versus Shannon Stillwell. The Fulton County Grand Jury has indicted the defendant Shannon Stillwell for the following crimes, which I will now read to you: conspiracy to violate the Racketeering, Influence, and Corrupt Organizations Act, murder, participation in criminal street gang activity, participation in criminal street gang activity, possession of a firearm by a convicted felon previously convicted of felony involving the use or possession of a firearm, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon previously convicted of felony involving the use or possession of a firearm. The criminal case of the state of Georgia versus Jeffrey Williams. The Fulton County Grand Jury has indicted the defendant Jeffrey Williams for the following crimes, which I will now read to you: conspiracy to violate the Racketeering, Influence, and Corrupt Organizations Act, participation in criminal street gang activity, participation in criminal street gang activity, violation of the Georgia Controlled Substances Act, violation of the Georgia Controlled Substances Act, violation of the Georgia Controlled Substances Act, possession of a firearm in the commission of a felony, and possession of a machine gun. Each of the defendants have pled not guilty to this indictment, and each of them deny every charge in it. This indictment and the defendant's pleas of not guilty present the issue that you've been selected and sworn to decide. The indictment is the way the defendants are charged with committing crimes that violate the laws of Georgia. The charges in the indictment and the pleas of not guilty are not evidence of guilt, and you may not conclude the defendants are guilty based on the charges or the not guilty pleas. Each of the defendants is presumed to be innocent until he is individually proven guilty. The defendants begin the trial with a presumption of innocence in their favor, and this presumption stays with them until it is overcome by the state with evidence that convinces you beyond a reasonable doubt that the defendants are guilty of the crimes charged. You may not convict any one of the defendants of any crime unless each element of the crime is proved beyond a reasonable doubt. The burden of proof is on the state to prove every essential element of the crimes charged in the indictment beyond a reasonable doubt. The defendants have no burden at all, and the burden never shifts to any one of the defendants to prove his innocence. However, the state is not required to prove the guilt of the defendants beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which you can give a reason based on a consideration of the evidence or a lack of evidence, a conflict in the evidence, or any combination of these. After considering all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must find the defendants not guilty. But if no reasonable doubt exists in your minds about the defendant's guilt, then you may convict the defendants. If the state does not prove the defendant's guilt beyond a reasonable doubt, your duty would be to find the defendants not guilty. My role is to determine the law that applies to this case. Then I will instruct you on the law that you must apply to the facts in reaching a verdict. I'm giving you some of those instructions now. I will give you more detailed instructions at the end of the trial. The jury has a very important role. You must decide the facts of the case from the evidence presented and then apply the law that I give you to those facts. Evidence is how a fact is proved or disproved. Evidence can be either testimonial or exhibits. Testimony is what you'll hear from people who take the witness stand right here and swear to tell the truth. However, the questions the lawyers ask the witnesses are not evidence. Exhibits are documents, photographs, and other physical items that are admitted during trial. The object of this trial is to discover the truth. During the trial, I will admit evidence according to the rules of evidence. Those rules are designed to aid in discovering the truth by making sure that you consider only the best and highest evidence. The lawyers are advocates for their clients, and they have the duty to represent their clients to the best of their ability. They must follow the rules of law, trial procedure, and evidence during the trial. They may make motions or objections if they believe that any rule is not being followed. Remember, what the lawyers say in making or responding to objections is not evidence. I will admit or exclude evidence according to the rules. If the lawyers make an objection and I overrule it, that means the evidence is admitted and you may consider it. On the other hand, if I sustain an objection, this means the evidence is excluded from the trial and you may not consider it. You should consider only that testimony and only those exhibits that are admitted. You should not assume or infer anything about evidence which I have excluded. If you happen to hear or see evidence that I end up excluding from the trial, you must disregard it entirely in your deliberations and in arriving at your verdict. None of my decisions and nothing I say during the trial are evidence. My decisions and remarks do not mean that I favor or lean to one side or another in this case. I am only interested in seeing that this case is fairly tried based upon the laws and Constitution of the state of Georgia and the Constitution of the United States. Sometimes I may have to deal with the lawyer's motions or objections without you being here in the courtroom, and if so, I'll excuse you from the jury room. So what I'll say, ladies and gentlemen, is, ladies and gentlemen, there's a matter we need to take up. If you retire to your headquarters or jury deliberation room, and I'll wait further instruction. That's my most artful way of telling you we need to take up something outside your presence and hearing, okay? I'll try and limit those interruptions, and I ask that you be patient when they do happen. I can't tell you when those will happen, but sometimes they do. So please I'll ask for your patience in advance on that particular matter. So the trial will proceed as follows. First, the attorneys may give what's called opening statements. No attorney is required to make an opening statement. Opening statements are not evidence. They're simply an introduction to the evidence, a preview, or an outline of the expected evidence. The state goes first because they have the burden of proof. Second, the evidence will be presented. Third, the lawyers may give closing arguments or summations. They may discuss the law that applies to this case and how you should consider the law in light of the evidence. They may also point out evidence that they believe supports their position. What the lawyers say in closing arguments is not evidence. The goal of a closing argument is to persuade you to decide the case in their favor. Fourth, then I will explain to you the specific law that applies to this case. This is referred to as charging the jury. I will then ask you to go to the jury room, your headquarters, to deliberate and to reach your verdict. It is important that you pay close attention during this trial. If at any time you cannot hear or see any evidence, or you're suffering from any discomfort that distracts you, please inform me or one of my deputies or my team, and we'll do whatever is needed to make sure you can hear and see the evidence and give it your undivided attention. If you need a break at any point in time, please raise your hand or alert one of our deputies. The jurors are not allowed to question witnesses. However, if you have a question you believe is important for your determination of facts, please write down your question, give it to one of the deputies, and I will determine whether or not it should be asked. If you have a question while the evidence is being presented, please keep in mind that you do not yet heard all of the evidence, and your question may be answered by the time the rest of the evidence has been presented. You should only consider evidence with you should consider the evidence with an open mind, and you should not reach any final conclusions until the trial is over. Do not jump to conclusions before all the evidence is presented. To maintain the integrity of the jury system, I'm going to remind you again, remember my ad nauseum admonitions? Okay, y'all shaking your heads like, okay, we're going to go through those one more time. I'm going to remind you that you must decide this case only based on the evidence admitted during the trial and the law I will explain to you. You may not conduct any research on your own about this case or about any people or places mentioned during the trial. You may not visit any places mentioned in the evidence. You may not refer to any books or documents that were not admitted during the trial. You may not use any dictionaries or other reference materials. You may not use Google or any other search engines or any other resource matters, the internet, websites, or blogs. You may not use any other electronic media to get information about this case. You should not use any of the sources to get any information about the legal terms or about the law. And finally, you may not listen to any accounts of this trial that may appear in the news media, whether it's online, in print, on the radio, on your cell phones, or any other smart devices that you may have, or any other mediums. Remember, you are the ones that have been qualified as fair and impartial jurors deciding this case. No other influence should affect your decision. For that reason, as I mentioned earlier, part of my admonitions, you may not discuss this case with anyone, including your family and friends, or let anyone discuss this case with you or around you or in your presence. This includes discussing or sharing information by email, text, blogging, or other form of social media until actual deliberations begin. That is, until after you've heard all the evidence, the lawyer's closing arguments, the law that applies to this case. You must not discuss the case, even amongst yourselves in the jury room, during breaks, or elsewhere. Remember, I told you, would it be a violation for you to sit back in your headquarters jury deliberation room after we take the first witness? Hey, what do you think? Is that a violation? Yes. Come on now. We all got to kind of shake our heads. Yes. Would it be a violation for you to be, as you're walking lunch, to recap and discuss the case?
Yes.
What about you in the bathroom?
Yes.
That's creepy. Remember I told you about that before? Okay, all right. So we're not going to do that, all right? But what about going to the jury shuttle? Yeah, that'd be a violation as well, okay? What about if you're walking on Wednesdays and
judge's
Tuesdays?
discretion in Georgia, I think.
All right, okay. And how did I tell you you're probably going to get caught
like
if
this
you
judge a
violate
lot.
my admonitions? You're going to tell on yourself. That's right. Or somebody's going to tell me
Yeah.
that you've been
He's
on
been,
some particular
in my
site
opinion, a
or
bit
some
too
particular issue.
lenient
You all
during the
remember that.
pre-trial
Okay, I'm
motions,
proud of you. All
but
right. But it's really important, ladies and gentlemen, because remember I told you, fair trial, just trial, lawful trial. So all of these things are really important in terms of the admonitions and how serious we are about you not being only hearing what's in this courtroom and only the cases presented to you. All right. So you've been given pencils and writing utensils and pads for your note taking and use during this trial. So what I want you to do at this point in time is take and open your pad to the very first page. For those of you that have them, okay. For the rest of you, I'm going to get you a pad. All right.
well, Law and Seaward and Atlanta First News are the ones who are streaming as
Okay,
news
does everybody have a
organizations,
pad?
and then we
Okay.
have a dozen people streaming the actual trial.
Okay. All right. Who else doesn't have a pad? Do we have enough?
no,
Or
that was
we'll get you
that was
one during
another
the
judge.
break.
I don't know his background.
What I need you to do with all of you that have pads, go ahead and write your name on the very first page. Okay, that's your pad, okay? So whenever you come back in, each after breaks and everything else, if you're going to your headquarters, just leave your pad inside the basket, okay? We're not going to take a look at it, and nobody's going to bother with it. Who else needs a pad? Okay, everybody got a writing utensil? Pen or pen or pencil? Okay, for those of you, go ahead and who just got pads, go ahead and write your name on the very first page, inside cover. Just go ahead and write your name on it. And believe me, we have more pads, so if you get, by the time the trial ends, if you need another pad, we'll give you another one, okay? So, but leave them in your headquarters when you have breaks and go outside and for the end of the day. Just put them in there, take another juror sticker out, and that'll be kind of your way to kind of just trade and make sure don't take them home with you. Then the next morning you can find your pad and you can kind of just be prepared to take notes. Okay. So, I'm going to tell you that again, just leave your pads as you have breaks and everything else in your headquarters. And at the end of the day, like I said before, we will secure your notes. That'll probably be Miss Umano's job, and we'll just leave them in the basket, and we put the basket in your location, and then we bring the basket back down. So you all, when you come back tomorrow morning, or whatever morning you come back, you'll have your notepad. All right. Now, but please keep in mind, all right, you may take notes if you wish. If you do take notes, please do not let your note taking distract you from paying full attention to all the evidence and the witnesses. You may not share or discuss your notes with anyone until you start deliberating at the end of the case, and I tell you how you're to begin your deliberative process. Notes are not evidence. They're only memory aids. They are not more important than your own impression or memory of what the evidence may have been. You may consider another juror's notes to refresh your memory. You should only rely on your own memory of the proceedings. Do not be influenced by the notes of other jurors unless they unless their notes help you in determining your own independent memory. You must leave your notes in the jury room except when you are in the courtroom. They will be collected by the court and destroyed at the end after you finish your deliberations. Ladies and gentlemen, you will not get a transcript of any witness testimony, so please remember what they said on the witness stand in a way that works best for you, okay? I'm gonna tell you a couple other administrative, or as I call, administeria. Ladies and gentlemen, I've tried a lot of jury cases, so some of the things I'm gonna say to you are the result of debriefing a lot of our citizens. One of the questions I get on a routine basis is, Judge, what are you doing up here on the bench? All right, so I'm gonna demystify that, and I'm gonna tell you right now, so there won't be any question about what I'm doing, okay? All right, so as I told you earlier, I'm responsible for just about everything that goes on in this courtroom. So on the bench here, I do have a phone, and I can make certain phone calls I need to. These devices here, ladies and gentlemen, you're going to see us use them from time to time. They are audio devices that each pair of litigants has on their table to allow them to hear bench conferences, because I may have to take up things out that I told you outside your presence and hearing, but we may not want to put you out of the courtroom. So we may come up here, I cut my microphone off, and everybody using these devices is able to hear the bench conference that I'm having. Will you be able to hear a bench conference? No, that's not for you to hear. So, but these devices allow us to do that. So if you see people putting on these particular devices to talk, such as this, you'll know that that's what's going on, okay? All right, to my left, I do have a computer. I have a couple of different programs that are open that help me do legal research and other things to keep track of what's going on during the trial. And otherwise, I'm taking notes. So if you see me typing, don't assume I'm booking my next vacation. I could probably be doing that, but I'm not.
Okay,
I
that's
do
good.
take notes, and I do
That's funny.
pay attention to what's
Yes.
going on. I of course, I'm very interested in your comfortability, and I monitor everything that's going on here in the courtroom. So that's what I'm doing up here on the bench. All right. One other thing that you might hear behind me is this bell that starts jingling. All right. And if you hear a jingling sound like a bell, please don't think that I'm doing anything creepy up here. All right. I have a service dog behind me. His name is Jack. I think some of you may have seen him already. He lives the best life ever. He's pampered. He's really.
Oh, he has a
he's,
doggo.
He's a
Hey, I gotta jump
Labrador
off real
Retriever.
quick.
He's about almost 2.5, 3 years old at this point in time. So, but if you hear that bell, that's him moving around. All right. He doesn't bark. He rarely gets interested in what's going on. So he might come up here and look, but that's about it. All right. Don't bring him any food either, okay? All right? He is spoiled rotten. So please don't try and throw any food back here behind me or anything like that. He doesn't need anything else, okay? But if you hear that bell, hear that sound, that's what's going on behind me, and he'll get up when we have breaks and whatever else. So, but that's if you hear the bell, that's Jack. All right. Ladies and gentlemen, I think we're ready for the lawyers.
The
to
court
begin
should
their
have
opening
a
statements.
doggy
And what
cam.
we'll do is we'll probably go to
Yeah,
about
seriously. This is going to be 6
12:15 or
months.
so,
We need
and
doggo
whatever
cam.
we don't get done, we'll just continue on at
We're
that
just,
point in time.
when
Dave,
Dave
when you
leaves,
all come back from lunch, okay?
okay, we're going to need to
So at
get
this
Dave
point in
drunk,
time,
and he's going to need to
councils, I'm going to
he's going to
invoke
need
the rule of
the drunk
sequestration to
call
both
the court.
sides. So anybody who's going to give testimony in this case, if you please absent yourself from the courtroom, please don't discuss your testimony to anybody except the attorneys in this case. So at this point in time, does the state wish to make an opening statement? All right, go right ahead, madam.
I will start this for Dave.
We have spoken with the court about in terms of witnesses, whether they are allowed to remain within the courtroom.
I believe the matter that we discussed, we won't be able to take up till Tuesday. So that person should probably be excluded.
Then
That person, if they're gonna.
Yeah, use
Other
the
than that, I think
microphone.
we've covered everybody else. Unless there's an exemption. Do you have an exemption to the sequestration?
Your Honor, family members of the victims themselves were the only ones that are concerned?
I'm not, then there's no issue about sequestration as it applies to them.
Thank you.
All right,
And, excuse me, Judge, I have several objections to the course opening charge. Would you either reserve those or?
I'll reserve those.
Thank you.
Okay, all right.
Can I just make sure that all the witnesses are excused? Because I think there's been mixed messages sent by the attorneys, not by the court.
Okay, all right, okay.
Your Honor, may I please approach the bench?
Say again?
May I please approach with the state?
Oh,
Yes,
and,
Ms. D. Williams.
and the forkery begins. Yeah, this
Yeah,
is what happens when you
For
have.
those of you that wish to listen in, you can go ahead and do so.
This
I
is
mean-
what happens when you have multitude of defense attorneys, because they only have their own defendant's interest in hand. They don't care about any of the other five, only their own.
No. And that's what, when the judge said, if you see me talking, and I said, and he should say, this is going to happen every 5 seconds. That's what he
Yeah.
should have said. And this will happen every 10 seconds.
And expect anything from this trial, because there are 6 defendants, and every lawyer with their own defendant have their own interest at hand. And the police prosecution use the microphone. It's right in front of you. And we have a sidebar.
We're going
I
to be on
have-
Dave.
I wonder if we ever
77
go to
before we
opening
get-
statements.
My bet is no. We'll be on day 77 before we actually get to opening.
Yeah, I mean, we are 2 hours. I started half an hour early just to make sure I got the introductions and what happened in pre-trials and stuff like that done. And then they were an hour late because they didn't find a juror. An hour and a half late.
Well, it happens. I mean, jurors, how can you find them?
Sidebar
Where would you-
counter. Pen and paper.
I mean, as a juror, you can be anywhere.
Manual sidebar counter.
We do need that. I don't know how you do that, but we need it. We'll have to ask Aussie how you do that.
Yeah, I have no idea. Available at my merch store. The mug with you can't un-F a cluster F.
That is true. We can use the whiteboard of truth for now. If I
Yeah.
remember where I put my eraser. You're expecting past Mo expects future Mo to be on top of things way too much.
Yeah, I have a piece of paper and a pen, and I will do it manually, and then I will try to find somewhere to have a sidebar counter.
I'm going to count
How many-
this as 2 because 2 lawyers got up.
No, but it's just one sidebar. Well, we compare notes afterwards, and then we'll see.
Well, I counted 2 lawyers objecting to something. So one
Yeah,
put
fir-
something on
first-
the record.
Yeah.
And
One first attorney objected to some of the charges itself. I assume that is because they have appealed a bunch of them to a higher court, but that might be just a technicality. he needs to have that objection in.
They what? No, they should have just,
We also
Everybody gets
have
at least
a
one.
mug with jingles.
no? No, they're not, they're not.
And
against
that
it.
looks something like this.
Then cut the camera off.
With jingles
They'll be
in a
like, cut the
Viking
camera off.
helmet and a suit.
And that is his exact face all the time.
Yeah. This is his, I'm so sick of this and I need to eat something. And he's not allowed to eat me, not yet. He tries, he tenderizes me with his murder mittens and yeah. He is around here somewhere, so he might make his presence known eventually. K-Pick, the YNW Melly case was against one defendant. Here you have 6.
Approach again with Miss D. Williams.
And okay, another sidebar. So they waited for the first sidebar to end, and then can I approach? Oh,
Jeannie Williams is getting her steps in. They hate her. They're like, we're going to wait till she sits the hell down.
I'm going to exclude you for the time being, okay? Let's just move on. I'll take it up.
No.
But another time. We're not going to take it up right now.
Thank you.
Okay, okay, not the sidebar.
Your Honor,
One remove.
that I have
Yeah.
provided certain things
All right.
that I want to comply with.
Yeah, we
Wait.
could have taken that thing up an hour earlier, but I'll take that issue up later.
Yeah, I assume the defense has no interest whatsoever to go easy on the court or the prosecution. There will be objections everywhere because, as I said, every defense attorney has their own client and their own client's interest, not the other 5. Yeah, and for you in the chat over at Rumble or here, I have no issues if you go off topic and discuss. As the other day, there were some pie recipes going, and sure. But eventually, I would like you to comment on the actual trial. No, Dave. They started with one objection and sidebars. Mr. Williams' attorney objected to some of the charges that was read to earlier. What are you waiting for? Yeah, my this case is going on until June 2024. Yeah, that's the minimum of 6 months. That was the plan when they had 79 witnesses for the state. Now they have 737 witnesses. Here's jingles. Yeah, Jingles is here to destroy my my share and heat up my neck. Yeah, it's Jingles, the bacon stealing cat. Yeah. Hello, Haley. Yeah, that was my barbecue stream where I tried to assemble a few burgers and started assembling. Then I leaned over for the bacon and the bacon was gone. And there's I didn't eat it. Yes, who stole it.
Jingle says, my lawyer has recommended I make no comments regarding the location of said bacon.
Why are they all being tried together? This is a RICO trial, so they are tried as a criminal organization or criminal enterprise. So, according to the state charges, they are responsible for each other's crimes as well.
All right, if you wish to make an opening statement at this point in time, please go ahead. All right.
I'm going to now share my screen report for me.
Yes, ma'am, go right ahead.
Okay, who starts? Seems to be the state. District Attorney Fanny isn't there today, which I don't know why, because I would assume that since she is the one who brought the charges, she would.
Now, this is the law of the jungle, as old and true as the sky. And the wolf that shall keep it may prosper, but the wolf that shall break it must die. As the creeper that girdles the tree trunk, the law running forward and back. For the strength of the pack is the wolf, and the strength of the wolf is the pack. Thank you so much, ladies and gentlemen, for being patient. Thank you so much for being honest during this very lengthy process that preceded this point here today during the voir dire process. I appreciate you all being here, exercising your civic duty, and honoring your obligation to pay close attention to what's going on in this courtroom for the next several, however many weeks.
Weeks, lady?
Some people like to say that opening statements are a roadmap to what the trial will show. Instead, I'm going to give you an overview, a bird's eye view, because you're going to be sitting here with evidence for the next several weeks at least. And you will be able to see what that evidence is. Nothing that I say to you during this part of the trial, and nothing any other attorney says to you during this part of the trial is evidence. But I can tell you what I expect the evidence to show. And what I expect the evidence to show in this case is that YSL, the group made up of the defendants sitting before you today, along with other both indicted and unindicted co-conspirators, YSL operated as a pack. The quote that I read to you earlier is from one of my favorite books as a kid, The Jungle Book. In case anybody recognized it, those were Rudyard Kipling's words and not mine. But they are appropriate for where we are today. For 10 years and counting, the group calling itself Young Slime-like dominated the Cleveland Avenue community of Fulton County. They created a crater in the middle of Fulton County's Cleveland Avenue community that sucked in the youth, the innocence, and even the lives of some of its youngest members. Now, the evidence is going to show that this group started out as a group called Rock Crew. And Rock Crew stands for Raised on Cleveland. The evidence is going to show you that Rock Crew, in fact, is a criminal street gang. It's not the kind y'all are used to. If you're more familiar with the national gangs, such as the Bloods and the Crips that operate in LA or in Chicago. But make no mistake about it, Rock Crew is and was a gang. It consisted of 3 or more members with common identifiers, signs, colors, linguistic choices, that committed crimes on behalf of and in furtherance of ROC Crew itself. That particular organization aligned itself under an umbrella of a larger, more traditional street gang called Sex, Money, Murder, Bloods. They adopted the nomenclature. They would do things like replace C's in words with the letter B, because traditionally Crips and Bloods were not aligned with one another. So Cleveland Avenue became Believeland. Some of you may have indicated during voir dire you've heard or are familiar with the Cleveland Avenue area. Maybe you've even heard of Cleveland Avenue Day. The evidence will show that this is where that comes from. The evidence will show that this is where.
Don't start with me now.
That comes from. The evidence will also show that sometime in 2012 or thereabouts, an internal rift or divide occurred among the members of ROC Crew. Now, the defendant, Jeffrey Williams, seated back there yawning right now,
All right, I'm moving from router to mobile. All right, I changed from router to mobile. It's the Mo Show.
Yeah. Well, you know, I try. Well, so I really do like how this judge went through and explained in plain language how the court works, because I think a lot of judges kind of expect people to have a working knowledge of things, that maybe everything has gotten so kind of usual and everyday to them that they don't realize that jurors don't have that everyday knowledge. And if you're coming in, you know, things don't understand or things don't always make sense. So I really like how the judge took time, kind of added a little humor. He wasn't a total hard ass on the juror who apparently just, I don't know what he was doing with life, but didn't show up on time. So he was very personable.
K-Pick, on a federal level, at least we checked this earlier in the stream, it's the wordings is may get paid by the companies, but it's up to the individual companies if they choose to pay their employees for during jury duty. But that's on a federal level. And but I guess it's up to the individual companies. But seems like my internet is up and working again, so here we go.
Stealing ATM machines, things of that nature.
You got to be.
As you do every night.
YSL, or Young Slime Life, was formed. And the defendant, Jeffrey Williams, was its proclaimed leader. Young Slime Life came about and consisted of 3 or more people when it began. 3 or more people who were willing to and who did commit criminal street gang activity, that is crimes, that were intended to further the purposes and advance the directives of YSL itself. Now, there will be no evidence of a written contract or anything like that. You won't see bylaws of YSL.
I've been on Chrome, but it seemed to be forking with me, so I am changing over to Edge and see if that works better. This will take only a few seconds. Bear with me.
Okie dokie. It's the Mo Show. So I think we are going to be looking at a bunch of sidebars. I am going to go ahead and place a small wager on today for the whole day, 35. Gonna go with 35. Over and under 2.
All right, I am back, and so is this. And here we go again.
And consisted of 3 or more people when it began. 3 or more people who were willing to and who did commit criminal street gang activity, that is crimes, that were intended to further the purposes and advance the directives of YSL itself. Now, there will be no evidence of a written contract or anything like that. You won't see bylaws of YSL, because this was a group of people associated in fact, who used common identifiers, common names, common colors, common symbols to communicate with one another and to express themselves to the rest of the world. So YSL, as the evidence will show, they didn't move individually. The members and associates of YSL, they moved like a pack, with the defendant Jeffrey Williams as its head. You'll hear from witnesses, both law enforcement and lay witnesses, who personally experienced and who personally witnessed the activities, the crimes that were committed. You'll hear from law enforcement officers like Kimberly Underwood and Tyrone Dennis, whose main goal wasn't to go out in the streets and lock up people who looked like them. It was actually to touch souls in the streets, to touch young people, and to alert them of the dangers, drawbacks of becoming a part of and becoming involved in gangs like YSL and Rock Crew. You'll hear about conversations with educators. You'll hear from members and associates of the gang itself. Now, as to how those members and associates will respond or act once they're actually in court and on the stand, that's something that I am truthfully not able to predict to you fully. But the court has given you instructions on determining and judging the credibility of the witnesses. And I trust that all of you will in fact follow those instructions. The evidence will show that YSL checks all of the boxes for being a criminal street gang. As I stated earlier, they are 3 or more people associated in fact. Their members commit crimes on behalf of the gang. They commit crimes such as armed robbery, hijacking, motor vehicle theft, theft by receiving, stolen firearms, so many stolen firearms, possession of a machine gun, and narcotic sales. And last but certainly not least, murder. What you will not hear any evidence of is that the defendants were not involved in a criminal street gang. You will not hear any evidence that they did not commit crimes on behalf of YSL. And as I stated to you earlier, what I'm saying to you now, this is not.
Let me object to that statement, please, as burden shifting.
Object basis?
Burden shifting. And under Parker versus the state at 277.
Why don't we take that up and
39.
I'll note your objection. I'm sustaining the objection. Why don't you rephrase, madam?
Yes, Your Honor.
Just rephrase it.
That was the lawyer who had a
Ladies and gentlemen,
30-minute.
I'm going to explain to you
That was the lawyer who had a 30-minute lecture on the Second Amendment in a hearing we listened to last week, which was an interesting history lesson where he tried to get all the gun charges off by claiming that there historically you can have a gun if you're a convicted felon. Not until I think 1984 it became in law.
Yeah,
And
that is
he made a
true.
good argument, and a good history lesson, but no, since it was a lawmaker who actually wrote the law about
Yeah.
not allowing felons, so it kind of fell flat. But it was an excellent history lesson. I think it was last Monday or Tuesday. But yeah, let's go on.
at the appropriate time, ladies and gentlemen, what the burden is in this case. Remember what I told you earlier, that the burden never shifts to the defendants to prove or certain innocence, the presumed innocent. And it's only until you hear evidence that you decide is sufficient, and I'll instruct you on how you're supposed to do that at a later point in time, okay? All right.
1986.
The evidence will show that YSL did not adhere and does not adhere to all of the customs of a traditional street gang. And the fact that YSL does not mirror all the customs of a criminal street gang, the evidence will show makes it no less a criminal street gang. The defendants on trial here today have, through their actions, displayed not only their allegiance, their alliance with one another and with.
That would be, burden shifting in opening, that's bordering close to a motion of mistrial. But we will find out later today, I guess, if they go that far. I don't think so, but because this is not evidence. But I think the judge did a good reasoning about it. And that makes the jury alert on that. Burden shifting absolutely never allowed from the prosecution. I wish that was the case in Kenosha County. And thank you, Brandon, for your $5 super chat. It's much appreciated. Super chats and memberships is what keeps this channel afloat. So thank you so much, Brandon.
The gang itself. Through their actions, they have displayed
Oh, come on.
unspoken agreements
I have a
to
full
participate
minute buffered.
in that gang through a pattern of illegal activities. And again, the head of this gang is seated in this courtroom too. The last paragraph of that poem that I read, that spoke to you earlier, goes as follows. Because of his age and his cunning, because of his right.
This is argument. This is not.
What's your objection, Mr. Harvey?
That it's argument.
Okay, Mr. Harvey, hold on. Madam, it is argument at this point in time, so I'll sustain the objection, okay?
Yes, Your Honor.
All right.
2 sustained objections in
The evidence
opening
will
statements
show
already?
That
Holy
these
Wow.
defendants, that the members and associates of YSL, they knew who their leader was, and they knew the repercussions of not obeying their leader. You will hear evidence that when members and associates of YSL got in
Who's
trouble,
abstained?
got locked up,
Sustained, I mean.
the first person they called
I'm writing it as
was either this
sustained.
defendant or one of his family members. Now, they didn't call him directly because he knew and they knew that he needed to have distance between himself and the crimes members and associates of YSL were committing on behalf of the gang. So they would reach out to his sister and have his sister reach out to somebody else and eventually get back to King's Line, as they call him. You will hear evidence that members of YSL committed armed robberies. You'll hear evidence that to slime someone is to do them dirty, and that sometimes members of YSL committed crimes against other family members of their fellow gang members. You'll hear evidence that when one of the associates or members of YSL did something to what Jeffrey Williams had perhaps considered a friend, they were threatened with their very life. Tell them to get that stuff back or they will be killed. You'll hear evidence that YSL, they had opposition within the city of Atlanta and Fulton County. That there were other gangs that were at various points in time at odds and even at war with YSL. One of those gangs was known as the IF gang, IF, Inglewood family. You'll hear experts come in here and tell you more about how the Inglewood family bloods in any way made its way down to Fulton County. You will also hear evidence about how one of the members, one of the beloved, of whom YSL considered an opposition group, was gunned down. Donovan Thomas on January the 1st, 2015. January the 10th, my apologies, 2015. Gunned down, openly and notoriously. Because the evidence will show that part of the reasons that criminal street gangs operate the way that they do is to establish dominance and to establish control and to establish fear. You're going to hear that this gang stole at least 3 lives from this community over the last 10 years. At least 3 that are referenced in this indictment. You'll find that as a result of this gang's activities, a young woman who had nothing to do with either YSL or any of their opposition was gunned down by people trying to get back at YSL for what they did. You'll hear evidence that after the murder of Donovan Thomas, no less than 50 shootings occurred over the course of the next several months. You'll hear evidence that hundreds of bullets were fired into cars, into homes, and into people as a result of the rift young Limelight had with other people in the community. So what are they accused of and what are you here for today? The judge read the 4-hour-long indictment to you 12 months ago. He didn't read it to you again today, but he generally gave you what each defendant is being charged with and what the state has the burden of proving beyond a reasonable doubt as it relates to each defendant. But just to broadly touch on those, the crimes that the state will be proving to you over the next several weeks include conspiracy to violate the Racketeer Influence and Corrupt Organizations Act. That is an absolute mouthful. So we'll just say RICO. There's no substantive allegation of RICO violations here. And by that, I mean, there's a difference. Here, the state is alleging that these defendants, they had an agreement, unspoken, but no less an agreement to obtain property, things of value, cell phones, cars, stolen guns, through a pattern of illegal activity. The evidence will show that
the Georgia RICO Act includes that the state can allege unspoken agreements. I mean, can you be more vague? Can you?
Yay for thought crime.
Yeah.
It's sort of like if 2 people said, okay, you know what, we're gonna go toilet paper our dean of admissions house. And they sat there thinking and talking about it, and someone overheard them and reported them to the police. And the police came and said, okay, I'm gonna arrest you all for conspiracy, for planning to go and do this. The evidence will show that it's not enough that they were planning to do it. Somebody has to do at least one thing in order for those two people to be found guilty of conspiracy. So say one of you goes and says, let me go get the toilet paper now. Then y'all in trouble. That's what we have here, and that's what the evidence is going to show. There was an agreement among the members of YSL to obtain property and things of value through a pattern of illegal activity. And it is their actions over the course of the last 10 years. It did not stop, by the way, in 2015. It didn't stop at all. It continued up through and even into 2023, after this case was indicted, as the evidence will show. But their actions are what the state will be looking to you to evaluate and determine. Does this action show that they are agreeing to participate in this organization, this enterprise, through racketeering activity? You'll see evidence, as I stated, of not just drug sales, trap houses, drug houses, whole houses out of which drug sales were conducted, where they held long-arm guns by the door, where they stood ready to act on command if either one of their number called. Who's on trial before you today is Rodelius Ryan, Lamarcus Nichols, Marquavius Huey, Jeffrey Williams, Shannon Stilwell, Diamante Kendrick. And their actions during the dates that are listed in this indictment are what we are asking that you pay close attention to and you evaluate.
Your Honor.
You have an objection?
Yes, sir.
Basis.
For the motion.
All right. Ladies and gentlemen, this is one of our breaks. I'm going to need to probably ask you to retire to your headquarters to your deliberation room, and we'll call you back in just a minute, okay, when we finish up our business, all right?
Okay, this counts as a sidebar in my mind.
Remember the court's admonitions, ladies and gentlemen.
Yeah, this is an objection they have to argue for, and the jury can't be there for the argument, and I assume the judge it's too broad for...
All right, please be seated. Our jury has left us.
This is the third objection.
All right, Mr. Steele, what's your motion, sir?
Good morning again, Your Honor. Your Honor, last week, 2 weeks, 3 weeks ago, you ordered the parties to share all of their displays in opening statement to the others so we don't have to have these interruptions. I did that. The state shared with me 4 attachments. That's all they had. That's what I got. What you just saw on your screen, if you don't remember, I'll ask the state to put it up and I asked for it to be marked as exhibit, is what you already excluded. It states that Mr. Ryan was convicted of murder and I represent a co-defendant who's not on trial on the appeal. How did that not get sent to me so I could bring it to the Honorable Court's attention? 1. And 2, how do we just violate court orders? So yes, I have a serious motion for a mistrial because it's intentional misconduct. That's my motion.
Oh.
All right. And I'd like the screenshot to be captured for Mr. Weaver to put in the record.
I'll admit it is next court exhibit order of the state's presentation anyway. So, all right. So that'll be court 1 for purposes of trial. So, Ms. Love, what's your response to Mr. Steele's assertion about Mr. Ryan?
As it relates to Mr. Ryan and the exhibits that the state intended to play and to display for the jury, I sent to Mr. Steele and everyone else the pictures and the photographs that I expected to use. As it relates to the slide to which Mr. Steele is now referring regarding his representation on appeal, I'm not certain if the objection goes to the fact that there was the conviction, because that's part of the indictment and that's part of the evidence that the state expects will show, or if it's as to his objection about the fact that he represents Mr. Ryan or Mr. Blaylock on appeal.
You don't represent Mr. Ryan.
Mr. Blaylock, man.
Excuse me. I've never said this, ever. That's it.
Okay, what's your objection based upon, Mr. Steele?
Objection based upon, I argued this before this honorable court. You argued the prosecution that before they ever mentioned my name, you granted this motion.
That I did.
You brought him up to this honorable court, outside the presence of everybody. We're an open statement. I am lied to. I am saying that. I am lied to. Or if anyone else got that exhibit, I did not get that exhibit. And I'm seeing everyone say shaking no. And now it goes against the court's order. We are bound, duty bound to follow some of the court's order.
And join in the objection on behalf of Mr. Steele.
Let me see the.
I can put it back up.
Yes,
Judge.
ma'am.
And Your Honor, while I am putting that back up, I will state in my place that initially when there was the objection from Mr. Steele, I didn't have a clue what it was about because I didn't mention his name and didn't intend to mention his name. As I looked at the screen, I saw that part of his name was on the screen for the most part.
When I mentioned that.
That's your responsibility. Jesus Christ.
I did. I would take it.
Do we have a standard operating practice in Georgia at all?
At that point, then I would deal with it accordingly.
Yes, Your Honor.
So,
And Your Honor, as to Mr. Steele's motion, as I'm pulling this up, the state would vehemently object to a mistrial and ask for a curative instruction and a reminder to the jury that nothing that the lawyers say is evidence in this case. This is not at all the type of thing that rises to the level of mandating a mistrial. Certainly not. It just isn't. I have the.
All right.
The slide.
Pull up now. Court one for purposes of the motion for mistrial.
This can be, I mean, this is quite serious. First, she hasn't shared this with the defense, that she would use this in opening statement. Second, she said she didn't know.
Well, and it's also going against an order that he already ruled on.
All right.
And we are, what, 15 minutes into her babbling or 20 minutes?
Yeah, on slide 11 of 65, that I see where you have that at the bottom, represented by Brian Steele. So we can leave that for the time being. Leave it for the time being because it is what it was up. I'm going to deny the motion for mistrial, Mr. Steele, but I will go ahead and give a curative instruction to our jurors at this point in time.
Okay.
So,
Your Honor, I'm supposed to ask for a re-occurrence for my mistrial before the next process goes on. I'd like you to do me a courtesy, if you would, and allow me to do that now and preserve the motion for mistrial.
You've made your motion for mistrial and the basis, and I'm going to mark the whole state's presentation as is as court one for the purpose of your motion, and it will go in as stated.
And I have two other issues I'd like the court to just take up. One is just remember, I know you ruled on it, but the state said earlier today that Mr. Williams is contacting through parties that they don't know to pay for other people's lawyers. So I think that couples with that exhibit. And number two, I'd like the court to now order prosecution to give me and anyone else who wants to see it. I need to see respectfully what you ordered last week, all of the displays of the state of Georgia that they have not given to us.
What do you mean by what displays you're talking about, Mr. Steele?
I never saw that. I never saw the wolf. I never saw the indictment. You ordered I gave all my displays. I gave everything to the state. I got from the state.
Are you talking about using for opening statements, sir?
Of course.
Okay.
Should have been done.
All right, Ms. Love.
Yeah. Thank you, Your Honor. Two matters, Your Honor. One, the first thing that Mr. Steele has requested of the court regarding the representation that the state made about other YSL members contacting Jeffrey Williams for representation is absolutely and has always been a part of what the state expects will show at trial.
I'm going to deny that portion, but to Mr. Steele's point, I'd already made that issue in terms of his particular involvement, and anything you need to let me know prior to that, and I need to rule upon it, and also subject to foundation, just like this. So I assume that what you told our jurors is what you expect the evidence to show. Yes?
Yes,
All right,
definitely.
so I'm gonna overrule that part of his objection. What about the last thing you mentioned?
And Your Honor, as to the court's directive that we turn over anything or any exhibits or photographs, that was my understanding of the court's directive, that we expect to show an opening statement. As a matter of course, I can again reiterate the fact that it was an inadvertent omission to leave Mr. Steele, at least part of his name on here.
I got that, but he's talking about, is there anything else you're going to use in open you haven't shown to the defense counsel?
I
He's
don't
telling
mind
us,
sharing.
well, I said that. I told you to do that a week ago.
Your Honor,
Because here's what I told you was going to happen. I've got a jury that's out right now that's being interrupted. And Mr. Williams, you should have made your motion or should have told me about that an hour ago or when you found out about it. Not hijack me at the bench about that. You did what you had to do, but I'm not happy about that. I'm not happy about any of this. Because this is stuff we can take care of before our jury comes in. And that makes you all, lessen your ability as advocates and lessen our ability for this jury to go ahead and get this case seamlessly. This is what I told you all was going to happen. So have you given them everything you're going to show them during opening statement?
Your Honor, I haven't given them all of the word slides. I did give to them what Mr. Williams objected to. I had given that to them previously. I will give them or share with them the things that have been added as of this evening. And
can you do that over the next 5 minutes?
I sure can.
Deputy Ingram, can you find out if our jurors are ready? Are they ready? Are they still using the restroom?
I'll send that to them right now as we're waiting.
He ordered her a week ago. Here's the slide I'm going to use.
Can we have
And
5
she
or 10 minutes to
didn't.
review whatever Ms. Love is going to send us?
You can take a comfort break, and I'll come back at 10 of 12. And like I said, whatever we don't finish before 12:15, we'll pick up after lunch. Okay?
Thank you, Your Honor.
Who's talking?
Yes,
Mr. Sharp.
On behalf of Mr. Stillwell, we've been operating pretrial with the Harvey rule. I want to make sure that the record is clear that we join Mr. Steele in his motion for mistrial. And if Your Honor,
I'll apply the Harvey rule unless you tell me otherwise. Okay?
And that will apply throughout trial.
Yes.
Okay, thank you.
Unless you tell me otherwise. Okay? All right.
Thank you.
All right, we're going to be recessed about 10 minutes. All right?
Your Honor, what I'm going to do before stating is I'm going to actually do a search for the first 4 letters of Mr. Steele's name, make sure that I didn't need anything else in there. So before I do that, I'm going to send that. I'll make that search.
What an absolute clusterfuck. During opening statements, they get 2 objections sustained, 1 for argumentative, and what was the first one again? For
the first one was for burden shift.
Burden shifting. And now she's showing the jury images she hasn't shared with the defense.
Now,
I
what
mean-
is the Harvey rule, Nicholas?
Yeah, I am.
Sorry, I
Harvey
was
rule.
thinking we would have questions about that. So, as a non-lawful law lawyer, how do you not send this stuff? I mean, do they not have interns?
I mean, she was ordered by the court to share it with the defense, and she just said in open court she didn't.
I'm gonna get to it.
The Harvey rule. I'm currently using Edge, so I'm binging this question, and Microsoft Bing is run by mentally challenged
Window lickers.
window
We
linker.
try.
Yeah.
So we've had 2 requests for mistrial.
Yeah. Well, one, they joined in on the mistrial.
Yes.
For 2 of the defendants. The other 4 are staying silent for some reason.
Well, unless what in the... I was under the impression that you can't just, pick and choose what rules of the judge you're going to follow. I mean,
Yeah.
I could be wrong. Georgia could be different. But,
Okay, this is Harvey v. Georgia. Just your opinion summary. Holly Harvey entered a negotiated guilty plea on 2 counts of malice murder for the ending of her grandparents' While serving consecutive life sentences, Harvey sought to challenge that plea through a motion for an out-of-time appeal, which was denied. Harvey appealed the denial of that motion, argued her plea counsel provided constitutionally ineffective assistance in advising her of what appellate right. Huh? This must be another Harvey. I need to use a proper search engine. Harvey rule, Georgia. Okay, under Georgia law, a motion to withdraw a guilty plea must be filed within the same term of courts as the sentence entered on the guilty plea. And I assume this is regarding the person whose name was on the screen, who is now appealing under the Harvey rule. Which excluding evidence. Yeah, so during the appeal, they're not supposed to bring it up? I'm not sure. Dave, you're welcome anytime. You have the link.
Between God, Google, and Dave, we will figure this out.
Yeah. That's a t-shirt. Between God, Harvey, and Dave, we will figure this out. That's a t-shirt.
Yes.
Oh.
And I think this judge has the service animal so he doesn't stabulate allegedly all these judges. He's like, I'm going to need a fluffy puppy. And Georgia was like, okay, you can have a puppy.
Yeah. And during the state's opening statements, they did burden shifting, argumentative, and now motion for mistrial because she showed a name she wasn't supposed to of slides she hasn't shared with the defense, which she was ordered to do by the judge a week ago. What an absolute clusterfuck.
Could Bailiff's shirt get any tighter? Could he size down just one more again, do you think? Kids extra small, just to get those buys?
Yeah, that's a bailiff that is working out and proud of it.
I mean, you get your sets in, sir, but...
Oh, and Prosecutor Love is on the phone with District Attorney Fanny. Yes, we have. Just saying, I don't say they are, but if they were to get married, she would be called Fanny Love.
Oh my God. Please make this marriage happen. 2023. We've already had Bigfoot possibly sighted, maybe the Loch Ness Monster.
And
all
for
we
everybody who, if you're American and don't know about English lingo, look it up. Oh, yeah.
There may be a reason Fannie Mae chocolates didn't go over well in England. I'm just saying.
Let's put up the Dave signal so he can get on here and explain this to us.
Yes, Dave, I know you have a real job, but your clients don't love you like we do. I mean, they're just, trying to stay out of jail. We need you for chat reasons.
I'm not that surprised because this has been the signum of this prosecution the entire time to avoid handing over evidence, avoid handing over everything. Hey, the Dave signal worked.
So I don't know what the Harvey rule is. I tried looking it up in Georgia. There's a couple of Harvey cases that have some fairly significant issues involved, Court of Appeals cases, but I don't know what the Harvey rule is. I don't know if it's involving excluding evidence that's unlawfully obtained. There's an issue with not sharing the information, but it's not really pertaining to this exact situation. It was something about a search warrant that was, or an arrest warrant rather, that was canceled. So I don't know exactly what the Harvey rule is, but at its essence, it essentially is excluding evidence that is for some reason improper. So I think that's what they're trying to do.
Yeah. And I mean, she was ordered a week ago to hand over all the slides she was going to use in her opening statement to the defense. And here she is using stuff.
Yeah. The biggest thing that I pulled out of the Harvey case was that if people don't know, the exclusionary rule is if evidence is obtained illegally, like in violation of one of your, constitutionally protected rights or some other statutory violation, then the only sort of recourse that a defendant has is that you can't use that evidence or any further evidence that was obtained from it. And so excluding that evidence from the trial is a big hit to the police or the prosecution or anyone that's committing the malfeasance. And that would also be the same too for the defense generally. So it seems to be the Harvey rule is focused around excluding evidence that was obtained or like hidden or something unlawfully was done with it. So that would be a good outcome here. You can't use it. But 3 objections in the opening statements alone.
Yeah, I mean, First burden shifting, then argumentative, and then motion for mistrial because they used stuff they haven't handed over to the defense.
Yeah.
And this is quite serious. I mean, I don't think this judge has, during all the pre-trial motions and pre-trial everything, done everything to move this forward to trial in order to hand it over to a jury. So I don't think he will, but I think the burden shifting was serious. But this,
if I was a judge in this position, I would be extremely frustrated with the prosecution for the way they brought the case, the way they're presenting the case, the way they're doing everything. And I would slowly chip away at them as sort of a lesson, not only for this case, but in the future, because the judge has the authority to do so. But I would just be extremely annoyed with the way the prosecution has been handling this case. And I would let them know in no uncertain terms.
Yeah. And he did let them know. He was quite angry. First, because
I saw that.
Yeah. The defense brought, they had an hour and a half break because they lost a juror. And defense could have chosen to bring forward that motion, another motion. During that time, they chose to bring it up as the jury sat down. So he's not happy with the defense either. So it might be equalizing it and just to move forward. But I mean, had this been for a lesser crime, I think this would have been yeeted from this.
Yeah, potentially, or a less complicated crime. The judge might be sitting here and thinking, wow, that was one little fact lost in the sea of the facts that are going to come out in this case.
Yeah.
The chat has spoken. We want to see hot Bales person in too small shirt. We have found our thirst trap. Well,
we have so Mr. Workout Bailiff has really he shops at the kids department when it comes to shirts because he's really proud of how he works out. So that's for you, ladies.
And
Dave,
there's an emotional support dog.
I'm stuck at the office today. I'm not supposed to be streaming right now, but you will see me in the treehouse this afternoon when I take over the stream.
Yeah, because over here it is 6 p.m. almost, and if this runs to 6 p.m. today, Eastern time, it's midnight my time, and I'm supposed to be up at 4:30 a.m. So Dave is gracious enough to take over the last couple of hours, unless there's a mistrial.
Yeah, that would be awesome.
I mean, I've been preparing for this trial for months, and it can be over in half a day.
And you guys, I am keeping tabs on the Delphi hearing. I did place a text to my lawyer friend to try to get the over under to see if Judge Gull will show up in court today or see her shadow, and there will be 6 more weeks of waiting. We don't know.
And no, I don't think. My bet is no, because she has been hospitalized and then working from home, getting all the other judges are doing her docket while she is doing only the Allen case from home. So if she's showing up, it's by Zoom, if the appellate court allows that. And I'm not so sure appellate courts are happy with Zoom.
Michigan appellate courts kind of like it.
Oh,
I mean, they don't dislike it necessarily. There's a lot of appellate courts that do a lot of things via Zoom, but they're, judges are old school. They're hard to change. So I prefer. I'm assuming they prefer to have people in court. Let's see what is trying to work a little bit here.
Yeah.
Why can't I find this case?
Yeah, I mean, the Harvey rule should be really accessible since they are referring to it, but I don't know how they refer to it in this court setting. But I think the appeal is about a plea deal he took, and then he is appealing everything about it, which might make it the conviction a bit moot during the appeal.
Oh, there was another case that was sent to me on my Discord from Georgia. The jury, I don't know if it has any connection with this, but the jury had found the guy not guilty by reason of insanity as to malice murder, but guilty as to felony murder. And so they went up on appeals, and the court's like, well, we can't overturn an acquittal. It's all kinds of mess. Let me look at that case.
Okay, they seem to be. Oh. They seem to be back.
The vehicle was broken down, from what I understand, right?
Something of that sort.
I was on hold with the court for 20 minutes, and then I gave up.
Oh, Dave, you do have to call the court. There is an emotional support dog. We need Doggo Cam.
Yeah. The judge has. What happened? What happened to sound? There it is.
I have no idea.
All right, if we concluded our sharing exercise, I told you all to go ahead and talk with each other through when we broke.
I did share, Your Honor, as well, if I may, Your Honor.
Yes, ma'am.
Sorry, I chatted as Nik again. I forget.
Earlier, concern brought to the court's attention by Mr. Williams. Ms. Hilton shared with me what was said on the bench, but as it relates to Cordelius Ryan's post after the murder of Shamel Drinks, that was provided from day one in discovery, Your Honor. And it is not a crime that he is alleged to have committed. We may have put that on a list, including things, but, Your Honor, that is not an intrinsic act in the sense of it being a crime or criminal act. And it is what the evidence is going to show happened. What I have in the PowerPoint, I can show to the court if you like. I sent that to defense counsel prior to today. I think I sent it Friday before 5. But what I have said is that on the day that Shamel Drinks was, I'm sorry, Jamari Holmes, my apologies to the court and to the family members here. What I said was that on the date that Mr. Holmes was gunned down, 12 hours after that murder, Mr. Ryan posted on his Instagram account, I bet YSL makes the news. And what I but I endeavored to say to the jury that the evidence will show is just that, that they were advertising and representing and boasting on behalf of the gang itself immediately after the murder occurred. And these are elements that the court, I believe, will hear from detectives and evidence. These are the things that the courts have said jurors and the courts should look to in determining whether something is done in furtherance of a gang. And so I would ask the court, I didn't take it out as the court instructed. I would ask that the court allow me to make reference to it. And thank you, Your Honor, for your time.
All right, Mr. Williams. Oh, sit down, Mr. Adams. You can just wait a minute. All right, Mr. Williams. What's your response, madam?
That the court already ruled on that, saying that you would bring it up as it comes forth. You stated that they couldn't use it in the opening, and I would just ask that the court use their instruction and make the state follow the instruction that the court already gave.
Okay, but it may not be what I think that Ms. Love is saying, Mr. Williams, is that the evidence may not necessarily be intrinsic. It might be for another purpose. It's what they expect the evidence to show. So, but here's the issue that kind of I'm disappointed as the court. We've had months and months and months. We could have taken this up before. I could have made it very clear. I don't need to take it up right on the eve of our jury sitting in the box. That's what I'm kind of more annoyed with than anything else. If you had clarity or wanted to seek clarity on that, I'm more than happy to rule on it, but I needed to go ahead and have some ability to do so. So I don't think it's intrinsic. It may be for other purposes, and I'll let the state reference that if they have a good faith basis to, that if they believe that's what the evidence will show. Okay?
They put it in their motion as.
Say again, madam, I'm sorry.
They put it in their motion as intrinsic evidence, though. So they shouldn't have put it in their motion if they were going to.
Yes, ma'am, I would probably agree with you, but did I ever rule on that issue?
You said that you would do it later as it came.
Okay. Well, here's the thing. Later is now. I got a jury in the box, so you could have asked me that an hour. I mean, we had time this morning. I could have gone through that this morning and made clarity on it for both sides. But do you have any other basis for the ruling? I mean, for my ruling, madam, any other argument?
No, just I wish that the court would just follow their own instruction.
Well, I'll follow my instructions when you all bring to my attention what you need to in a timely manner. Okay? And
they didn't know the prosecution was bringing this up. How can they bring it up before they know this happened?
Well, and did the attorney just actually hand over their opening statements? Because it seems like they didn't. So how are they to know what? Yeah. I mean, I get the judge's frustration, but I don't think they're talking around each other because the judge didn't realize that the state didn't give them this stuff. So the defense attorneys are trying to say, hey, she didn't give us this stuff. And you told us to say later. Well, later is now, and she didn't give us this stuff. So welcome to the dumpster fire, y'all. Yeah. Bring your popcorn.
The full breadth of, so I can rule upon it accordingly. That's what I'd like you all to do.
Well, they also have slide 45. They have my client's name on there as gunning down a 23-year-old Shymel Drinks, and my client has nothing to do with that.
That was another area.
But I didn't get that.
Ms. Love says she is going to remedy that and exclude it.
Thank you, Your Honor.
Okay. All right. Now, Mr. App, what is it you want to tell me?
I am so sorry, Your Honor. But thank you for allowing me to speak. I do have an objection, Judge. So,
what's your objection specifically, sir?
Attempted to email us during the break the PowerPoint slides that she is using in opening. I could not open the attachment. I brought that to the attention of her co-counsels and staff, and Mr. Matthews was able to open it, and I looked over his shoulder and was able to see some of it. There are at least a dozen more slides that were never turned over to us, even though the court instructed us to share it with the state and for the state to share with us prior to opening any exhibits for opening argument. And so, I mean, these are all new to us, and I would just ask that the ones that she did not share, she shared 4, that the ones that she did not share be excluded. I'm objecting because the court ordered for us to share these. She did not. Clearly, she did it intentionally. There's also apparently factual errors in them. I would ask that any slides that haven't already been shown to the jury and that she did not disclose be excluded from her opening argument.
That's a good.
Seems reasonable.
Yes, ma'am, and then I'll go on to the next person.
Thank you, Judge.
Yes.
Your Honor, I did not send only 4 slides or attachments. I sent to counsel for the defendants the photographs, the evidence that I intended to put into the opening PowerPoint. As far as the state's theory of the case and theme of the case and the words that I wrote, those are things that were being developed,
She's
ongoing.
admitting she
And
didn't
I did not understand the court's directive to me that we needed to turn over the words we would be speaking. As far as these photographs go, Judge, I said to them, if they can, actually, I sent them to them. So there are some, I have only about.
You should have sent them.
Hold on, wait, let her finish, and then I'll let you respond, Mr. Adams.
So all of these slides that involve Christian Ebinger, I sent to them. And other than the slides involving Christian Ebinger, there is a slide of the vehicle that Donovan Thomas drove on the day he was gunned down. It's the back of the vehicle with the placards of showing the bullet defects. That will be shown. There's no one that has made any objection to that evidence being introduced at trial. Nothing that I have put in the PowerPoint includes anything that has been objected to as being admissible at trial. And I believe that I'm not certain if this app thinks that we only serve 4. I don't know if he has.
This has been the prosecution, the entire pre-trial motion and the entire pre-trial hearings. We don't clearly understand the judge's directions. We don't clearly understand this. Everything to avoid handing over material to the defense. And here the judge clearly ordered them. The slides you are going to use in your opening statements shall be shared with the defense before opening statements. And here she is. That wasn't clear enough. This is
BS.
Yeah.
Letter in total.
Yeah. So when does good faith run out and you have misrepresented so much? I mean, my impression of the judge, I mean, he's presenting himself well to the jury. He's barking out stuff. Where's the bite, Judge? Where's the bite?
Had trouble opening it up, but we served, I think all of them, if not the great majority of them, because I don't have that many. I don't even have 20 photographs in this PowerPoint. So everything, and I can show the court, I would share it if I did not, with the court as well. But these photographs, I have a picture of Donovan Thomas in life. I have a picture of the barbershop where he was gunned down. I have a picture of the back of Donovan Thomas's Tahoe. I have a picture of Donovan Thomas's headshot. At the time of the autopsy, no cutting, no nothing, just his face with the number. I have a picture of, as I stated earlier, Your Honor, the truck with the defects noted, and then I have pictures of Christian Ebinger, all of which were provided, and that's the extent of it.
Well, the materials they are planning to use during the opening statements, that is so the defense can have the opportunity to object against some of them being used and control so there's no factual errors in them. And now, as we heard one of the defense lawyers say, there are factual errors in the slides, which they could have brought to the judge's attention had they been provided them before opening statements. Instead, we have objections everywhere and calls for mistrial during the state's opening statement. I mean, it's a clusterfuck.
Majority of the slides have my words, my work product on them.
All right, Mr. App, before I go ahead and respond.
Your Honor, no one's suggesting that she had to turn over the text of her opening argument, but if she's going to show a PowerPoint to the jury, that is what the court instructed us to share. We're visual exhibits, and that's what she's doing. She's placing it up on a screen for the jury to see. And whether that's her own words as part of her opening as a PowerPoint, or it's just demonstrative, she could have shared it, and she didn't. And she did it. And she's suggesting now to the court as a work in progress that she hasn't worked on her opening statement until this past weekend. I don't believe that. I think if that's the case, then she's just lying to the court. But if it's not the case, and she didn't mean to mislead the court just now, then she could have and should have shared those PowerPoints. As to the photographs, those also could have been shared with prior opening. If there's, and no one's suggesting they're not admissible at trial. If they're admissible, she can admit them at trial. But to show them to the jury now is part of our opening that violates this court's order that we were supposed to share our exhibits for opening prior to trial, which she did not do. So I think they should be excluded from the opening. And if she wants to introduce them later as evidence during the course of the case, then so be it. But I think there is good grounds for this court to, and Your Honor got upset because these issues could have been handled. They didn't have to wait until now. This is wasting time while the jury's waiting. Your Honor's right. And it's not our fault. It's her fault for not doing what the court instructed. And as a result, the appropriate and reasonable remedy is to prevent her from sharing any of these slides with the jury that she did not share with defense counsel prior to today. Whether they're evidence or whether they're text is part of her opening.
All right, Mr. Matthews.
Yes, Your Honor. Good morning to the court. I'd like to direct the state's attention to slide 15. In slide 15, the third bullet point, it references October 1st, 2020, in terms of that quote from a text message. In the indictment, Your Honor, if you look at Overt Act 102, that's where that particular quote comes from, Overt Act 102. In Overt Act 102, the date of that alleged text message was March 12th, 2020, not October 1st, 2020, as in the PowerPoint presentation. That's number one. Number two, the quote in the indictment is different from the quote in the PowerPoint. So that's two errors in slide 15 pertaining to Marquez Hugh. And then you go to slide 16. Slide 16 is an overt act that is alleged in the indictment as Overt Act 123. In the state's opening presentation, the date they have is October 1, 2020, but in the indictment, that particular overt act is November 16, 2020. So that's a third error in the state's opening slide presentation. So those need to be corrected to mirror the indictment so that it's not misleading the jury and in fact giving wrong information to the jury judge. So I would ask that the state correct that, remove it, or correct it.
All right, anybody else? Yes, Mr. Short.
Your Honor, on behalf of Mr. Stillwell.
Speak up, please.
On behalf of Mr. Stillwell, slide number 47, it suggests that Mr. Stillwell is still committing crimes on behalf of the gang, even after being indicted on these charges. We began to discuss intrinsic acts and other unindicted allegations last week. But we did not get through it. And my understanding was that anything that you had not ruled upon, we were not supposed to reference or discuss in opening statements. So those are clear references to unindicted charges that we did not get a ruling on its admissibility yet. And I would ask that that just be taken out of the presentation and no mention be made of those.
Anybody else? Yes, Mr. Steele.
Thank you, sir. If you would look at also number, I'm looking at now, 48, 49, 53, 54, 55. That's your prerogative. That's within your zone. That's law.
Would the court allow Mr. Steele to repeat those slide numbers? Because what I think that he's referring to is something that I placed in here that the court said during its preliminary instructions to the jury. And it was regarding the court, as a matter of fact, it was the last thing that the court said. And all that I did was put on the slide, judge's law.
In terms of what slides are you talking about, Mr. Steele, again?
I have 48, 49, 53, 54, 55.
So 48 through 55?
Excluding, so 48, 49, but then skipping to 53, 54, 55.
48 people now. Your Honor, may I share via Zoom the slides that Mr. Seal?
I would, yes, please.
Thank you. And he said, Mr. Seal, he said 45.
Just share the presentation, please.
What an absolute clusterfuck. So she didn't share it, even though the court ordered her to do it. Then she's misplacing things in the slides.
48, which is the last thing that the court.
Take notes?
Yes, Your Honor.
All right.
And
49?
that was directly from what the court just stated.
All right. 50?
And 50,
It's not 50, sir, 53.
53. Let's get down to 53.
Had
And
she shared this last
53
week,
is
this would have been done. This
what I
is
expect is evidence
shady
is going
from the
to show.
prosecution.
So I'm going to, in speaking to the jurors regarding the witnesses and the instructions that the court has given them, I'm going to say to them, some of them, as I've already alluded to, some of them may not be wanting to speak. Some of them, you're going to see evidence that some of them are afraid, some of them are embarrassed, some of them are intimidated, some of them don't remember, some of them don't want to remember. That's simply what the evidence will show. And Your Honor, what I'm asking that the jury does in listening to and considering the testimony of any such witnesses is as the court has already instructed, which is just to use your common sense because you alone decide who you believe. We're asking you to listen carefully, take notes, and pay attention. So there's nothing in that slide 53 that is in any way infringing on or entering into
Hold on a second.
a lane that does not belong to the state. We are entitled and allowed to show and to state to the jury what the evidence will show. The way that I have decided to represent it in writing makes it no less so.
Yeah, but it borders on argument at this point in time.
So I can change it because I do expect that the evidence will show that some of the witnesses are afraid, some of the witnesses are there. So I can take out.
Well, that's different. You might want to just redo it. Any further objections, folks?
Yes, Your Honor. I went over to the state's table, Carson Matthews, again, Mr. Bureau, went over to the state's table and brought to their attention an error in slide 42, and I think it's incorrect.
All right.
Is that correct, Nate?
All right, here's what I'm going to do. Folks, this is exactly why I told you. I wanted you to, and let me go ahead and just say this, Ms. Love, I told you to give them your PowerPoint presentation. This is why you give it to them, so that they can get errors and they can also figure out there's something they object to. So this is what's caused this delay. Because at this point, like I told you, there's no secrets in the trial of this case. You all have gone through quite a long process. But this just highlights the concerns the court had in terms of just breaking up the presentation for our jurors. So what I'm going to do, ladies and gentlemen, I'm going to go ahead and call our jurors out. I'm going to go ahead and release them for lunch. I'm going to tell them they're going to be at lunch until 1:30. During the lunch hour, Ms. Love, I want you to play or the slides that you have that otherwise have not been shown. You need to show them to the defense counsel and make sure they're correct. In the absence of them being corrected, I'm going to exclude your presentation.
They have the presentation.
But it needs to be correct. I don't want, if I get another objection about an error, I'm going to exclude it for the purposes of the opening statement because you didn't follow my instructions. This is why I told everyone. They need to get, and the defendants needed to give you their opening statements and the things they wish to use during their openings as well, because we're having interruptions and delay, and that's what I wanted to avoid for our jurors. That was the reason I told you all to do that. So,
Your Honor, as far as any typographical errors.
I'm not worried about that. But I'm not worried about that. But the errors that Mr. Apt, Mr. Matthews, and Mr. Short have made are errors, and Ms. D. Williams need to be corrected. Okay?
Yes, Your Honor, I will of course do it.
And but everyone else needs to see it so they can be comfortable and make sure that you represented something that what you expect the evidence to show to be correct. Okay?
Thank you, Judge. We'll do it. Your Honor, also
But he allows it in.
That even
If
if
you
I
can
spoke,
correct it.
even if I misspoke, the court has already instructed the jury and will continue to instruct them that nothing I say is evidence, and if I misspeak or miswrite,
But that's not the but that's not the point. I'm gonna tell him that. But and I told him that already. But that's not the point. The point is so that we can have a smooth and orderly presentation of evidence. Okay. So, all right. Sergeant Ingram, can we go ahead and call for our jurors, please?
Number 6-2.
You can go ahead and take up that during the recess. Okay.
Yes, sir. Thank you.
All right. Yes.
Yeah, I mean, the judge has been spicy before. But what does it matter if the prosecution is never actually punished for it? Then it's all bark and no bite. Now he's giving her an opportunity to correct the errors when he could have simply said, this should have been done. You violated my direct order. Those slides are out until they are presented in trial. That's what he could have done. And he chose not to. And I'm disappointed.
Yeah.
Because he always gives the prosecution a chance to correct themselves over and over. Has been that for the entire year of pre-trial stuff.
Yeah, it really does seem like he is very averse to, and I don't know if this is political. I don't know the culture of the judicial system down there, but if he threw out the case, what would that be?
Yeah, that's the issue he has, that can he really do it? And for me, what the prosecution has done for this entire year, this could have been thrown out months ago. But he wants to bring this to a jury. He really does. And I understand him. But at what point does it stop being fair? Because he's talked about fairness. But fairness goes both ways. You can't be fair to the prosecution all the time when it is objectively rulings against the defense. I'll turn the sound off because he's only instructing the jury that they are going to lunch and there are some mistakes being done and stuff like that. Yeah, appellate lawyers will be drooling over this because there is so much, in my opinion, apparent misconduct from the prosecution. And I believe a bunch of stuff probably is up because the judge allowed it.
Yeah. And why is it that she has put, I mean, you have the indictment. How is she putting things wrongly in the indictment? How do we expect the jurors to keep track of this if she can't even keep track of what she's putting down in slides? Yeah. This is insanity.
Yeah. I mean, for me, this is part of discovery. The opening, what she's going to use in the opening statements. And the witness list that wasn't sent over in its entirety until right before 5 o'clock Friday. The last 105 or so witnesses. But let's listen to what the judge will say now when he has sent out the jury.
All right. Ladies and gentlemen, please be seated. Our jury has left us. All right, so ladies and gentlemen, consistent with my earlier directions, go ahead and take a look at that, make those corrections, and I'll see everybody back for 1:45, and we'll go ahead and continue with opening statements at that point in time, okay? All right, we're in recess.
Oh, that's okay. That's okay. I thought he would get a lot angrier.
Me too. I mean, quite honestly, I would be ticked off.
Yeah. And we are now at recess Okay, so they are choosing a blank canvas for this. Yeah, an hour break where the prosecution and the defense will go through her slides, which she should have sent over to them last week so they could have gone
how does
through
that?
it. Yeah.
I am all the confused, but
this is a temperament. EDB always says she lacks, so she couldn't be a judge. She's too pissed to be composed right now. I mean, he does everything he can to avoid a mistrial. He really wants this to go to the jury for a decision. So he isn't sat down for, I'm saying it, in the next election. He will. I mean, he needs to be re-elected for his position. And this is a huge trial in Atlanta. These are several murder charges, attempted murder charges. It's about armed robberies, all the things. Okay.
Yeah, and I get
Liam
that.
also, Glanville is by far the fairest judge in Fulton Superior. Newcock runs a close second. Okay, but I don't care about bark. I care about bite. When misconduct has been done, there needs to be bite. There needs to be consequences, especially when this has been the only thing consequent in this trial so far, in this case so far, is the prosecution actively avoiding to give anything to the defense. Yeah.
This is a bit overdoing it as far as letting them get away with it. I understand you want it to go to the jury, but at certain point, if it goes to the jury mangled, that's not justice.
Yeah, and I'm looking for the fairness in all of this. And I mean, and as consequences, where are the consequences? Because if you, I mean, he's presenting it good to the jury, the instructions and everything. He's handling himself well. He is shouting at the prosecution. But if there aren't any consequences, they will keep doing this because they know that all they need to do is to ride out the storm, correct the mistakes, and then they're on again.
Pretty much.
Yeah. Yeah. Fanny has devoted her entire felony trial team to 2 cases, this and Trump. Yeah. And when this thing started, the Trump thing, she only promised, but now that's going. She's moving forward with that too. I assume that's why she's not in court today during opening statements, because she has something to do with the Trump RICO trial. And I said it yesterday, and I said it earlier today. This is what you will see when this goes to the Trump trial. This is the kind of things you see, because she's the district attorney. She's running the show. These people are doing things as she orders them to do.
I'm just smiling, thinking if she's going to also use the Jungle Book to quote first.
Yeah. Yeah, former ADA Rosenwasser is over in Gwyneth laughing her ass off. But DA Fanny, she took over this case. So she wasn't the original indictee to bring this forward. I think she's number 3 on this, in just since they started this in 2021. So she has used that as an excuse a lot of times in the pre-trial motions that, well, she was given this. Yeah, but seriously.
Peace, Peony. I hope she does move on to Ricky Tikki Tavi. I would love that to be the opening statement for Trump. Who's going to be the mongoose and who's going to be the cobra? I am willing to bet that will be hilarious.
Yeah. Yeah, I mean, for you who have followed me during this, there were 28 defendants to begin with. And then they started to plead out after about 6 months. But 5 of the defendants didn't have attorneys for over a year. They couldn't even have a bond hearing because they didn't have representation. Because there weren't enough defense lawyers in the state of Georgia or in Fulton County that were willing to take on the case. And the reason for that? Well, the county offered $7,500 as compensation for the entirety of the case. They had issues, so the lump sum went up to $15,000, which is a nice chunk of change. But for a trial that is at least 6 months, where the pre-trials have been hearings have been going on for over a year, that's not much. People, I mean, lawyers will go bankrupt. I remember the leading attorney, or the lead attorney, the YouTube channel, he is Georgia-based. He apparently spoke to one of the lawyers, defense lawyers in this, and more or less, you might have to start an OnlyFans page to not go bankrupt, because this case is bankrupting defense lawyers and defendants. Yeah, defense counsel is going to be hitting the food bank at lunch with that wage. Yeah, I mean, we are talking about $15,000. Say the trial takes, just say 10 months. So it makes math easier. That's $1,500 a month as a lawyer. I mean, that's below minimum wage at McDonald's in Georgia. And yeah. Now, what shall we do during this break? Sound is on. I can try to find the lawyer who had the Second Amendment, so we can have a history lesson about the Second Amendment. Hold on here.
I like the short, angry lawyer. He's my right kind of pissed off. And with Napoleon coming out, you know, he's historically relevant.
Let's see here if I can find it. Wonder which one it is. I'll check that one. I'm looking for that specific lawyer. That's why I'm taking a bit of time here. Not him. You're more than welcome to grift yourself, Mo.
Okay, so tonight we have, I probably will not be doing Newsy News Nooner, since we didn't expect for them to have a lunch break because of, well, I'm going to go ahead and say stay effed around and found out. That's my professional view on it, but we will have nightly Newsy News with a special guest host, Donna Adelson, Granny Satan. She has a bone to pick with the state of Florida, who may or may not be trying to take away her precious, precious Charlie's, dental license. It is a terrible tragedy. It is a crime, and she has a bone to pick. So, live from Tallahassee jail, where she's also upset about being, she may be reading some news stories for us. We'll be introducing new characters along this week. Sarah Boone might show up to read us some letters. It's all the things. What have you missed? Well, Farrell, we got about 5 minutes into the opening statement. We read some Jungle Book, and then the state started showing, slides that sardonisms. It's a joke. I'm playing a character. It's not the real Donna Adelson. She is my quote unquote, Tallahassee associate or affiliate. But yeah, apparently the state was ordered to hand over all of their slides to let the defense know and make sure they were checked for errors. And she did not one of that. So 973 of the defense attorneys stood up and said, hold up. And
I wanted to pop in real quick and say I got some information on the Harvey rule.
Oh,
woo!
I went over to the lead attorney that I know practices in Georgia. So I asked him what the Harvey rule was, and he says that there's an attorney, a defense attorney, who's like the biggest defense attorney in the area, named Bruce. I think it's Bruce Harvey. And so he thinks it's a colloquial term, like it just means that when he objects to something, that it applies to all the defendants. Or when a defense attorney objects, we can just assume that all the defense attorneys are raising the same objection. But it's not like a standard rule. I couldn't find it anywhere. And so it's not like a legal thing. It's literally this attorney has this kind of rule because he's just so well known or whatever. And he's one of, the dozens of attorneys that are there. So, so that's the info that I got from a man in the know from that county.
Yeah. So for simplicity, they all call it the Harvey rule, that if one objects, all objects.
Yep. Yeah. But it sounds like it's named after one of the defense attorneys. It's not like a statewide or nationwide rule, because I had never heard of it. So that's the info I got. Hello, Farrell.
Now, I found the 30-minute history lesson on the Second Amendment in a previous hearing that we can listen to while we wait for the court to resume.
Cool. And I'm just going to jump off again because I got work, but I wanted to let you guys know what I found out.
Oh, awesome.
Okay, see you guys.
See you. Okay, let's find... that one. There. So we have Jingles in a Viking helmet and a suit over the... Yeah, and this guy should be aware of Second Amendment statutes from 1792 because he was there.
It's not his fault. He wrote them.
We have just heard a long list of what the state has tendered to the court in support of what they now believe to be their burden, which I believe I have always said it was their burden. And that burden is enlightened by the court in Bruin as follows. The scope, and this is what I argued yesterday, the scope of the protection applicable to the federal government and states is pegged to the public understanding of the right when the Bill of Rights was adopted in 1791. The Bruin Court specifies, and I will give you the exact quotes when I get to the particular parts of the proffer, Judge, with regard to pre-1791 authority and post-1791 authority. The first item on the state's response, thank you, is a citation to a case in 2008 before the Supreme Court said that the Second Amendment confers an individual right on people to keep and bear arms. That was in Heller, which is a 2011 Supreme Court case. So for whatever relevance that case may have, I don't think it has any relevance to pre-Heller construing the Second Amendment as a personal right. I'm drinking smart water. I'm getting smarter as I go along. I hope. That's for the record. That's for the record. Yeah. Second, it appears to me that that is a 2009 law review journal. You can take a law review journal for whatever value it might have, but it certainly isn't a specific.
I need to change into civilian clothes.
Historical analog to
I'll be right back. I already heard this.
Okie dokie.
C, firearms in American history, 1910. I wasn't pointed to any particular portion of that, and I don't know particularly what relevance that may have. Same thing with D, Poe versus Ullman, 367 U.S. 497, 1961. With regard to the pre-Heller relevance, I don't particularly see that. So I'm objecting so far to the first four, A, B, C, D. Now, we get to E. And Exhibit E is denominated on the list as Ancient Laws and Institutes of England. That's a one-page exhibit. On that one-page exhibit, I see, without any pages before, without any pages afterwards, a quote that says, "If a man furnish weapons to another where there is strife, though no evil be done, let him make," I don't know, let him make bot with, and that's not bots, but bot, with a number of shillings. So we've got an undated law, apparently of England. I don't even know where it comes from. I don't know what date. I don't know what anything with regard to that. And it certainly is not a prohibition on the ownership of weapons. The Supreme Court said, and I said I'd go with each one of these. As far as English history is concerned, the court in Bruin said, English history is ambiguous at best. And the Bruin court saw, quote, little reason to think that the framers would have thought it applicable to the New World, unquote. That's Bruin at 2139.
I am not sure whose attorney this is.
To E. The journals of the Continental Congress, you know, all this stuff sounds great, but when you read it, it doesn't, it simply is inapplicable. I guess I'm on F. Journals of the Constitutional Congress, 1776 at 205. Well, what they said was, that it be recommended to the several assemblies, conventions, and councils or committees of safety in the United Colonies. And Georgia had a committee of safety. This was a recommendation that they were going to give to the committees of safety to immediately cause all persons to be disarmed within their respective colonies who are notoriously disaffected to the cause of America, or who have not associated and shall refuse to associate to defend by arms these united colonies against the hostile attempts of the British. So that's an oath. That's a recommendation to prohibit those people who don't support and are enemies of the United States of America to disarm those people. Certainly not a historical analogy to our statute. So I would object to F as well. G.
They're not for puppies.
G. Now we're getting into the acts of 1776 in Massachusetts. 1776 happens to be, if I recall, Paul Revere's ride, right in the middle of the American Revolution. And what that says is an act for the executing in the colony of Massachusetts Bay in New England, recommending the disarming of such persons as are notoriously disaffected to the cause of America, or who refuse to associate to defend by arms the United American Colonies. Same thing as in F. In other words, it's those who refuse to take an oath of loyalty to the United States. Has nothing to do with the disenfranchisement of felons. Exhibit H, the statutes at large of Pennsylvania from 1682 to 1801, same thing. Recommending upon the Honorable Continental Congress recommended to us that we cause all persons to be disarmed who are notoriously disaffected to the cause of America, who have not associated and refused to associate, etc. In other words, exactly the same thing, disarming those who refuse to take the oath to protect America in the Revolutionary War.
I mean, this is amazing. What a history lesson.
So the next is the state records of North Carolina from 1905. That's a 35-page document. The print is smaller than my bank account. I have absolutely no idea where in the 35 pages of supremely small print there is anything related to disarming any individuals. And I haven't been pointed to anything in that particular exhibit that shows anything with regard to disarming felons. So I'm objecting to that. J, again, May 1777, another oath who will not bear the not give oath to the allegiance to same and for other purposes. All freeborn male inhabitants above the age of 16
Has he
years,
said the
except
N-word yet?
imported servants during the time of their
No, but
service
I did.
shall, on
I
or
guess
before the
spoiler
10th of
alert.
October,
That's coming.
subscribe the following oath.
Yeah, because
And if they
apparently
don't take the oath,
in the
they
statutes
get
he's reading
disarmed.
from, in one of them,
So that's
might
another
be
oath
inappropriate language
session.
of today.
or statute. K, same thing, another oath statute. So far, we haven't had a single, not a single. We're going to disarm felons. We're going to disarm permanently those who may be convicted of felons. So far, absolutely nothing. I see nothing in any of those. So that's J and K. L, there was a law review article from 1983. M is a law review article from 1983.
Jingles is
N
home.
is a law review article from 2009. O is a law review article, it looks to me, from
He's arguing Second Amendment to get
2013.
all the gun charges
So I
off
object to
the
L, M, N, and you
get all
can
the
consider
gun
whatever law
charges
review
is,
articles
charged.
you want to consider, but they certainly aren't historical analogs, and I've gotten nothing so far by way of the record of any particular statutes from anywhere in the United States. P is the debates of the several state conventions on the adoption of the federal constitution. Well, that's all good and well. I don't know what that has to do with anything, so I would object to that. Q, I'm sorry?
Could you clarify what your objection is?
Yes, my objection is that it is not an historical statute. It is not a statute anywhere. It is also something that may or may not have been adopted by any particular state, and certainly not been shown to be adopted in the state of Georgia. I am not abandoning a dual track. I've seen nothing particularly related to Georgia, and I see nothing in this particular article that may or may not. And I haven't had a chance to read all these articles because these today at 12 o'clock.
There was
over my objection.
They were cited in the state's brief file.
That's great, over my objection. You didn't tender them yesterday. We had a hearing yesterday. They weren't tendered yesterday. I object to them being tendered today.
That was his emotional outburst. And for a man, age 201, that's impressive.
Is a pre-Bruin opinion. Quoting another pre-Bruin opinion.
To clarify, is there an objection to Q?
Yes, there's an objection to Q, there's an objection to R. Now, let's get to S.
What was the objection to Q? I'm not clear.
Well, if you're not clear, I'm sorry. So I'm at S. We kind of blew through S. S is an 1804 Mississippi law.
1804 Mississippi
And
law.
that law says,
Okay.
no slave shall keep or carry any gun, powder, shot, club, or other weapon whatsoever, offensive or defensive. And I can tell you what's offensive to me is that the state is tendering this statute as a historical analog to the prohibition against felon disenfranchisement in 2023.
Well, it's true that the first form of gun control was to
And
keep
for the record,
firearms out
the
of
14th
freed slave
Amendment, I think,
arms.
renders explicitly racist laws in slave codes irrelevant to the Bruin analysis. Bruin does not even consider the many explicitly racist laws of the 18th and 19th centuries. A ban on restricted groups cannot be an historical tradition.
Yeah, I agree. Had this been from any other, from an actual debate about gun laws, this would have been an amazing argument. But this is a RICO trial. But just listening to it, I want to hear him argue this in a debate or something where he's given half an hour and his opponent giving half an hour, something like that. This would have been an amazing argument for the Second Amendment.
Yes.
Yeah.
But here, the Reagan, administration did happen.
Yeah.
So,
I mean, he was old and gray back then as well, I guess. Because he seems. I mean, I love when stuff like this happens in trials, complete out of the left or the right or whatever. But I just.
Let's go with, so that is beyond objectionable. Let's go
beyond
with
objectionable.
1804.
1804.
Indiana Acts. A law entitled A Law Respecting Slaves. Be it further enacted that no slave or mulatto whatsoever shall keep or carry any gun, powder, shot, club, or other weapon whatsoever, offensive or defensive. Again, if the state thinks they're going to rely on that as a historical analog to the current 1980 Georgia felon disenfranchisement law, then I think it's barred by the 14th Amendment. I think it's barred by common decency.
No. Get your baby.
Let's go to you. 1806 in Maryland. And here's what the title of that statute in 1804 from Maryland that the state is tendering to the court. An act to restrain the evil practices arising from Negroes keeping dogs and to prohibit them from.
Well, I mean, you have to title it something and you want it to be flashy. It's what we all do as YouTubers. I mean,
yeah, and YouTube, this is him reading from law statutes. I'm not condoning that kind of language. This channel is for trials and law and evidence and amusement and stuff. Please don't eat me.
Yeah, it's not our fault. We had no idea he was going to use any language or history.
From carrying guns or offensive weapons. That's what the state is tendering to you.
I am still green.
In Kentucky. Let me just say this.
I agree, Matt.
1851.
That term was very neutral at the time.
It's 58 years after 1791.
And he's arguing it against
the court
a black
ruling
judge.
Specifically said if a law was adopted long after the founding, it cannot be afforded much weight. Heller said that at 554 U.S. at 634, 635. Bruin at 142 Supreme Court at 2316 cautioned against, quote, giving post-enactment history more weight than it can rightly bear. Even if it's relevant, it's adopted too long after 1791, which is the relevant date. So Exhibit V, 1851 Kentucky Act of dealing with slaves and suffering them to go at large. If any Negro shall keep or carry a gun or other deadly weapon, powder, or shot, the same may be seized by any free white person.
Okay, but sir, Reagan did exist. I mean, this is
Yeah.
all very
I
well and
object.
good, but it's called abrogation. It works in the Quran and it works in American law.
Yeah, I mean, when normally I've seen this on other channels when they talk about history, there maybe at 1986 they did not, but as for now, 1986 is history. So yeah, I mean during the Reagan administration, not Reagan himself.
Okay. Well,
Mm.
I misspoke. The Reagan administration.
Mm.
But it's a concept that works both in the Quran and American law.
Yeah.
You can all these things being true.
Mm. Yeah. I need to get me some more nicotine pouches. I'll be right back. But hey, we're having a
Well,
good history
yes.
lesson about the Second
Bruin
Amendment.
should trump this, and old man Rat Tail is right, but perhaps he should have gone on with Bruin and said Bruin trumps Reagan's administration, and maybe left out the old, slave trade talk. Just saying. I mean, I love the history lesson. I am a big history buff, but
He could have this statute from this year mentioned this with slavery. He doesn't have to read every word in the statute, maybe. But here we are.
if you wanted to go also with historical context, you could say that most of the gun control that was first placed in America was historically racist. I mean, we could put that out there.
Yeah. And there could be an argument held that gun laws today is misogyny. Because if you want to defend yourself, according to general population thoughts and stuff, the people who needs most defending are women.
Yes.
So not only I heard this in a debate not that long ago that they were arguing. It was some high-level politician who had bodyguards was arguing for gun laws, and he was asked, "But your private bodyguards are armed with guns. You want to ban my family from having to defend themselves?" And that was quite interesting. But
It's
I need to get
definitely elitist. But yes, continue. Let Sir Rat Tail go with the questionable tie. Dave must analyze this tie.
And that was what? V? W. 1861. North Carolina sessions, and again, I'm relying on Bruins and Heller specifically saying if it's too far past the founding, it's to be given little weight. But again, the state's tendering it to you to meet their quote burden. 1861, North Carolina Session Law 88, relating to free Negroes having arms. If any free Negro shall wear or carry about his person or keep in his house any shotgun, musket, rifle, pistol, sword, etc., he shall be guilty of a misdemeanor, and upon conviction, fine not less than $50. That can't be a historical analog to a felon disenfranchisement law. Next, 1863 Delaware law. This is Exhibit X. And by the way, I'm objecting, obviously, to all of these. 1863 Delaware laws enact in relation to free Negroes and mulattoes that free Negroes and free mulattoes are prohibited from owning or having in their possession a gun, pistol, sword, etc., etc.
What about dynamite? It never says dynamite.
Yeah, he says etc., etc., because he doesn't want to mention all the guns. But the other words, yeah. I'll check if I'm still green. Hold on a second.
Well,
yep, still green. I have no idea why. But I assume that will be changed as soon as this stream is over in about Jesus Christ, 5 hours. that might have changed.
AI is going to say,
Hi, Kim,
no.
welcome. We are. It's lunch in the trial, so we are listening to this man, age 217, arguing Second Amendment gun laws are
He's
bad.
quite old to be a Padawan. I mean, still. I feel bad for him.
Yeah. So while we wait, this is a history lesson about the Second Amendment. Treat it like that. Words will be said, and he says them, all of them, over and over again.
So here's the state's proffer of laws that are historical analogs. The next is 1863. That is, well, I'm sorry. Maybe I missed something.
You maybe missed some.
Yeah, were there more about, were there certain terms you missed?
1863 Delaware law.
I'm sure there are words about Latino folks in there as well.
Yes.
While we are,
I begin with S through X. I just put those in to avoid the accusation that I'm cherry picking. I'm presenting the history, warts and all.
Okay, well, there are plenty of warts. There are more warts than anything else. Y was 1878 New Hampshire law, Exhibit Y. That's 87 years after the 1791 adoption
he can do math.
of the
He just calculated from his date of birth and forward.
Prohibits
he was like,
tramp.
I saw the first car. It was amazing.
A weapon. Any person going about from place to place begging and asking or subsisting upon charity shall be taken and deemed to be a tramp and shall be punished by imprisonment and hard labor for not more than 15 months. And a tramp with a gun gets up to 2 years in jail, but doesn't get disenfranchised.
Any tramps with guns out there, y'all need to stop.
Is in 1879.
You will be disenfranchised
after
tramps with guns. I think that's all that banned.
And that's the same statute as
tramps ruin it for everyone.
As Y. It is a statute that is an 1879 statute saying the exact same kind of thing, that it's a
Listen, Albert,
misdemeanor
if you want it
to
thrown,
have,
you have to let it go.
to be a tramp with a gun. But no
Just keep
disenfranchisement
saying the word.
and frankly, no seizure of the gun. And let me see.
But Mr. Harvey, if I may, in Bruin, doesn't it say that?
Hey, look, I'm not answering your questions.
Oh, wait.
Good. You shouldn't have an opportunity to go again.
Mr. Harvey, we're not gonna have any of that. You can look at me all cockeyed if you want, but we're not gonna have that.
Well, I didn't start it.
But you were starting to finish it, and that's what
I was.
That's what being professional is all about.
All right, that's fine. I won't finish it. I'll finish it with the continuing reference to their proffer.
We need to finish Tramp Talk. Tramp Talk 2023.
Let's see, AA. Annotated statutes of Wisconsin containing a general law being enforced in 1889, which is obviously well after 1791. And that statute is again a vagrant or tramp statute. And the penalty for a vagrant or a tramp or someone who is drunk and has a gun is imprisonment in the county jail at hard labor not exceeding 3 months, or by imprisonment in such jail in solitary confinement for not exceeding 10 days. So I object to that one. State versus Hogan, a 1900 case from Ohio. I must have missed it, but
only 100 years ago now.
I didn't see state, the Georgia case that we all rely on and that the Supreme Court quoted with approval in Heller. That's Nunn versus the state. I also didn't see and haven't seen yet, and we're up to the 1900s now, anything that the state proffered from the state of Georgia in particular, that any state statute that disenfranchised someone who got convicted of a felony. So I object to the relevance of BB, State versus Hogan.
I promised girlfriend that if I ever lose the hair up here, the rest goes, because even I have a limit. I mean, I can wear a hat, but no, I mean, and if I'm looking at my dad, and he hasn't lost everything up here, so I'm good, I think. But having that, I mean, yeah. Yeah. What were you about to say?
No, those 4 hairs up front are valiantly hanging on.
Bald Nick. Well, at one point in time, I had that giant beard and shaved head. But I prefer this before that, because then I have to shave the head every 2 days.
CC is an 1897 statute from Kansas And CC is in 1897, which, again, I want to say that under Bruin, once again, at 142 Supreme Court pinpoint at 2316, cautions against giving post-enactment.
Hi, Bass. Welcome. No, he's not rebutting laws. He is. These are laws that were rebutted already because they were deemed unconstitutional, which raise laws and laws against tramps, apparently. And he's arguing that gun laws imposed from 1986 going forward are unconstitutional through a historic perspective. That's what he is arguing before this court in a RICO trial. Which is, I mean, he's doing, if this was a Second Amendment argument before the Supreme Court, for example, excellent.
Yes.
In this, maybe not, but it's a good history lesson.
Yeah, it's just.
You don't have to use all the words in the statutes, maybe.
Well, are these statutes that the state is putting forward as legal precedents for them charging his client for being a felon in possession?
Yeah, he is arguing that the current laws against gun control are unconstitutional through a historic perspective. That's why he wants the charges for possession of firearms thrown out. So that's his aim.
All right. It's a bold strategy. I don't know that that's going to work.
Yeah, but since the charges are separate, he might try to appeal those upwards. You never know.
Yeah.
But that would mean he would face the appellate court, local appellate court, the local Supreme Court, then federal court, and then Supreme SCOTUS. And by then he would be around 302. And yeah.
Yeah, I don't know if elves live that long.
Old line read. It sounds to me like state used all these 1800 laws to say they meet the historical element to meet Bruin. Unfortunately, they are all widely racist laws. Okay, I'm not American. And trampy, yeah. And I'm not American, but I enjoy the history lesson here. With the exception of the few words that he didn't have to express them all the letters. Maybe. But here we are.
Weight that it can rightly bear. This is many years after the 1791 enactment, and this prohibits carrying a deadly weapon. Any person who is not engaged in any legitimate business, or any person under the influence of intoxicating drink, and any person who has ever borne arms against the government of the United States,
I'm yellow,
who shall be found within the limits of Kansas, carrying a pistol, bowie knife, dirk, or other deadly weapon,
I am shocked.
Shall be subject to arrest upon a charge of a misdemeanor, fined $100 or 3 months in jail, or both. Again, I object to that as being even remotely relevant as a historical analog. DD is an 1897, well, maybe it's not 18, let's see, DD. It's another Kansas statute. I don't know why I have 1897, but I'll take the state at its date. 1883 is what they have on DD. But that prohibits any person who sells, trades, gives, loans, or otherwise furnishes a pistol to any person of notoriously unsound mind. And the penalty for that, giving anything like that to a person of notoriously unsound mind, was a misdemeanor. I don't think that qualifies, and I object to that as a historical analog. Now we're into the 1920s. We're well over 100 years past the 1791 adoption of the Second Amendment. I guess by my limited ability to add and subtract the 1923 New Hampshire laws, that's 132 years after the adoption of the Second Amendment. And it specifies in 1923, way beyond the period that Bruin says is relevant. I believe that it says that no unnaturalized foreign-born person and no person who has been convicted of a felony against the person or property of another shall own or have in his possession a pistol or revolver. God bless you. A pistol or revolver. A violation of the section shall be punished by imprisonment for not more than 2 years, and upon conviction, the pistol or revolver shall be confiscated. Now that may be the first that I've seen that the court might deem to be relevant to this inquiry. I say it's not based upon the exact wording of Bruin. However, it is in fact, in 1923, 132 years after 1791, something that doesn't disenfranchise a felon, but what it does is, and of course, there is a difference between confiscation and future prohibition. So I will concede that may have some relevance to Your Honor, and that is EE, the 1923 New Hampshire statute. There's a 1923, again, 132 years later, FF. That is an enhancement.
Did you say F off or F
for possessing a weapon while committing a crime unarmed.
Foxtrot.
And also includes unnaturalized foreign-born
he has said every other word.
convicted of a felony. It doesn't
You would think
disenfranchise
so.
or allow for confiscation of a felony, so of the gun. So I'm objecting to FF.
Okay, hello, it's happening with Hopper, and welcome. Well, we started off today with a juror being late, apparently car problem, so everything started an hour and a half late. Then the state got 10 minutes into their opening statement, and the first objection came in for burden shifting, which was sustained. And then it was another objection because argumentative, which was also sustained. And then she started to showing slides for the jury. And then all hell broke loose. And because she was ordered by the court last week, the prosecution, to share all the slides she was planning to use during the opening statements with the defense, so they could either object to it in a timely manner or, well, stuff like that. And she didn't. She started showing pictures and stuff that was never shared with the defense. So they had a call for mistrial because this was shown to the jury. stuff that may or may not have been, should have been excluded by a prior order. And then, stuff happened, argument happened, judge got mad, but it seems like the trial will continue after lunch. And we will, I am having that. It hasn't started yet. That's why we are listening to this guy from a previous pre-trial hearing arguing the Second Amendment, why the court should exclude all gun charges because he deems them unconstitutional. So that is what we're doing now. Fun times. We are doing this while we wait for the court to come back from recess.
19 GG is the 1923 California law, again, 132 years after 1791. And again, it's a sentencing enhancement for someone committing a crime when armed, and it provides for confiscation of the arm, but not prohibition from future owning an arm. And again, it's not a felon disenfranchisement law. Number, let's see, HH. HH is a prohibition, 1925, 130.
The Tesla strike in Sweden, I'm waiting for some information, but it will be a video maybe next week. But as for now, I am waiting for, I'm doing this trial, which will take up most of my time, but I will address the Tesla situation in Sweden as well. Thank you for your super chat. A Norwegian 50 krona, which is around $4. Thank you so much.
Woo!
Go through. We need Mr. Jingles. He is currently asleep. And I don't want to wake him up because I have survival instinct.
Yes.
For you who don't know, Jingles is the cat that is portrayed over the Law and Seaward logo, dressed in that's an AI thing with him in a Viking helmet and a suit. But yeah, that's the way he looks, and that's his temperament. He is active. He is barely waiting for me to pass on before he starts eating me.
4 years after 1791. It prohibits felons from possessing a pistol, a revolver, or a firearm capable of being concealed, but doesn't prohibit the possession of long guns or guns. There is not a prohibition on owning guns, just on certain types of firearms. So I don't think that's certainly not a historical analog. IIJJKK. I think both of those three do prohibit felons in possession. You can take those for what the court might think they are worth, but they're 1931, 1933, and again 1931. So you can take those into consideration. Again, I think they carry zero weight under Bruin, but the felon disenfranchisement, they're felon prohibitions on possession of weapons. There's no showing by the state that they are permanent disenfranchments as opposed to confiscations. LL, the 1927 Rhode Island public law is not a felon in possession law, and I would object to it. A 1980, MM is a 1986 law review article. I don't see the relevance of that. I don't see the relevance of NN. I don't see the relevance of OO. I don't see the relevance of PP. I don't see the relevance of QQ.
You don't see the relevance of PP.
It's not an R. Kelly trial. We don't need it.
Yeah, we don't need it. I mean, that's like, I mean, hotels doesn't have a 13th floor, and police lawyers do not have evidence named PP. Just for notice, if you haven't grown up before 50, you don't have to. Just saying. That's the general rule.
Yes. All of which were written before Heller determined for the first time that there was an individual Second Amendment right to bear arms.
Flux!
88, I mean, RR, SS, TT, UU, VV, UU are all pre-Heller cases. VV is the only post-Heller case that I see cited, and that is a pre-Bruin case, almost a decade before Bruin. And there's one citation here, one little citation to a case from the Northern District of Illinois from this year. For what value that may have, the court can consider that. So those are my objections to the state's proffer. And of course, and I'm sorry, I had objected to the court allowing the proffer because yesterday, I believe, was the time that the state had to meet its burden. Again, I have seen or heard, and the state has not proffered a single, not an iota, not a scintilla of evidence regarding any felon disenfranchisement laws in the state of Georgia, or any statutes or constitutional provisions from the state of Georgia. I think that's where we are. So I objected to allowing the state to put these in, although I think, frankly, it helps me. Now, they had their shot. You graciously allowed them to present this massive materials, which I scrambled to look at over lunch. And again, remember, it's not my burden. So the state has had an opportunity now to put into the record whatever they wanted to. I've made my objections. I think the record is ready for Your Honor to rule without any further argument.
Well, let's see if the judge or the prosecution chooses to answer. Well, the judge has to, but.
So, Judge, that's all I have. All right.
Your Honor, just so the record's clear.
He looks shell-shocked.
The judge is like, what?
Yeah, I mean...
Where are...
I assume they have read this in law school, but I'm quite confident he haven't heard it since.
Very possible.
I am proud of your parties arguments on behalf of Mr. Still.
It'll apply to everybody unless you opt out.
One thing, one final quote. Yeah, I know. And it's a good one. This is a good one. On February 7th, 1867, Frederick Douglass gave a famous speech in which he said, "Keep no man from the ballot box or jury box or the cartridge box." I'm leaving that with you.
Yeah, that was the defense Second Amendment defense, where they say that the state does not have the right to bring gun charges towards the defendants because of this and that. And we heard a lot of words that haven't been used for some years.
Yeah. I mean,
from a history lesson point of view, that I mean, it's good to hear it. I know Dave thought it was a bad argument, but as a history lesson, I enjoyed it, with some exceptions for certain words.
yes.
Yeah, we're still waiting for the trial to commence after lunch. I have no idea. Yeah, Gigi says, obviously the state was using these laws or he wouldn't be objecting to each one individually. Yeah,
Yeah, it does seem like an odd. It does seem odd that the state would bring these up as
defense for the current laws as from a history point of view. Yeah.
Yeah, I'm not thinking those would be the ones they would want to bring up, but I can understand that those have historical precedents and
yeah
of sorts.
I see his point here. Why do you use these laws and old statutes that are obviously racist and obviously misogynist as defense? But laws have been written about gun control since 1986 and prior to that, and I assume that's for the legislators or for the Supreme Court to judge on, and apparently they have on a few occasions, but I'm not remotely close to arguing before or against Second Amendment details. But the only thing I can say is I've read the Second Amendment, and in my absolute layman opinion, if you want gun control, you have to change the Second Amendment. But if you try, you are going to have a new civil war. That's my opinion. Now, if it's correct or not up to me. But still waiting for... let's hear what the judge has to say.
The judge is probably like, what in the hell did I just... Young Padawan, how much did you smoke before you came in here? Let's start with that.
All right, anything else, Mr. Yossi?
I have 30 seconds.
You may.
All right, Mr. Harvey went into great detail about how all these statutes that I provided are hundreds of years out of time. Instead, what I would draw your Honor's attention to is Bruin at 2119, which says, and I'm going to quote, "Constitutional rights are enshrined with the scope they were understood to have when the people adopted them. The Second Amendment, 1791. The 14th, 1868. Historical evidence that long predates or postdates either time may not illuminate the scope of the right." Just to make that
I'm
clear.
agreeing again.
Now, Mr. Harvey's also talked about how I haven't provided any Georgia statutes that prohibit felons from firearms. I don't need to. It's about whether the current Georgia statute is consistent with the nation's historical traditions, whether it's an oath, whether it's a legislature, whether it's convention, talking about what they want to have in the Bill of Rights. We're looking at the national history. I don't have to have a historical twin. I just need a historical analog. And from the briefing, I'll just reiterate, there is at least one. You go back to AD 602, and from there, it's enemies of the state, okay? And then it's violent persons, dangerous persons, and then criminals. And then you start getting into the late 19th century and into the 1900s. They start calling it, by felonies. So I think we have more than enough as far as a historical analog, and I do appreciate the court's indulgence, allowing me to have some extra time to get this together. And
One thing that would be amazingly fun was to hear him defend the language in the statute that apparently the state had brought forward.
Yes.
That would be interesting. But I don't think that will happen.
Well, no, but it would be funny.
Yeah.
And I'm all for funny. I'm all
Yeah.
for funny. If this is a dumpster fire on top of a nuclear volcano right next to Chernobyl. So let's just lean into it at this point.
Yeah. Yes, what the prosecution is saying, that his argument is, yes, gun control is lawful law.
Dang it.
And I would move to admit these for the court's consideration. Thank you.
All right. Thank you, sir.
This is, oh, by the way, this is 6.5 hours in on a full day of hearings. And he has an hour and a half to go before he can go home with his support dog. And yeah.
Oh, I'd be done.
Mm-hmm.
You would not want to deal with me as whatever.
Let's skip ahead until he starts to talk.
All right. To begin with, I am going to admit over Mr. Harvey's objection, the state's index of exhibits and state's response to opposition to Cornelius Nichols, Shannon Stillwell,
The court report.
Monty Kendrick and others, and to all persons is set forth in this indictment, 22 SC 183-572. The court, after hearing arguments of counsel and after considering the state's exhibits 1 through WW for consideration and submission for the record, as well as defendants 1.
No. I'm looking at the cases I follow. I have maybe 3 or 4 I know I actively, and then I have maybe a dozen on the side that may or may not, depending on the cases I follow. If they, trial, just 3 days, okay, then I wonder what this is. When I started following this Young Thug RICO, it was because I have never dealt with anything like the RICO Act, and I was interested. And I thought, well, and it was a slow week, So I thought, well, let's check the Daubert hearings. And here we are.
Yeah, it's kind of how
Mm.
that goes.
Yeah. And I think week 2 of me covering this was the first time they said it was going to be a 6-month trial. That was when oh, fuck. I didn't realize that.
Yeah, we kind of didn't realize how much it was going to be.
Yeah, but here we are, and I've been doing 4 or 5 months of coverage of this trial, jury selections, shenanigans, motions hearings, Daubert hearings, and I'm not surprised that the first day of trial would become a complete cluster F. Oh, we have 5 hours. It would become a complete clusterfuck. I'm not surprised. I'm a bit surprised the level of it. Yeah.
I'm shocked that the prosecution decided to just not send anything over. I'm surprised. I am surprised at the just utter lack of, well, I'm going to do what I want.
Yeah. And this judge have a lot of orders in place, which, in my opinion, the state has violated time and time again. Because as we will see after lunch, that there will definitely not be a mistrial. The state will have an opportunity to correct themselves, which they are doing now during lunch, because the slides for their opening statements contained factual errors. Pure factual errors. And since they didn't send it to the defense last week, as the judge ordered them to, here we are. I mean, the state was maybe, well, I don't even think they were an hour into their opening statements before hell broke loose. And they have, as we heard, at least 53 slides planned for their opening statement.
They indeed do, because they want to hurt us.
Yeah.
with this.
And I assume that this opening statement from the state would take all day. They are definitely going into a big chunk of tomorrow if this continues, or next week. We might be done with opening statements before Christmas break, before the holidays, maybe.
Because you have 8 different defense attorneys who are objecting to different things. You have 8 different clients who are being represented, or 8, right?
6.
6. Sorry.
6. Yeah. And we don't know if they choose to have just one opening statement or if all 6 are doing because they represent their client, not the other 5. Their client and their client alone. So we might see 6 defense opening statements.
We'll see you in 20 years when this trial wraps up.
Yeah, again, I don't mind side conversations, but please come back to what we are actually watching. I mean, on Friday or Thursday, that had an interesting discussion about pie recipes. And I don't mind that as long as the chat moves forward and comes back to what we are actually doing. But if it's an hour of sidetracks, yeah, I will probably set my foot down. But I don't mind sidetrack between a couple of people who just want to discuss other things while they are listening. Well, can't afford to lose viewers or members. Well, yes and no. It's my channel and I run it as I see fit. Yes, it's amazing that there is so many of you here and over at Rumble. I appreciate greatly. And since YouTube has started with forcing me to show ads on my streams, but that's like pennies to the dollar. I mean, that's a calculating error. If I get any things from the ads, especially if YouTube says I'm in the yellow, because then they will run ads and I don't get paid.
Ugh, those giant buttholes.
Yeah. Let's see if we are getting close. No, nothing yet on the actual trial stream.
That
We
is
should-
weird. I thought they were going to be there 20 minutes late, aren't
Yeah, but
we're on the same.
this judge is infamous for running everything late.
Oh,
But,
wonderful.
Yeah, I mean, during the pre-trial hearings, we are taking a 15-minute break, and then an hour and a half later, oh, we're back.
Well, that's
I
good.
see that Law and Seaward are having a stream up, but they are having just an interview, so they are not back yet. And so did the Atlanta News First, also had an interview, and now everybody's just waiting for the trial to continue. Yeah, you can watch here or on Rumble, and if you have a Rumble account, please follow me on Rumble. I have currently close to, at least at the beginning of this, I had 195 followers there, and I have to check. Hold on. Dun, dun, dun. I am still at 195 followers, so if you have a Rumble account, I would not mind you going over there and follow me. So in case YouTube decides to put a foot in my arse and yeet me the F out of here, then I have a platform over at Rumble to begin with. And thank you so much, Peace Peony, for gifting a membership. Yay! And it came to Dave Umbarger, who rejoined as a member. Thank you so much, Peace Peony. Yes, memberships on YouTube, $3 a month. And for that, you get members-only content. You get access to my Discord. And according to my chat and my members, I produce the most members-only content on LawTube. So you get your money's worth on a weekly basis. Oh, that should have been oh, I forgot. This should have been grifting time. Yes, memberships $3 a month. Memberships is what keeps this channel afloat. I do have costs regarding the channel. I mean, the StreamYards, the art list, the licenses I have to pay, and everything around it. And so thank you so much for you who are members and keep being members, because you keep me afloat. The occasional super chat, that is what gets me to improve my channel. Now, it got me better sound, or better microphone at least. I bought a new computer. So my old 8-year-old gaming rig is out the door now. And currently I have ordered better lighting, and the next step will be a better camera. And in the spring I will purchase what do you call it? One of these caravans that you see construction workers changing in, and I'm going to remodel it into a studio so I can get out of the house while doing this. So so every penny that goes into the channel goes towards improving the channel. And way down the line, if I'm starting to get, I mean, I'm currently just over 3,000 subscribers, which I'm eternally grateful for. If I go to 10, 20, 50 and upwards, now then we might, years into the future, I might start to pay myself as well for my time here. So yes, I will get a role in studio. Yeah, that was the end of. Yeah, okay.
I like it.
And we are still not back to the actual. It might be that the judge, when he got back after lunch and they still weren't done, he's doing out of court yelling.
The judge is trying not to unalive everyone. He's like, look, I
Yeah.
got this daggone dog.
Yeah.
We're trying to.
Yeah. And as Brandon says, yes, I am covering this trial gavel to gavel. I will live stream as long as my work doesn't get in the way. I have Dave who can stand in for me and at least start the stream if I get if I have to go away for a few hours, or end the stream if I'm not back before it ends, so he can get guests on and off and stuff like that. So you will get as much live coverage as I humanly possibly can. If I can't, I will do daily or at least every other day recaps of this, but I will be here gavel to gavel. Yeah, and if you become a member, please let the mods on Discord know if your Discord name is different than your YouTube name, so they can let you in to look at all the Discord. Am I initially falsely advertising? Maybe what?
No idea.
Yeah. But thank you. After this gavel to gavel coverage, I should be at 10K. I would be amazed if that happens, but I don't count on it. But I would be amazed if it happens. And I hope that me, my personality, and having Mo around as my sidekick.
I live to serve. What can I say?
Yeah. And unless there are an actual mistrial in the middle of it, it's at least 6 months of coverage. Now, also on top of possible mistrials in this trial, the defense attorneys have appealed a few decisions from the judge that if the appellate court says yes, the defense is right, then this trial stops on a grinding halt. So, and this is what happens apparently with since RICO is so broad, Georgia RICO is so broad and vague, that if they get 1 or 2 of these motions or appeals to the Georgia appellate court, if those get approved, we're done. And I will panic a bit because I don't have anything else. 32 seconds. Oh, then I gained 40 subscribers today. Wow, nice. Thank you so much, people. Thank you so much. And on the membership tabs, you can answer questions and send me things, questions and suggestions and articles. If I get a downtime in the trials, I can maybe, that article about that specific case, that sounds interesting, and I will read from it. For instance, we have the Delphi case going on. Today is appellate court day. For a lot might happen today in the Indiana appellate court, and if news or documents comes out of it, I will report on it either today or tomorrow, or Mo will do it on her channel, because Mo has much more coverage of the Delphi case on her channel than I have.
I'm trying.
Yeah. The Delphi case only became interesting for me. Well, it is interesting, but it became something in my radar when all of a sudden the Odinist angle showed up, and that one, say what now?
It is all the crazy packed in there with just all of it.
Yeah, I mean, and apparently all of it in that Frank's motion is from the discovery that the defense got from the prosecution. Because so far, the prosecution hasn't said, out loud at least, that they outright lied in their Frank's motion. And that's interesting.
Yeah.
They say
You
they
don't
have
wanna do
bad
that.
arguments and mishandling and stuff like that, but nobody, not even the judge, has so far said they outright lied in their Frank's motion. Sometimes it's not what they say that's interesting, it's what they don't say. Welcome to law, folks. Hey, Sonny! Welcome. Broad and vague describes many things. Sex life, foods.
Well, you know. It does.
Oh, that's
We
so
try.
funny. We try. I mean, gravity takes over with age for both men and women. And we all have dangly bits that suffer from gravity.
In the end, everything dangles. Just is what it is.
Yeah, and Sunny was my court reporter in the Adelson trial. She was in the courtroom during the Adelson trial. And we got great commentary from her during the Adelson trial. And the Adelson trial I will still try to cover because I think she has a new hearing. Donna Adelson this week.
Yeah.
Maybe.
I think.
And if
I wanna
I
see-
get during lunch or something, I will try to cover that as well. And I do believe that Mo will cover that on her channel. If you haven't subscribed to Mo's channel yet, you should.
Yes.
Everybody go over there, subscribe to her, like everything she's ever done, and give her lots of hours and stuff like that. Just say,
Yes.
you will never regret it.
Nope.
Well, you might,
we
but
have-
that's not my
well,
fault.
You know, it is what it is. Look, you
Mm.
cannot unsee some of the things you're going to see. Look,
It's
the
a
unicorn
YouTube channel,
Christmas tree.
nothing else. So she's referring to what you see on her YouTube channel.
The unicorn Christmas tree is either the most awesome thing or an abomination against humanity. I can't tell you what to think.
Yeah, I tried to get Rob from Law and Lumber to get his viewers to buy all the, but apparently it's sold out on Walmart.
Really?
But it's not at eBay. Just saying. And eBay has delivery.
Oh my Bob, that is hilarious. I have started.
Haven't you got an emergency? I'm sending from Sweden, so it might take some time. I hope it arrives before Christmas. Because if I send merch from my ready to order site or whatever it's called, the Teespring, then I have to pay full price to send it to you. So I had to make stuff over here to send it over. But I'll get it sent to you, Sunny. Or you can order it and I will reimburse you. You can do that as well. Yeah, but it should be on its way. Yeah, I was on the expert stream last night. Yeah. I scared I had fun because it was really early in the morning. I had just woken up and I had absolutely no filter. And apparently there were, somebody said my favorite joke, one of them at least, that I like my women like I like my coffee, wet. And
gonna say with sugar and creamer, but
Or I like my women like I like my cheese, with holes.
well, I was gonna say lightly aged and without mold.
Yeah. Here's the thing.
With
I have
wine.
a law degree with all that comes with it, but I have the need to entertain as well, because at my line of work in labor law, I have to be so stoic and so serious all the damn time. So it's so amazing to get an output. Sal, I can't put that up on screen.
Leave it to Sal to put stuff you can't put in screen up.
Did I make myself blush? No, this is how white I am. Every time I physically do something, I get red.
I like Flux's report. I like my men like I like my coffee rolling off the hood of my car in the morning.
Oh, December 12th. That would be a Monday. Donna's arraignment and Charlie's hearing are both on December 12th in the same courtroom.
Oh, mom
Different
and son
time.
together again.
I just think that that's an amazing, what you call it, very, very amazing irony.
Family reunion.
Yeah, because
Oh.
Wendy Adelson felt so trapped in Tallahassee. Donna allegedly had her ex-husband murdered, and Charlie is convicted of it. And now she's in Miami and they are in Tallahassee. Literally trapped. Oh, court is back and
Here's
he's
the
yelling.
plot twist. Wendy hates her entire family and Dan. She set up her entire family to take the fall.
Oh.
And she gets rid of all of them. No, he's yelling.
Yep. Hold on. While I go there, I have to put that up again. That up again. Let's go back a bit. This wasn't on the channel. Oh, they have been on for a while. Damn it. There. Okay. That's an unfortunate picture of the microphone.
Share its PowerPoint with the defense. We went through and made any corrections to typographical changes or needs in the PowerPoint itself. They are actually able to access the state's PowerPoint in real time, so they can see any change or anything that we made. We actually took out most of the photographs that we initially included, particularly most of Christian Eminger. So I have not heard from anyone on the defense team that there was any other objections. We added back in Rodelius Ryan's party opponent admission on the date of the murder of Jamari Holmes. And we would like to, but have not, add the third homicide victim's photograph in. And that was it. So I have not heard anything from anyone regarding any of the changes.
Okay. Do I have any further objection, or are there any further objections to the state's PowerPoint that you all, or changes that you all individually have objections as to going forward?
I would.
Go ahead, Mr. Slip. Your Honor, I understand the court's ruling, previous ruling, just renew my objection that I think because the state didn't turn these over, they should be excluded.
Mr. Steele?
Yeah, Your Honor, I was unaware that there were changes. I apologize. No one told me that and didn't email to that or text.
I told you all to do that during lunch. That was my last conversation with you all before I went ahead and broke for lunch.
That's what I've been doing. I'm waiting. Right here. We're always in that other limitation. So I expect the state updated something, and not realize that that's what they were doing.
Your Honor, we would be making those corrections.
You know, you all don't listen to the court, and it's going to get you all in a lot of hot water. You need to listen to me when I tell you something, and don't rely upon your own understanding. If you have clarification, ask me at that point in time. I'm more than happy to do that for you. But that's not what I told you all to do during the break. These jurors are waiting back there. We are dallying out here. So, you didn't follow my instructions, Mr. Steele. I mean, that's what I asked you all to do. I asked you all to share each. We're already behind to begin with. So.
Yep. But the base of the problem is the prosecution, not Steele. This should never have happened if the prosecution listened.
Any further objections?
Yes, Your Honor, I didn't know that they
Why
were.
is the judge getting mad at them?
Slide 10 and 13, they misquoted the Instagram post.
Again, they misquoted it?
Yes, they did. It says, I bet YSL make the news tonight. That's not what the Instagram post says.
Your Honor, we actually copied the Instagram post into slides 10 and 13.
And it does not say tonight.
I'm sorry, okay. I will take out the word tonight. She's right.
Anything?
Did you just hear what the prosecution said? We copied it right from there to there. That word isn't in there. Oh, I'll remove it. That means you put it in there. Shady.
All right, guys, I will be back. I am running to go pick up the children who, well, probably listen to directions about as much as these lawyers do.
Yeah. What happens?
But I'll be listening.
What happens if judge has an aneurysm during trial? I'm not so worried about that. I'm more worried about me having an aneurysm. Yeah, and thank you for being a member for 4 months. Thank you so much, Sal. Let's continue.
Further. Mr. Shard, did you rise to?
Well, I'm just seeking
I, on behalf of, I think, everyone in this back row, we're seeking clarification. Is the state saying that the same link that they sent earlier before the changes will now show an updated version?
In fact, it does. It has on every other person's computer who has this PowerPoint. And at the appropriate time, we would, Mr. Sharp shared his PowerPoint. We were able to see it, and the state has objections to the argument of the slide in Mr. Sharp's PowerPoint that we would like to stress it for here in front of the jury.
Could you repeat that, Ms. Love, again?
Yes, Judge.
Mr. Harvey can't hear back there.
So the state shared its PowerPoint with all parties, including other members of the state's team, and the other members of the state's team that have looked at the PowerPoint, they were able to see in real time the changes that are being made, as are anyone with the link that I shared with the defense earlier. Additionally, Mr. Sharp, over the lunch break, shared for the first time his PowerPoint and has included slides to which the state objects and has responded and told the court and Mr. Sharp that we object to. But I just wanted to make the court aware before we were in front of the jury again, as this, I think, is the appropriate time to do so. But the changes that the state made were available and published to everyone on counsel for the defense team.
All right.
Okay. I think the confusion, Your Honor, I understand what the state's saying now. The confusion is no one on the defense team we were waiting on a new email with the new version of the House.
That's not what I told you all to do. I was pretty clear. I said, y'all, over lunch, just take a look at the state's PowerPoint, make sure you have no further objections. I didn't tell you to email it to you. I just told you to look at it. I don't care how you did it, but that would be the thing I would probably have gone through and said, hey, let me see slide 1, 2, 3, 4, 5, 6, 7, 8, 9, whatever else.
Okay. We were waiting. We had voiced some concerns already, and we were waiting on a new version. And I'm just explaining, Your Honor. I don't think anyone was aware that it was being edited on that old link. I think people were waiting on a new version of the PowerPoint.
Okay. Here's what I'm going to do. I'm excluding the PowerPoints. Y'all are just going to have to make this thing up the whole way. Yeah, just make an opening statement. No PowerPoints. Let's bring our jury in. No PowerPoints, because you all did not do, hold on, I'm starting, you didn't do what I told you to do, and that was to exchange PowerPoints. We have wasted almost 2 hours trying to get this stuff done, and my orders to you are not aspirational. They're given for a reason, and when you don't follow them, then I have a way to remedy that. So the remedy is nobody uses no PowerPoints, okay?
in terms of what we have done here on our team. We have provided our opening statement to the state of Georgia as well as to every other person on the defense side.
Yeah, the judge seemed to forget these are 6 different defendants. If Mr. Steele didn't do his thing and the other one didn't do his thing, don't hold that against the other 4. State, complete clusterfuck. They should be reprimanded for this and a lot of other things. But don't punish the other 4 who actually did what you told them.
We have received from the state of Georgia an updated, came to my email from the state of Georgia with the changes as it relates to Mr. Hugh. I have it. I will be hamstrung, Your Honor, if I am not able to use my opening statement because I prepared my case with my opening statement. I have not committed every single slide to memory, Judge. I'm depending on my opening statement to present to the court, to the jury, Judge. So I'm asking the court to reconsider its position as it relates to Mr. Hugh. Respect.
All right. Mr. Steele?
I sent our entire PowerPoint to the state of Georgia last Tuesday.
Which the court has already. I do acknowledge that.
Now I did everything the court demanded.
All right.
I'd like to use mine.
Okay, all right.
And Your Honor, to be clear, on behalf of Mr. Stillwell, I sent over all the.
When did you send it?
On Friday, I sent all the photos of the exhibits I plan to use or the monsters I plan to use, save for one which I did not have physical custody of, which is a Fulton County jail uniform, which I took a picture of. And I have it with me right now. But I did not have that on Friday when I sent that over. I did not have custody of that object. Regarding the PowerPoints, when the state finally handed over their PowerPoint and said that they didn't realize they were supposed to hand over the entire PowerPoint, but really which they didn't do that either, by the way. I did. I sent them out of an abundance of caution my entire PowerPoint. So.
Yeah.
And Your Honor, I don't object to.
Yeah, judge is punishing everybody that is more or less solely the state's fault. Solely. That's not fair.
Generally speaking, the PowerPoints that have been shown, what the state did do was exactly as the court directed during the lunch break, as Mr. Matthews was able to see. We provided to each member of the defense team every change that we made. And respectfully, Your Honor, we would also request that the court allow the state to continue in the path that it has gone. We have complied with the court's directive.
No, you didn't actually. The court's directive was you were supposed to turn this over way beforehand, because then we could have corrected these issues and not spent 2 hours in doing this. I'm deeply disappointed in, because this is exactly what I told you all was going to happen, was that we were going to end up dealing with a lot of objections. And I mean, I don't mind dealing with the objections, but I got to have time to do so. So that's why I told you I had to start having this discussion with you about a week, almost 2 weeks ago. Mr. Steele brought that up, saying, hey, go ahead and turn over your PowerPoints so that we can go ahead and, if the court mentioned, have as smooth as an opening statement as we possibly could. That obviously, very few people adhered to the court's instructions, and we find, my words to you, a self-fulfilling prophecy, meaning that we are still dealing with this particular issue, and our jurors are waiting on us. So.
No, we have as well, as I stated, we provided the photographs we intended to use.
When did you provide them?
Friday before 5, Your Honor. The language that is in the PowerPoint are the words, our opening things. They all have that. Everyone has that. I don't believe that there is no objection to that. Every objected to portion of the PowerPoint that the state has, Your Honor, has been modified to address those objections. And we just ask the court to allow the parties to proceed as we have been proceeding with respect to presentment of opening statements. Additionally, Your Honor, I am not objecting on the basis of anyone having given the state the PowerPoints today. I'm not objecting as it relates to when anyone gave us the PowerPoints. I only objected to these photographs that were provided to us just a few moments ago on the basis of that they were argumentative. And I want to bring that to the court's attention. If the court decides that they say, even though they're argumentative, the state has, we can get past that quite easily. we would just ask that the court allow the parties to proceed as we have.
Are you referring to I'm in possession of 2 emails with photographs while marked as the next court exhibit in order. One of them is, it has the subject of state objection arguments contained in Shannon Stillwell slides below, and I have a couple of, it has like 3 slides.
Yes.
And marked as the next court exhibit in order.
Yes.
Mr. Sharp, why don't you believe this is objectionable? It would seem to me it's got pictures of a couple of folks here in our facility, and a picture that's probably more prejudicial than probative, and it has somebody that purports to be an inmate. So why wouldn't that be?
Wow.
Yes.
The prosecution sent a slide of a few slides. Then all of a sudden, the slides they want to present are including things that the judge says is more prejudicial than probative. This is surprise shenanigans again from the prosecution, which they have done the entire time leading up to trial. This is ridiculous. Judge, don't let them get away with this again.
I don't believe, I'm not seeing the email. I see an email saying the state objects to use of these photographs during opening.
Scott, your 4 slides, state's key witnesses, Nicholas Robinson, and then Nicholas Robin, aka Spencer Wright. Those are 3 that I'm looking at.
It's not showing that in my email. I'm seeing 2 pictures of jail.
I got that one too, which I'll mark as the next court exhibit in order, and that's the 2 pictures that you referred to, and it has the state subject matter as the state objects to the use of these photographs during opening.
Could I see what we're talking about? Because I don't have it on my email.
Sure.
I'm not seeing it.
Christina, can you mark these in these court exhibits? And
Got
show
to
them
be.
to Mr. Sharp. Counsel, you can approach and take a look at it.
Unless it is in his trash can, or email trash. This prosecution, seriously, I can't imagine the judge being far from actually just punting it out of his court at this time. Yeah, maybe Miss spam filter.
And you're on the floor on the right.
Hang tight. Which one did you mark it as? So we can.
It's marked Exhibit 2.
All right, court 2. Or
yes.
Next court's exhibit in order. Okay. All right.
And I wasn't on that email, and that's fine. I just wanted to, that's why I hadn't received it.
He wasn't on the prosecution's email list? I'm so glad I have to work tomorrow and I have to get up at 4:30 in the morning. Because as of every lawyer out there, I'm borderline alcoholic, and this is clearly, I need a shot. Luckily, I have work to do.
So this case is going to involve
objectionable.
Well, I'm allowed to preview the evidence that I believe that will come out. I not only believe, but I know that several of the witnesses in the case, which I'm going to discuss in opening, became involved in this case once they were in the Fulton County Jail. They were jail inmates. Okay? Now, I'm allowed to preview the case in that way. To the extent if the state has a particular argument or objection to one of the photos, then we can talk about that. But okay,
Court does.
well, I can alter my. I mean, so what is it you want me to alter, Your Honor, to avoid
the picture? And if the state doesn't have any objection to the, you saying anything about any other witnesses in custody, then that's certainly within their purview.
Well, the case law, as I understand it, allows us to preview the case and let the jurors know in advance that witnesses were in custody at the time they made statements. That is completely appropriate as under the law, as I understand it. Now, if there's a problem with the pictures, as I said, Your Honor, I will remedy that. That's not a big deal.
I think well, I would ask that you take the pictures out.
Okay.
Okay.
That's fine.
What about the argument in the pictures seem to be, and that would solve that issue. So what about the other issue about the slides?
What they also said is Nicholas Robinson won. I'm not sure what their objection is. I will be letting the jury know, which will come out in evidence, that a man who claimed to be named Nicholas Robinson was arrested on October 19th, 2015. He's an important witness in this case. The evidence will show that he was interviewed by Detective Thorpe, and he gave his vantage point of where he was, and he told a story which involved the guilt of 5 people that are listed on this slide. And that evidence will come out at trial, and I don't see anything objectionable about this at all.
All right, Ms. Love.
Judge, I don't object to Mr. Sharp telling the jury the words that he has shared with the court. What I object to is the imagery that is depicted in the.
You mean the person that's in a uniform as well as the purported condition of the jail in that lower one?
Well, that's a separate slide. That's a separate slide. These are 2 separate slides. I just want to make clear. These are 2 separate slides. So I'm saying that I'll take out the pictures.
And also the giving of the false information. So the only problems that I have with the language in the other slides is that part of that information is improper impeachment that Mr. Sharp would not be able to introduce at trial. And I don't have any problem with Mr. Sharp telling the jury that the evidence will show something about Nicholas Robinson, but he has listed all of the arrests for Mr.
Yeah. This is probably the defense. We will go by the rules, but we will object every time the prosecution still tries to put Shenanigans. Now it's more important than ever that the defense doesn't fork it up. That they don't give the prosecution a reason to say, but they did, and stuff like that.
Right, Mr. Spencer, right?
Who is Nicholas Robinson, Your Honor, just so the record's clear. Your Honor, as Your Honor knows, we're allowed to impeach with prior convictions.
They got to be called first, right?
But we are also able to impeach with bias. And the fact that this gentleman was arrested, Your Honor, that's the central crux of this case, and it's something that the jurors need to be made alert and to look out for as this case is presented. The bottom line is Mr. Wright, who identified himself as Mr. Robinson, was arrested on felony charges and probation violations on 10/19/15. And then he reached out to APD and said he wanted to give information. And then he met with Detective Thorpe. Nothing I'm saying is incorrect. It's all accurate. It all would go to his bias and motive and reasons for coming forward. And
so you're saying this is what he was arrested on 15?
Right.
On 10/19/15?
Correct.
Okay. All right. Okay.
And quite honestly, off the top of my head, I don't know how those cases were resolved, but they were biased at the time that he made those statements.
Are you saying that because the evidence will show that he then gave information against your client?
Yes.
Or involving your client?
Yes.
And Judge, I don't have a problem with him saying that Mr. Wright was in jail. I don't have a problem with him saying he had open charges. It is the listing of the specific ones that we objected to.
I don't know why that's
because they are not convictions and that is not the proper method.
Yeah, I would agree with that. So you can talk about, unless you get them in a proper format, yes, you can talk about if you have criminal charges, that would be appropriate. What happened as a result of that, but I think the longer listing of that, because you said you don't know what what happened to him. So,
but the reason I'm saying that is because I think it's irrelevant, because this is really about bias.
it's not proper though. It's not proper format. Bias is fine. You can talk about
But he had the bias because he was facing these. Certainly, if someone's arrested
you just
for murder,
can't. You just can't mention the individual charges themselves unless they're in the proper format.
I
okay?
understand. But my only point would be, Your Honor, certainly if someone was charged for jaywalking, arrested for jaywalking, and someone else was arrested for murder, the bias, the level of bias would be different. So,
okay, but what does that have to do with them not being in the proper format, though?
Because the jury is allowed to understand specifically what bias the person has, not that they're just in jail, but what they are facing.
If you can get it in the proper format, then it can be, and you can tell them about that. Do you know what happened to these RICO charges?
Well,
is Nicholas Robinson going to testify?
At the time that
answer my question. Is Nicholas Robinson going to testify?
If the state doesn't call him, I will.
Okay, well then, at that point, then it might be appropriate for you to get into that specifics. But unless you're going to package that up, and certainly that's not, you can decide that. You don't have any responsibility to present anything on behalf of your client. But in order for you to delve into it, it has to be in a proper format. I would agree with the state with that. I would sustain that objection. But you can talk about arrests. You can talk about pending charges. You can talk about that, you'll present evidence sufficient to show that he's got an axe to grind. He's got bias.
So just for clarification, because I want to get this right, we're saying your instruction is that I can say that he was arrested and he had pending charges, but I just can't say what those charges are.
Until and unless they become in the proper, you get them in the proper format where you have a witness to, you can lay a foundation for those. Okay?
Okay. And the third thing, Your Honor, is I have a Fulton County jumpsuit. This is the same uniform, not actually the same one, but is the same make and model that a number of the state's witnesses were wearing when they inserted themselves into this case. I wish to preview to the jury and say the evidence will show that these individuals were in Fulton County custody wearing this jumpsuit at this shirt at the time that they gave statements. That's previewing the case. There's nothing objectionable about it. I'm not going to put it on. I'm not going to jump around the table. I'm not going to do anything with it. I'm just going to show them and say this is what they're wearing.
Now,
Judge, I think that is appropriate for argument, but I think that saying, and they can, certainly Mr. Sharp can tell the jury that the evidence will show they were in custody, all that, but that I would argue would be more appropriate for a closing argument. And that is argumentative.
I believe it is appropriate for a closing argument, but I think it's also appropriate for an opening argument. And I'm allowed to use demonstratives to try to get my point across to the jurors in a way that will stick in their mind, because we all know that they're going to be listening to 15 hours of probably, or 10 hours of opening statements and 9 whatever of testimony in this case.
All right, I'm going.
Okay, now we know at least 2 of the defense attorneys are planning to have opening statements. I would assume all 6 of them will have, and that is one of what the poll is up for. But you never know. You never know. Yeah, 10 hours of opening statement. We are 6 hours in, and the prosecution has so far only got out about an hour of opening statements before 2 sustained objections from the defense, one for burden shifting, which is clearly serious and unconstitutional, one for argumentative, and then the mistrial motion that was denied, so far at least, about the prosecution using slides they never presented to defense, violating the court's direct order.
To sustain that particular objection and also remove the ask you to remove that picture of what purports to be as, I think it's a cell or something like that. So remove
Yes.
it. So yes,
remove the pictures
and lose that for the time being. Sure.
Okay, and take off the specifics.
Take off specifics. Okay.
All right. Thank you, Your Honor.
All right.
Now, Your Honor, hold on one second. You good?
Oh.
Mr. App, have your client put on shoes.
Yeah.
All right. Anything else? Anybody else?
Your Honor, there was not anything with respect to any of the defendants, but there was a matter that probably is best addressed with a member of defense counsel at the bench briefly. It is a short matter.
Okay.
Defense counsel?
Either one, it doesn't matter, it's not. So-
All right, put your headsets on, please.
And we have a sidebar. Yes.
They have to also hold it.
Not the time to air out your feet.
Can you hear me? Thumbs up? Okay, all right.
Can we send the court case of your mugs? Yeah. You're more than welcome to. And for you who don't know, these are the mugs that currently exist on my merch place. I expected clusterfucks. This amount, not really. No, Janus, you can't sit on my seat. Ow. You know exactly. You can be up here, but you can't be where I'm actually sitting. And for you who are new here, if you recognize this, my avatar that is covering the logo.
As long as we don't have any other issues? Okay.
This is Kingo! I want to make certain no objections, Mr. Attorney.
Yes, Mr. Steele, what is it?
On the PowerPoint, I'd like you to grab the newest one, I got the last one. Number 19 is argumentative. Number 41 through 47, 51, and 54 is the law that they take from the court. I would object to those numbers.
And I believe that the argument about the law was raised prior to lunch.
Hold on. As it pertains to number 9, I'm going to mark the safe second PowerPoint as the next court exhibit in order.
Okay, pull the PowerPoint
in terms of number 19.
That is.
I think that's the wrong ruling. If anybody should be punished, it's the state. Remove it. Don't walk back on it. Don't be all bark, no bite, Judge.
We didn't chase the lyrics to solve the murder. We chased the murder and found the lyrics. Is that what you expect the evidence to show, madam?
Yes, it is.
All right, I'm going to overrule that objection. What's the next one, sir?
41.
41?
Yes. Oh, wait a minute. You had a ruling about those lyrics that when the prosecution wants them in, they have to have a hearing about each individual lyric. So why do you allow it in opening statement if they may not be able to show it during during case in chief? That's weird.
Judge's rules. All right, this is a note taking that I already gave them.
Didn't change it.
Ms. Lowe, why are we rehashing this since I've already told them that?
Your Honor, why are we putting it
Why
back?
are we rehashing that? I just told them that. I told them what was in 41, as well as 42.
Your Honor, I can take them out. I don't mind. I was just, it's part of the opening that I wanted to emphasize, but I can take it out.
I'll sustain it. You can tell them that it's fine. I'll ask that you take out 41 and 42. So I sustain that objection, Mr. Steele. What about 49, 43? Did you have an objection, sir?
Correct.
Your Honor, is the court directing me to take out the picture, or can I just take out the word take notes? Because
no, take notes is fine.
Oh, okay.
He didn't object to that. Okay. He's objecting to 41 and 42, which I'll sustain the objections to that. And then 43, let me look at it.
Oh, okay.
Okay, I have not instructed them on how to judge credibility as of yet. So 1 through 7 would not be appropriate at this time.
Okay, so.
But you can leave in bullets 1 and 2.
Okay, so
You must remember in any way that works for you what they said on Wednesday. That's fine.
Okay.
And use whatever memory aid you need, just not to remember what you heard, but to remember who said it and how credible you found them to be when they testified, or some words to that.
Okay.
But the other things I have not instructed the jury as of yet. I had to judge credibility. I didn't give them a preliminary charge on that. So if you could take those out.
Okay.
1 through 7, please.
Yes, Judge.
Does that suffice, Mr. Steele?
And as
Or do you still have an objection to 43?
Yeah, and I appreciate what you said, exactly, but prosecutor opening statement, this is Johnson versus State 261 Georgia Appeal, 98 Division 6C as in collect.
Charlie.
And Charlie.
No, just one, Charlie, okay? Just one. We gave you the military alphabet. It's on your desk.
No, I have it. That's why I say and Charlie.
I only want military alphabet, okay?
So that is my life.
I know. I'm very sweet lady, okay? All right. So
It says the prosecutor's opening statement should be limited to what the prosecutor expects in evidence to prove a trial. So I don't see why the law is coming into their opening statement. That's my objection.
I removed 41 and 42.
for clarity's sake, Your Honor, I did and have been editing as the court has directed. So my 41, because I took out a whole slide, may be different. For clarity, the one that the court is referring to is 41. Is that the one where we are saying your assessment of a witness's credibility?
Why are we still talking about them having this slide when they violated a direct court order? And now he's allowing them to correct themselves. Again, please stop being all bark, no bite. Please. It's good that he makes them remove stuff from the slides, but the issue is they did not provide this at all, except 3 or 4 slides to the defense before they noticed it today, during their opening statement.
Blah, 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 all of that.
Blah, blah, blah,
No,
blah.
no transcripts in the jury room.
Okay.
I've already told them that too. So why don't you just do this?
I can take that.
Why don't you just take, your last slide can be take notes. And you can tell, I think that what you told them, what would be more than proper argument would be. Hey,
I didn't do
what
it.
the court told you.
I didn't neuter Jingles. He was neutered when I got him and his brother.
And take notes in a way that works best for you, and use whatever memory aid you need. And remember, that would be more than appropriate, and I think would not be objectionable.
So I'm also taking out the one that says, please pay attention. Is that what the court has directed? Because I'm gonna hit delete if it is.
Yes, I would take that slide out, okay? Anything else? Can we call for our jurors now?
If you move on 45 or the old 45,
I don't have the old 45 right here. They've gone through, the new one goes through 43, sir.
Okay, as long as it's removed, then yes, I understand.
Okay.
Your Honor, and I want to make sure that we all have everything the same. So just to be absolutely certain, I'm going to share again with the court, because
That would be
numbers
at
that I just heard
least
the court
12
reference.
slides
I have a
removed.
new slide to show you sent me, which goes from 1 through, I didn't go down far enough.
No, they can still use it in the case in
slide
chief,
goes 1
just
through
not
56.
during opening statements.
I took out
Then they will have
So
to
I'm
do a
gonna say take
ruling
out 41,
during.
42, 43.
The defense can still object to them during the case in chief. Unless
and I'm
there's
changing
a
them in real time, so I'm
motion
taking them out.
and a court ruling about it. What an absolute clusterfuck.
You need to take out 44.
Okay. Is that the one that starts with judge's rules?
No, please pay attention. You need to take out 41, 42, 43, 44, 45, I will leave in over objection.
I mean, because we don't know what the jury will think of this. They only heard the defense object. So hopefully they come to the conclusion they have been out there for hours because the prosecution did fuck up. But we can't control what they think.
I'll let you leave in 45 and 46 over objection. 47, judge's rule, 47 needs to come out.
So the one about with the finger pointing, that,
Finger and the eyes are fine.
okay. And I took out judge's rules
I got 47.
and
They tried to.
I think I've already taken out 47.
47 is judge's rules again.
I took that out.
Any further objections, Mr. Steele? Because I am going to leave in 45 and 46, okay? But I'll take out the other ones that you just mentioned.
So, my mistrial, thank you, sir.
Say again?
About waiving my mistrial, thank you, sir.
Is your motion for mistrial has been denied, and I've noted your objection for the record, sir.
Yep. Okay.
And
Motion.
confirming everyone has 1 through 52.
Yeah, and he's he keeping reaffirming his motion for mistrial. That's for appellate issues, so he can always appeal this decision as a appellate issue, and if the appellate court agrees with him, then it might be sent back for a new trial or removed with prejudice, and that would be motion number 7 or 8 that is already on the way up to appellate court that they will handle in the next coming months. Yeah.
With the edits that the court has directed.
We're over
Yes, it
6
is.
hours in, and we only got through 1 hour of actual trial time. This will be all day tomorrow as well. State's opening statement.
All right.
Unless there are more objections.
Anything further? All right. Yes.
Just don't want to get an objection to the opening charge. We can do that later before we break for the day.
What are your objections, sir? To the court's, the court's preliminary instructions.
First, before the court talks in terms of guilt and innocence, and I would object to any of the phrases that are used in terms of guilt or innocence. I object to the use of the phrase, the purpose of the trial is to discover the truth. No, it's not. The purpose of a trial is to determine whether the state proves beyond a reasonable doubt the allegations in the indictment. So I would object to that. I object to the fact that the court, I believe, is going to allow the jury to frame questions to provide to the court. I was unaware that the court was going to.
No, I'm probably not going to do that, Mr. Harvey. I do that because that's part of the pattern charge, the pattern preliminary charge. And most of 9/10 of the time, they're not going to ask any questions. And if they do, I will then present that question to you all for your consideration.
Okay, so this is a trial where the jury can ask questions. Okay. Yeah, we'll. Okay. This trial just got a bit longer.
And I may or may not ask it. But you objected to it. Okay. Anything else? Okay, all right. And I'll note your objections for purpose of the record, sir. Okay, all right. Can we summon our jurors, please?
Ta-da!
I go ahead and share.
Yeah, put the last slide. I believe that was Mr. Ryan.
Okay.
Yeah, we all live in Georgia now.
I'm gonna go back to Zoom.
I don't know if that's the same Harvey, but it might be.
This is Zoom. Did you just send it?
Yeah. He's definitely old enough and persistent enough to actually have a rule named after him. Mo is doing mom taxi duties. She will be back when she can. And Dave is probably joining us in an hour or something like that.
Oh, ladies and gentlemen, please be seated. We just want to wait on one.
Oh, my. If you talk to my sisters, I haven't been sane since age 8.
Wait on one. We'll wait on one juror, ladies and gentlemen. Just be made easy. Just a second, please.
It will be interesting to hear what his jury instruction will be after this.
All right, thank you, Sergeant Ingram. All right, ladies and gentlemen, how was your lunch? All right, good. Okay, ladies and gentlemen, before we go ahead and continue with the state's opening statement, I need to kind of just advise you of just something that was said to you earlier, okay? So with your patience, all right, I believe the state counsel earlier referred to some representation of the parties, and I just want to remind you of two things. Remember that opening statements are not evidence, and that what the attorneys say is not evidence. And with that, Ms. Love, you can continue, okay?
Thank you, Don.
All right.
And thank you, ladies and gentlemen of the jury. I like the court. I hope you all had a great lunch. You can stay awake with me for just a few moments more. So where we left off, the crimes that the defendants are accused of committing in this case. You're going to have the indictment with you. It's going to go back. A listing of them includes the following: conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, murder, armed robbery, aggravated assault, possession of a firearm during the commission of a felony, possession of a firearm by a convicted felon, possession of a firearm by a first offender probationer, and death by receiving stolen firearms, among other things. This list is not exhaustive. You will have again with you the indictment, and you are to consider as the state admits further. So breaking it down, the evidence is going to show that the defendants, when we say conspiracy, it's nothing elaborate. It's a legal term, which simply means the evidence is going to show that the defendants had an agreement. It will not be a written contract presented to you. There will not be a letter signed in blood by any of the defendants. But what you will see evidence of is the defendants' actions, their presence, their companionship, their conduct before, during, and after a long list of crimes. And what you will see is that the defendants weren't always convicted of these crimes. Sometimes the state no-prossed or dismissed charges. Sometimes the police never brought formal charges. But what the evidence will show is that the defendants did commit those crimes. And when we're talking about a conspiracy, an agreement, just an agreement, unspoken agreement, we're gonna participate in YSL.
That was interesting that she brought up in her opening statement that they will hear about incident where charges was never brought. I would lean into that hard as fuck as a defense attorney. Really leaning into this is a trial by volume, not by evidence. That the prosecution throughout the years have never charged them because there was simply no evidence. And now they are trying to do it by sheer volume in hope of you ignoring the fact that there were never enough evidence to even charge these people. That is something that defense must point out. And I would assume they will.
Through a pattern of racketeering activity. That's another large word that is used in the legal community, but regular folks, myself included, just don't generally tend to use it. Racketeering activity is
let's
nothing
call the
more
jury
than
stupid.
certain crimes,
Good
the
choice.
crimes that are listed out in the indictment. You will see that, and the court will instruct you, I expect, that those crimes constitute racketeering activity. And as I stated before you all broke for lunch, a conspiracy requires just one overt act. So you will see evidence of several overt acts. Several acts that were done by these defendants and by unnamed and unindicted people as well, to further the interests, to further the goal of the conspiracy that the defendants participated in. You will see overt acts meant to establish YSL's dominance and control. You will see overt acts meant to gain illegally access to money and wealth and property that did not belong to YSL. You will see overt acts, steps taken on the part of various individuals to act to protect the group as a whole. Steps that have nothing to do with a recording label. Steps that have nothing to do with an A&R executive. You will see steps that were taken solely for the purpose of illegally gaining goods for and on the behalf of YSL and its members. You will see steps taken by each of the defendants to protect the members of YSL, to establish the dominance and control of YSL. Nothing in what I expect the court will tell you, nothing in the evidence will suggest that any of the defendants had to be convicted of all of the overt acts in order for you to see that they actually had an agreement. The acts don't even have to be crimes, but they are. And that is how the state expects you will know that these defendants, they wanted to participate in this enterprise. They wanted to participate in this organization through these illegal acts. They wanted to obtain ill-gotten goods that they did not have a right to have through robbery, through stealing, through drug sales, and the like. So we'll start off by looking at the defendants. 6 of them are at the table, and 6 of them are here for you all to decide, has the state proven its case? Rodelius Ryan. Rodelius Ryan is one of those people whose youth and life was swallowed up in the crater created by YSL in the Cleveland Avenue community. The evidence is going to show that in 2019, Rodelius Ryan was 15 years old. And that in February of 2019, Rodelius Ryan used female acquaintances to lure Jamari Holmes to a particular address here in Fulton County. The female acquaintance lured Jamari Holmes to that address, telling Jamari that he would get sex and weed once they got there. Instead, when they got to the address, the female gets out of the car, and the defendant, Rodelius Ryan, and his accomplice, Damone Blaylock, also a YSL member and associate, they then came out to the car with guns. The evidence will show that Rodelius Ryan and Damone Blaylock then fired those guns into the car, where Jamari Holmes, not even 20 years old, was seated and hit him in the back of the head with a bullet that took his life. Jamari Holmes is another one of those young lives. The evidence.
They were never charged or convicted, no trial, no nothing. So yeah, apparently she can use acts committed or allegedly committed while they were juvenile.
Will show that was swallowed up by the crater that YSL created and left in the middle of the Cleveland Avenue community in Fulton County. 12 hours after shooting and killing 19-year-old Jamari Holmes, the evidence will show that Rodelius Ryan didn't say, I bet I make the news. Rodelius Ryan posts on his Instagram account, I bet YSL makes the news. The evidence will show that in posting about YSL as it related to his flagrant, overt act of extreme violence, Rodelius Ryan was agreeing to.
No, every charge in this trial are for things that these 6 defendants have never been charged for before. Now, there are people in the alleged YSL-gang who has taken plea deals after spending a few months to over a year in jail during this RICO case. And then they pled out. And I think 6 or 8 have pled out and are testifying in this trial. So, yeah, none of the 6 defendants in this trial has ever been charged with any of these crimes the state is alleging.
And attempting to participate in YSL through this illegal activity. He was promoting the gang. He was showing their dominance. He was showing their power, and he was showing their control. Rodney Uten was also in the car with Jamari Holmes. That's another young life. He wasn't taken, he survived. But he was forever changed by the acts of YSL, conducting and committing violence on behalf of the entire organization. And in case it hasn't been lost on you, Rodelius Ryan's Instagram handle that he used, Slime Business Ride. Because as the evidence will show, slime is spoken and used to signify doing someone dirt. And Rodelius Ryan is proudly proclaiming his association with YSL as he talks about and as he promotes the gang itself. Rodelius Ryan's accomplice, another YSL member who's not here today, but who is a co-conspirator. What did he post after they killed Jamari Holmes? The evidence will show that Damone Blaylock didn't say friendship over females. He didn't say Blaylock over buddies. He said slime over sluts. Slime over sluts while posting a YSL-gang hand sign with the caption slime over sluts, a green heart emoji, and a green snake emoji, which I expect the evidence will show are the common identifiers associated with YSL. They're the identifiers that they use to announce and project themselves to the rest of the world. And then, on February the 25th, 2019, Rodelius Ryan made another posting where he's flashing cash money on his Instagram page with the caption, "Fuck YFN." YFN being a rival criminal street gang. The evidence will show that none of this was a part of what anybody has to do to be a part of a record label. The evidence will show that these acts were done in furtherance of and to promote the goals of the enterprise, the criminal street gang that is Young Slime Life. And what did the paper say? 15-year-old, they called Jamari Holmes a known gang member, but the evidence is going to show that that's not who he was to the people who cared about him most. Jamari Holmes was Jamari Holmes. He was a baby, a child, found shot to death inside a stolen car, police said. Jamari Holmes was just the latest victim of YSL's quest to maintain and retain dominance and control of the Cleveland Avenue community. Again, Rodelius Ryan didn't post, "I bet I make the news." He said, "I bet YSL makes the news." Marquavius Huey, he's also on trial for you to determine whether the state has met its burden of proving he committed the acts that are listed in this indictment. Marquavius Huey showed his agreement to participate in the activities of YSL through a pattern of racketeering activities. He showed his willingness to commit acts on behalf of the gang through his actions. The stolen handgun he had, that was the property of Jeremy Smith. Because as you will see throughout this trial, stolen handguns will become a reoccurring theme. There's no need for a legitimate organization not comprised of people committing crimes on behalf of the organization, to have all these stolen handguns. Everybody has a right to have a gun, so if you're legitimate, just go get one. But the evidence will show that in this case, YSL members, stolen handguns every time you turn around. And not just stolen handguns. The evidence will show that most recently in May of 2022, where some of these defendants were found at the home of Jeffrey Williams, their leader, it wasn't just stolen handguns that YSL dealt with. It was machine guns. You'll hear evidence that at the home of Jeffrey Williams, in addition to the pharmacy full of drugs, that there is a gun with a switch that allows, with one trigger pull, 10 times more bullets to come out at a time than if you just had a regular gun.
10 times as many than with a regular gun. That would be 1 or 10. So that would be an automatic gun with an, well, according to, I don't know the Georgia law, but I think alter a gun from semi-automatic to automatic isn't really legal. But as she brings it forward, 10 times as many bullets. No, it's either pew or pew, 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 pew.
There will be no evidence to show any need for that in legitimate, ordinary, record deal making business. The evidence will show that the existence of those dangerous weapons like the machine gun, the stolen firearms, those things are all evidence of these defendants' conspiracy. Those things are all evidence of the existence of the enterprise known as YSL, whose goal it is to maintain and retain dominance, control, and ill-gotten gains. Marquavius Huey, on April the 26th of 2019, further showed his actions showed his agreement to participate in YSL through a pattern of racketeering activity, illegal activity. When he took the property, jewelry, money, and debit card of Dewan Maynard by use of a firearm. Dewan Maynard, another life affected by this crater created by YSL in the middle of the Cleveland Avenue community. Marquavius Huey showed his agreement to participate in this enterprise when he struck Maynard in the face with that gun that he used to take Mr. Maynard's belongings.
Yeah. For you who don't know, they are showing slides simultaneously to the jury, but we are not allowed to see those slides. I'm just mentioning that just for our record.
Marquavius Huey hijacked on October 1st of 2020 a Buick LaCrosse from yet another victim of YSL's violence, Gary Holloman, by force in violation of the law. Mr. Holloman has since passed away, not from that incident. So he won't be here to tell you what he was feeling and how he was able to tell the police who it was that committed this armed robbery. What you will hear evidence of is the extraction from Marquavius Huey's phone, where he's planning the armed robbery, where he set up with Mr. Holloman a ruse so that he could have the opportunity, along with another uncharged, unfound individual, so he could have the opportunity to put a gun in Mr. Holloman's face and rob him. What Marquavius Huey did was kind of slimy, the evidence will show. He told Mr. Holloman, hey, your nephew in the Fulton County Jail, Tinquarius Mender, he needs some money on his books. So he wants me to meet with you to get money to put on his books. So Mr. Holloman, because he loves his nephew, and any friend of his nephew coming to him that way is legit, right? The evidence will show that Mr. Holloman arrives intending to meet the person so that he could give to them the money for his nephew. And to his shock and horror, he's met with the butt of a gun. Two people, one with a long gun, one with a handgun, demanding his money. And that day, as the evidence will show, Mr. Holloman wasn't the only person affected by the violence perpetuated every day by YSL. Delmisha Coppage, she just happened to be on scene. She just happened to be right there conversing with and talking to Mr. Holloman when the defendant and his accomplice came up, held him at gunpoint, and demanded their belongings. You'll hear how they directed Delmisha Coppage to just sit on the ground, just give me your stuff. You'll hear how they robbed Delmisha Coppage at gunpoint. The evidence is going to show Mr. Huey's tight relationship with their leader, Jeffrey Williams. The evidence will show that Mr. Huey, on various occasions, checked in with, reached out to Mr. Williams to see, hey, I got this stolen item. You want first dibs on it? Marquavius Huey's actions that betrayed his agreement to participate in the conspiracy didn't stop with Gary Holloman and Delmisha Coppage. The evidence will show that in November of 2020, he made terroristic threats towards Justice Woodard. After Woodard told Mr. Huey she'd see him in court, he said, "You will die if you put the police on me." Showing their association, showing their agreement.
That is what the prosecution alleges. And we will see what that evidence is in the next coming months.
Showing their intention to participate in this organization, this enterprise through a pattern of racketeering activity. The evidence will show that while fellow associate Quinquarius Mender was an inmate at Fulton County Jail, Mr. Mender, Mr. Huey, and Mr. Williams conducted a recorded video call wherein Mender relays he needed something and Williams pointed to Mr. Huey to take care of it. And then flashed Mender the YSL sign. You see, it's not a crime to flash a YSL sign. The evidence is going to show it's not a crime to participate in a video call. The evidence is going to show that it is not a crime to endeavor to provide something for a friend who's locked up in jail. All of that is okay. These acts aren't listed on the indictment because they are crimes. They're listed because they are actions. Actions that the legal leads for is overt acts that reflect each of these defendants' tacit or unspoken agreement to participate in this enterprise.
Yeah, the one so-called gang expert we saw during the Daubert hearings a few months ago, there has been an additional two gang experts that have been approved as experts in this trial that will, according to the Daubert hearing, will testify to that certain hand signs, certain colors, certain words are gang related explicitly to the YSL people. Do I think it's proper? Well, prosecution can do whatever they want to try to prove this. But for me, it sounds a lot far-fetched because some of the signs that is shown in the videos and stuff like that, I mean, I've seen those signs in pop culture for decades, long before these people used it. So that's up to the defense to bring up.
Through a pattern of racketeering activity, to be a part of this group, to gain ill-gotten goods through crimes listed in this indictment. I don't even have to use the word racketeering. I don't even have to use the word conspiracy. They endeavored to do some illegal stuff to get a bunch of stuff that didn't belong to them. And somebody, more than one, but all we need is one, the evidence will show that at least one person took a step towards furthering that goal. So when you get the indictment, after high.
If that sounds strange, it's because it is strange, but that is the broadness and vagueness of the Georgia RICO Act. They only have to prove that one in this YSL furthered the goal of crime syndicate of sorts. And yeah, that's the Georgia RICO Act.
How long it takes us to get there. And you're looking at 191 acts and thinking, state, really?
I sustain the objection.
Thank you, Judge. I'm
Move
moving
on, move on. That's argument.
The evidence is going to show that these steps that they took are akin to just going out and get some toilet paper to further a conspiracy to go TP a house. Doesn't have to be a crime, it's just action. The evidence is going to show that the defendant Jeffrey Williams' words and actions also betray his participation in the conspiracy. I expect that you will hear from a YSL associate and member at trial that the defendant Jeffrey Williams rented a car, notwithstanding that Jeffrey Williams had his own cars, but he rented a car which happened to be a silver Infiniti sedan, that other YSL members, among them Delonte Kendrick and Shannon Stillwell, used when they openly and notoriously gunned down Donovan Thomas on January the 10th of 2015. The evidence will show that after that horrific act, I expect yet another YSL associate will come in here and tell you that Jeffrey Williams paid them money, gave them money to go to Miami and lay low in the wake of the Donovan Thomas murder.
Yes, under the RICO charge, they have 191 acts. And again, none of them they have been charged for between 2012 and 2021.
Later that month, on January the 26th of 2015, Demekion Garlington, who isn't before you for your consideration today, but who is in fact a YSL associate and co-conspirator of these defendants, he posted a video of the defendant Jeffrey Williams looking into the camera and saying these words. So, I'm gonna lie to their mama, lie to their kids, lie to their brothers and sisters, and then get right into the courtroom and tell the God's honest truth. Don't get it. Y'all need to get fucking killed, bro. That's from me and YSL. The defendant's words tell you that there is an enterprise. The defendant's words establish his willingness and agreement to participate in this enterprise through illegal activities. He didn't say that's for me. He said that's for me and YSL. And as the evidence will show, that's akin to him saying that's for me and my pack.
Let's go back.
The evidence will show that's akin to him saying that's for me and my pack.
I expect you will hear. That's lawyer speak. That is because they will call a witness, but they don't know what that witness will testify to. And the quote, I don't know where it comes from, if it's from a text, from an email, from a song, I have no doubt. And I mean, in every society, there are figures of speech. Don't know if that is something they regularly said without anybody getting killed, but you never know. And here we have, this is a lyric. We didn't chase This is, we didn't chase the lyrics to solve the murder, we chased the murder and found the lyrics. Here's the thing, this alleged murder took place 7 years ago. And yeah. And you see, for instance, how these quotes are back to back. That means they are taken out of context in the actual lyric. Dear YouTube, these are lyrics. Yes, it's not me. I did my my dramatic reading of Young Thug lyrics in Friday's stream a few days ago, and where I did the hot lyrics and halftime lyrics with music that may not have been the original. And if you want to have a good laugh after this, you go see that stream, the first half hour, and see the whitest man on the face of the planet do a rendering of Young Thug's mumble rap. Here it is, but yeah. But let's continue with this.
Kendrick's and Williams' words, there's been a lot of talk about lyrics, but y'all, the evidence are going to show in this case, we didn't chase any lyrics to solve any murders. Law enforcement in Fulton County chased the murders and found the lyrics.
And never brought charges.
They're investigating, they're finding out who committed it. And after doing all of that, they happen upon lyrics. Lyrics that have an uncanny similarity to very true and very real and quite specific events, as the evidence will show. Jeffrey Williams' words that he promotes through songs with beats behind them, they aren't random. He tells you, as the evidence will show, take this shit to motherfucking trial. I rep my life for real. For slimes, you know I kill. Trial, I done beat it twice, Kendrick's. I'm undefeated, like feds came and snatched me.
If she ever charges a group of comedians, because they slay on stage, they kill it, and they bomb. See what I mean? Sometimes words in lyrics are not what you think they are. Just saying.
No point in asking. I was on what? Believe it. Stuck like a magnet, bitch ass nigga. I shoot at your man, you need to stand down. I up my stamina, take it to trial. Get an appeal, take it to trial. Yeah, you're gonna whack him. Pay for that casket, that's just if we whack him. My young niggas pulling up. Bentleys, Austin Martins, rarest Teslas, strapped with an FN. You're gonna hear a lot about FNs.
What is said in a trial setting is not public domain, but you can say them. The lyrics themselves are copyrightable as a lyric. So is whatever music they put to it. And yeah. I do not and cannot give any legal advice. Mainly because I'm not a US based at this. But even if I was, I do not give legal advice. And nothing I say here can be construed as legal advice. And most of you who listen in, I can't represent you because I'm in a different country. And even if you were in Sweden, you have to be a part of the union I represent.
FNs galore. From here to 2015, FNs all throughout the incidents that are involving gang members YSL. Watch me whack that bitch. Pop him like a sis. Glock with the assist. Incidentally, the gun at the home of Jeffrey Williams on May of 2022 that had been modified with that switch, it was a Glock. Again, we didn't chase the murders. We didn't chase the lyrics, rather to solve the murders. We chased the murders, as the evidence will show, and in the process, we just found the lyrics. Jeffrey Williams' words and actions further reflect his agreement to participate in this organization through this criminal activity. He tells you, we committing them crimes. Hop out and shoot. Roll one up for the gang. He's not using gang colloquially. The evidence will show he's telling you they are a gang. You want to be slime? Children of Fulton County, go catch you a body. Me and Lil Bro. The evidence.
How would you expect evidence to show, madam?
It is indeed, Your Honor.
All right, I will rule the objection.
The evidence will show that when Jeffrey Williams is saying me and Lil Bro, we used to steal from the store, we had to stick it and go. He's talking about himself. The evidence will show that this is the man, through the music, that he has been blessed with the opportunity to be able to release and gain wealth from. Through that music, through that blessing, the evidence will show that Jeffrey Williams led the group of people that wreaked utter havoc on Fulton County. Jeffrey Williams' words and actions, as the evidence will show to the members of his gang, you'll hear in a conversation he has with them, y'all ain't beat him up or shouting at y'all, he's getting soft. The evidence will show that there's no place or need for that kind of edict or statement when all you're doing is making music. And to clarify and put a very clear and fine point on it, the evidence will show that no one is attempting to take away from Mr. Williams the fact that he has had a lucrative rap career. The evidence is simply being put before you to show that he is guilty of committing the crimes that are laid out in this indictment. That he and his fellow YSL-gang members and associates on trial before you now agreed to participate in this organization through the illicit and illegal activity listed in this indictment. And that they further committed all the other crimes listed in the indictment beyond count one. Because as you'll see, count one consists of 191 overt acts. Acts that aren't all crimes, they're just acts. But counts 2 through 65, the ones that have these defendants' names on them, are the ones you're here to evaluate whether or not the state has proved. Actions and words, words and actions. The evidence will show that this was Donovan Thomas in life, that on January 10th at 2:15, about 7 o'clock in the evening, Donovan Thomas
years ago.
was living his best life. He was up at the barbershop at 330 McDaniel Street. He had paid for a bunch of people, a bunch of kids to get their haircut, and you'll see that he is out there enjoying himself. The last
did he do something for the
actions that he
community?
took while he was fully alive and healthy, joking with his friends. You'll see that they didn't even see it coming. You'll see evidence that Donovan Thomas was literally in the middle of lapping it up with his friends when a car drives by and opens fire on him and whoever else might have been in close proximity to him. The evidence will show that this act wasn't done secretly, it was done openly, notoriously, almost as if to send a message. We did it. The evidence will show everybody knew who did it, because it wasn't done secretly. The evidence will show that this act didn't happen in a vacuum. There were things that led up to it. An argument at Club Crucial or Club Brucial, as my defendants may like to say, that involved a YSL associate by the name of.
And we welcome back Mo.
Did I just hear her do what? What am I listening to? I'm over here trying to put a roast into the Instant Pot, and I'm over and, yelling at kids to do their homework, and I'm hearing, "We didn't, put pimps on a blimp because, we wanted to. We just, happened to find that, pimps were on a blimp." Good God almighty.
Yeah.
Which are we on slide number 8 now?
I have no idea because they have shown us 3, but she has been pointing at multiple slides.
I mean,
So
also 10, when you push a force multiplier, 10 freedom seeds do not come out. That is not how any of this. Prosecutors should have to go to the range. I don't know why we have to have. There's semi-automatic, which means 1 pull, 1 freedom seed. Burst, which means, 1 pull, several freedom seeds. Fully auto means I mean,
yeah. And I don't know, I'm suspecting that the machine gun she's referring to is an altered ordinary gun from semi-automatic to automatic.
Yeah, it was probably something where you kind of did an illegal modification and, you went from, to burst. You went to burst or I'm trying to Flux. Only if you pay me.
Yeah, go over to Most channel and like everything she's ever done. Mo in the deep end. Subscribe to her. I would consider that a personal favor. But we are 6 minutes behind plus change, so we kind of need to catch up.
Sorry. Oh my gosh.
Hopefully there's an afternoon break.
Yes.
And a member of a rival gang. Kenneth Copeland gets jumped. He's flashing money because that's what they do. It's ladies fight night and they're out there flashing money. Kenneth Copeland gets jumped. Diamante Kendrick jumps into action, goes to Kenneth Copeland's defense, punches out a member of the opposition, and then shots are fired. Shell casings. Shell casings are all throughout the evidence that you'll see and hear in this case. Remnants of the violence inflicted on this county by YSL and its actions. Shell casings are fired in between January the 6th and 7th of 2015 and January the 10th. Other incidents take place and they lead to the ultimate gunning down of Donovan Thomas. As the evidence will show in the ensuing months, there were series of shootings and retaliatory shootings. Most notably, the mother of rapper Rayshawn Bennett gets shot. Her house is shot up twice. She gets shot one time. And the evidence will show that there is not always cooperation because there is a code that people adhere to when this type of violence is surrounding them. No snitching. So the evidence will show that even as people were getting shot, even as people were bleeding, even as people were being taken to the hospital to have their wounds attended to, they weren't always forthcoming. They weren't always willing to talk to and to trust law
That's
enforcement,
burden shifting
not even
again.
if it would serve their own purposes. The
We
evidence
can
will show
expose them because they didn't
that
talk.
members of YSL ultimately, as a result of those shootings and retaliatory shootings, ballistics or firearms matches started coming back to various people. And then one YSL member, Quindarius Zachary, he gets caught with a gun. The shell casings from that gun go to match some of these shootings. Quindarius Zachary is caught. He starts telling. The evidence will show that Quindarius Zachary was a straw purchaser for YSL. A straw purchaser is nothing more than somebody who goes and gets guns for somebody who's not supposed to have them. And that's what Quindary Zachary did.
I already beat you to it, Nicholas.
I say this in every trial of this type when they are claiming we can match this with that. Tool mark analysis is not a science. It's a subjective opinion based on shit evidence. Okay? I will come back to this, especially when they call these hacks. But for now, I'm just putting it in there. And there are trials or convictions moving upwards in the appellate courts. One or two might be on the way to the Supreme Court about the absolute crap that tool mark analysis is. If you want to know more about tool mark analysis, go watch Rumble of the Bailey, and especially about the test that he is. He has a tool mark guy test that he and a few others are collecting donations for, where tool mark guys will get a few bags of spent bullets and a gun, and there could be 0 bullets matching that they know was fired from the gun. It could be 5, it could be 1, it could be 7 in a bag of 20. But if the tool mark guy claims science, then he or she should be able to decide which one it is. And I can almost bet money that nobody will take that. But give us time and maybe absolute perhaps money to conduct these and force these tests on this community and make it standard. If you claim to be a tool mark guy scientist, then you need to go through with that kind of test. But now we are getting behind again.
Firearms found in the hands of Kenneth Copeland led to further revelations to the police and law enforcement.
At this rate, 2026.
Members of YSL were so eager, so gangster about acting on behalf of and in the protection of the defendant Jeffrey Williams and YSL, that when Wayne Carter, otherwise known as Lil Wayne, came to town to perform at the compound while the defendant Jeffrey Williams was performing in Lil Wayne's hometown, according to word from the people that talked getting booed at the time, members of YSL show up at the compound, locked and loaded with guns. Evidence will show that security knew to be on the lookout for members of YSL. The authorities were alerted to ongoing public rifts and back and forth between the defendant, Jeffrey Williams, and members of his gang, and statements being made.
Were they having a rap battle? That sounds like a rap battle. Unless, well, if shots are fired after. This might be the case where we will see if this is the case where the prosecution alleges that this was an attempt act, but in the hearing, the police report said this was a justifiable shooting. We will see if it is that one.
Publicly on social media about, towards, and threatening Wayne Carter. So when Tyrone Dennis, who is working an extra job, he is a law enforcement officer. At the time, he was an investigator with the Atlanta Police Department gang unit. So when he's there working his extra job, and he sees Walter Murphy, one of the founding members of YSL, show up with the defendant's sisters and Trontavia Stevens, and ultimately Jimmy Winfrey with guns. When he sees Walter Murphy try to secret a gun underneath the wheel well of a car, He calls him out. He's like, what are you doing? Walter Murphy's like, oh, hey.
No, that's not that time.
The evidence will show that the YSL-gang members that showed up at the compound that night were not allowed entry into Lil Wayne's concert, his venue. So what they did was they waited until Lil Wayne leaves, gets in his tour bus, and is attempting to leave the area.
That's a
They
bunch.
get up beside the tour bus and they unload bullets into the man's tour bus. Bullets. For nothing, except to show their dominance. There will be no evidence that Lil Wayne threatened either of them that night.
You mean they didn't just pee on it?
But that act on the part of Jimmy Winfrey and the defendants before you today, that act was intended to show their solidarity, their willingness to act on the behalf of, their willingness to exact violence upon anyone who threatened the position of the criminal street gang calling itself Young Slimelight. You'll hear evidence that after being arrested, or actually when he was approached back in 2014 about an armed robbery he allegedly committed, YSL member and associate Trontavia Stevens was seen bearing tattoos on his hands, ROCCREW, Cleveland Avenue. And that on his side, he had YSL. And Detective Mark Belknap inquired of him, what's that? Though Belknap knew, because he had been working in the streets of Atlanta for a long time. He was familiar with RICO. But as gang investigators, they're taught to interact with and talk to people when they see indicia of criminal street gang activity. You'll hear that Trontavia Stevens told Belknap, well, Rock Crew is the name we used to call ourselves. Then we started going by YSL, which stands for Young Slimelight, or it did stand for Young Slimelight. But then, when my friend Jeffrey Williams started becoming successful, he changed that name to Young Successful Life. The words of a member of the gang himself. The only time, as the evidence will show, that members of YSL don't want to call themselves and acknowledge that they are in fact the gang is when it would be to their detriment. The evidence will show that any other day of the week, they are loudly and proudly promoting their criminal activities. Donovan Thomas, he was driving this Chevrolet Tahoe the night he was gunned down. The evidence will show that this location here is the barbershop right up from the Texaco at the corner of McDaniel and Northside Drive in Atlanta, Fulton County. We asked you during one year, you heard us say, how many of you are familiar with this area? This is that area. The evidence will show that that is the way that Donovan Thomas looked last time his loved one saw him. That his life was swallowed up in that crater created by YSL in the Cleveland Avenue community. And the words that they found while looking into this murder, spoken by members of YSL. We don't speak about shit on wax, but indeed they do, as the evidence will show. They just kind of thinly veil it. We are known to kill the biggest cats of all kitties. Donovan Thomas in the community, he was a big homie. He was a friend to a lot of people. He was a big deal. And it touched a lot of people, as the evidence will show, when his life was taken. The words that were spoken, we known to kill the biggest cats of all kitties. How coincidental that Donovan Thomas was gunned down. And these were the words later spoken by members of YSL. The evidence will show that it's not coincidental at all. 100 rounds in a Tahoe. 100 rounds in a Tahoe. The evidence will show that the lyrics released by YSL members, the lyrics they chose to speak, they bore a very eerie significance to real life. 100 rounds in a Tahoe. And you'll see that Donovan Thomas's Tahoe had bullet defects all along the back of it when they sprayed Donovan Thomas and his car on January the 10th of 2015. That slime shit, killing
Nobody in
12
the
shit.
YSL was ever charged with it.
The evidence will
until
show
now.
that 12 is the word that is commonly used to denote law enforcement. And speaking of the young people whose innocence and whose lives were swallowed up by that crater created by YSL, Christian Epinger. He's not before you today, but he is a co-conspirator of these defendants. He is a YSL member and associate who got YSL tattooed on his face at the tender age of 15. He reps YSL continuously and notoriously throughout his social media. The evidence will show that at the age of 16, he, along with an accomplice, robbed a young woman by the name of Taradia Hill at gunpoint in front of her child. And that at his sentencing hearing, Taradia.
Around people who are famous, there will always be hangarounds that do a lot of crazy, shitty, and stupid stuff. Check. I mean, you have women or girls tattooing their face with pop acts. You have, I mean, there's everywhere. Now, we will see if the evidence actually shows what she is claiming, or what the state is claiming. That's a good point. Why did you include... it's the state's opening statement. And so far, well, except all the shenanigans earlier today, not many objections.
Seeing a young black boy who could have been her brother, cousin, she actually advocated for Christian Epinger's lenient sentencing. So Christian Epinger, he wasn't sentenced on what he was originally charged with. With the acquiescence of the victim, Christian Eppinger received a lesser sentence. He went to prison for a short time, and within less than a year, he committed an armed robbery. And when law enforcement officers are out there looking for Christian Eppinger, who incidentally constantly posted on social media with guns and his gang signs and the green emojis with the gun pointing to the camera or to some other emoji talking about how he reps hard for YSL. When law enforcement officers, specifically a law enforcement officer just 30 years old by the name of Officer Rogers, when they go to apprehend Christian Eppinger on this armed robbery he committed after being released from prison, having robbed Taradia Hill, they do everything they can to take him in without causing any harm to Christian Eppinger. But you will see that while he's being taken into custody, what Christian Eppinger does, he takes the firearm of this young officer. He pulls it out of the holster and he fires, putting 7 bullets in Officer Rogers. The evidence will show leaving a law enforcement officer with PTSD after he has tried to humanely apprehend a member of YSL. The evidence will show that this person depicted here is Fontavious Greer, also an associate, but perhaps more importantly, the brother of the defendant, Jeffrey Williams. Christian Eppinger was so deeply entrenched.
I'm 6.5 hours, my alarm bell goes, so I'm putting up the sign. Dave, this is the Dave signal, because I kind of need him to prepare to take over this stream so I can get a few hours of sleep, because I work tomorrow and then I have day 2 to stream, so I kind of need to have a few Z's in here. But
just tell him you're going to buy a jet ski. He will show up immediately.
I have more than one day signal. Let's continue here at least.
Ingrained with loyal to YSL, he's even posting free bitch as Fontavious Greer served a sentence for murder. Who said they want smoke? Christian Epinger, as he's calling himself YSL Briss. Note that Chris does not start with the letter B, but it does when you're associating yourself with a criminal street gang who aligns itself with the Bloods.
Here we go.
And that's the tattoo that Christian Epinger on the side of his face proudly publicized on June 27, 2015.
That's a tattoo? It looks like a freckle. I mean,
Or a birthmark.
yeah, I mean, I'm not trying to be a butthole, but
That's maybe.
I would get my money back, sir. Possibly. Look, but
He wasn't even 16 yet. New ink with a green snake emoji and a red heart.
Have anybody ever heard about 16-year-olds doing insanely stupid things like getting a tattoo?
The evidence will show that.
16-year-olds being
So you'll
stupid?
hear over and over the names of the 6 people on trial before you today. That the 6 people on trial before you are not the people who were
I'm not
most
saying tattoos.
viciously
must be-
affected
I'm
by
saying
the acts
getting a face tattoo
of
at
this criminal
16
street
might
gang.
not be an intelligent choice.
The evidence will show how far members of YSL are and were willing to go to act immediately on behalf of each other. Dexter Montgomery, minding his business, happened to drive in just a little too closely
Hi,
behind
Dave.
another YSL
Can you
associate,
prepare for taking over the stream?
who then phoned up the gang who's posted up at the trap house.
No,
And then
Dave, this trial continues to 6 p.m., but I have to get at least a few hours of sleep before my alarm bells goes off in 6.5 hours. So that would be 4 p.m. your time, which is in 10 minutes.
minutes, 2 more YSL associates showed up with a long gun and handguns. Dexter Montgomery had no idea he was about to lose half of his head that day. As Dexter Montgomery left the gas station, 2 YSL associates followed behind him.
Allegedly.
And as he stopped at a red light, they opened fire. Miraculously, the evidence will show that Dexter Montgomery survived, but literally half of his head is gone. You'll hear from and see Dexter Montgomery during the course of this trial. The evidence will show that after that happened, law enforcement, at first it wasn't the gang unit, but the gang unit recognized some of the players, Walter Murphy, other members of YSL. And so they began to assist in the investigation. And they learned, the YSL gang members said, we got a call that one of us needed some help. He didn't know who this was pulling up behind him, so we just responded. You'll hear that investigators, Gaither and Dennis, said, well, wait a minute, did you know what you were responding to? They're like, no, we don't have to know. If our boy need help, we're gonna respond. They said, well, where'd you get the gun? Oh, they're by the door of the trap house that we were in. They're just there, ready for us to use when we need to. Their words, I can't make it up. The evidence will show that actions of YSL gang members and associates on behalf of their leader, when they felt someone disrespected, Jeffrey Williams or any other member of their gang,
Bible verse later.
they made threats. Not quiet, whisper threats, loud, public threats with wide, vivid displays of firearms. We're not going back and forth. There's about to be some Biggie and Tupac shit and shooting up Wayne Carter's tour bus. The evidence will show that all of
if, say I had access to a lyrics central and I entered the words Tupac and Biggie, how many lyrics do you think I would come across from the last decade? More than 2 is my guess.
What is all, Alex? What is all?
Yeah. I mean, I would assume more than one artist are using those names in their lyrics, including shooting and crap like that. Yeah, that's my alarm going off saying you need to get some fucking sleep.
Okay,
if you're
he
going
said
to
he's
survive this week.
going to his clubhouse.
Good.
Those actions, they're not elements of the offenses that are charged in the indictment. We don't have to show those things in order for
All this evidence that she's claiming they will show, and the people that she's pointing at were never charged when this happened or the years following. Not until this RICO trial.
Yeah.
for you to find them guilty, but the evidence will show that those things prove the existence of the conspiracy, of the agreement itself. The agreement on the part of these defendants and other charged and uncharged co-conspirators to be a part of this organization known as Young Slime Life through a pattern of this illegal activity outlined in the indictment.
And
there are numerous victims that you're going to hear about. Shannon Stillwell is another defendant who is before you, being accused of various crimes in this indictment. Shannon Stillwell is alleged by one of his own crew, by another YSL, two other YSL members, to have been one of the gunmen who took the life of Donovan Thomas. The evidence will show that Shannon Stillwell was arrested. He was arrested after some investigation by the Atlanta Police Department. The evidence will show that the information initially relied on by that first arresting officer, it didn't pan out to be actually accurate. So when the case got to the district attorney's office, more investigation was conducted. The evidence will show that the office didn't just take the word of the person who originally identified certain people.
this is, I told early in the stream about this particular case when the person pointing at some of the defendants back in 2015 said, I saw them at that bus stop. There was surveillance camera over that bus stop and the defendants was never there. So during the Daubert hearing, one of the first Daubert hearings I covered, that prosecutor that will be a witness said there was nothing to charge them with. So when she says evidence will show in this, at the time and a year later, yes, these two was arrested. They were released just days later because they found out the state's eyewitness lied. And here we are in the RICO trial saying evidence will show that.
As having committed the murder of Donovan Thomas. Instead, as the evidence will show, what our office did was dig. dig to find out whether the people who were talking were actually in a position at a place to know the stuff that they talked about. And what they learned was that that person originally relied on by Investigator Thorpe, that person was just lying.
Yeah.
And so the people that Investigator Thorpe originally arrested on the Donovan Thomas murder, they were released at various times on bond as the office continued to investigate further. The evidence will show that our office did not just stop at the word of one YSL member. The evidence will show that yet another accomplice corroborated the words of the first YSL member that talked. The evidence will show that cell phone records further corroborated the information law enforcement was getting from these people. And ultimately, Shannon Stillwell, Demonte Kendrick, Justin Cobb, Javoris Bradford, they were all indicted in this particular instrument that you'll have for your consideration. But the only two people who are in front of you for you now to determine whether or not state has met his burden
now, and not even separate charges for murder, but please convict them on shit evidence and lying eyewitnesses because we are doing it.
However, between the time that this indictment came down and the time that our office decided, no, we need to look into this investigation some more, Shannon Stillwell was released from jail. But he had to wear an ankle monitor as a condition of his bond. The evidence will show that during the time in 2015, after a lot of arrests were made following the murder of Donovan Thomas, that the violence in Fulton County, the gun violence that had continued over the course of that year, it kind of subsided a little bit.
Basis. I sustain the objection.
Yes, Your Honor.
But you already
the
said
evidence
it.
will show that around 2019, 2020, law enforcement investigators, they started noticing some activity on the part of gang members. They started paying particular attention. One of those investigators was Investigator Marissa Vitorito. You'll see and hear from Investigator Vitorito, and you'll learn that one of her jobs as a law enforcement officer, one of her background experiences was that she was a probation officer, so she had a lot of information about a lot of YSL-gang members.
That would be prior acts,
You'll hear that
which are not allowed.
initially, after Shamel Drinks was gunned down, Detective Hogan with the Atlanta Police Department, he didn't have any leads. As a matter of fact, he came back to the precinct lamenting the fact that he had no leads on this homicide that just occurred at Windsor and the I-20 entrance ramp. Young man killed, gunned down inside his car. When Investigator Vitorito began talking to Detective Hogan, she saw that Detective Hogan did have some footage from the gas station right up from that location. And that
That's
Investigator
half a mile away,
Hogan was
by the
looking
way.
to find the people in the gas
That
station
gas
because
station.
that gas station was the last place that Shamel Drinks was seen alive. One of the people in the surveillance footage was wearing a very distinct hoodie and coat. And as it would happen, Investigator Vitorito had hours earlier been at a Waters Road location, one of YSL's hangouts as the evidence will show a place from which they conducted transactions. And that the Waters Road address had been shot up, and Investigator Vigorito happened upon Shannon Stillwell.
Hi, Dave.
Hello. Okay, how far are we behind on this? I've got the stream up.
We are 13 minutes behind.
Okay, that's fine. I just wanted to get the spot because she repeats herself a lot.
Yeah,
Right.
evidence
I was
will
just
show,
started trying to
evidence
find. I was using the last objection as a key marker, and I'm like, I can't find it, but she keeps saying the same thing.
Yeah. Evidence
Okay.
will show, evidence will show, evidence will show. But if evidence actually showed it, you would have indicted them years ago.
I was going with the key marker thing that she kept saying. The key marker, the key marker. She says that like 40,000 freaking times.
Yeah.
Thus saith the Lord. That's the vibe I get from this woman. But all right. Well, let me present to my screen here. Oh.
No, I don't. I won't ask you the entire week for this. I might simply do a cutoff at 4 p.m. Eastern and do the two last hours the next day. And
Okay.
I don't know if they have court on Friday. Not sure. And either way, we will catch up eventually because we have holidays coming up.
Well, yeah, and you also, I mean, they cannot be streaming. Or not streaming. They cannot have trial every single day continuously for 6 months. That's just not a reality.
Yeah.
So, so that's just not going to happen. But I can pull up my feed. I don't know. We might be repeating ourselves a little bit, but it might just be a minute or two. But at least that's better than missing something.
Yeah.
Hi, Mo.
Hello.
So by the way, I'm like 2 hours ahead of where I thought I was going to be. So I'm talking to courts. I've got client phone calls coming back. So I have no problem taking over. I was just like, oh, now? All right. Get up there.
Yeah, because yeah.
You're tired and I get it.
Yeah. But thank you so much for taking over. And if you need me to do the same for you, I will.
Oh, yes. I appreciate it. And not a problem. We're a big family here.
Yeah.
So. Yes.
You will see me, Dave, Mo, Excited Utterance, Sal, and Baker. We cross each other's paths all the time. So I expect all of you new here to subscribe to all of these people because we have tons of great content for you.
I have access to YouTube too, so I can not only post a link, I can pin it.
Yay!
Ooh.
Hey. Big dysfunctional family. Yes, that is right, sis.
Yes.
All right. Well, let me add this and there we go. Okay, so this is my feed. So we can get going with this and we won't lose as much time. Let me just boost it.
Yeah. Sound is
we are not a gang. We have no hand signs, and we will never go to Georgia.
Yes.
The only hand sign we might have is the.
We do have a hand sign. I will confess, but it doesn't mean what the great state of Georgia thinks it means.
Yeah.
Yeah.
All right.
More of an invitation for self-love.
I'll be diving into bed. I'll be throwing jingles out of my bed and try to get a few hours of sleep.
We'll expect you for the next 2 hours chatting away, I'm sure.
All right.
More like a call. All right. Take care, Nicholas.
Okay. Thank you all. And I will see you all later or tomorrow. Bye-bye.
Okay.
Bye-bye. Yes, we are a cult, not a gang. Got to get it straight.
Blackout.
Tax purposes.
On. Earlier the day that Chanel Drinks was gunned down.
Were we watching it in real time?
Of a rental car. The evidence will show.
I think we can speed her up, to be honest.
Yeah, let's.
Hang
on.
I mean, I can't keep the people straight.
I'm good with 1.25. If it's too fast for anybody, let me know.
That as a result of all of this violence and activity, during the midst of it all, Investigator Vigorito had secured a wiretap for Damikian Robinson, YSL-gang member and associate. She was able to listen and detect hours of the goings-on of the enterprise. She learned throughout the course of her own investigation and during her time looking into YSL that a rival gang member, Rayshawn Bennett, ended up at the Fulton County Jail at the same time YSL gang member Jaden Meyer was there.
Yes, but it's referring to Zachariah Anderson.
The evidence will show that Jaden Meyer, upon seeing Lucci,
You know what? Hang on.
reaches out to get permission from King Slime to take Lucci out. The evidence will show that Jaden Meyer actually endeavored to stab Rayshawn Bennett to death, but that he was unsuccessful. The evidence will further show that Jaden Meyer wasn't the only one reaching out to this defendant, Jeffrey Williams, for permission to commit a homicide.
I have thoughts.
Looking at Shannon Stillwell's words along with his actions, happening upon the lyrics while trying to solve the murder, the evidence will show that law enforcement found one nugget.
What?
Spoken by Shannon Stillwell. I just beat a murder rap. Paid my lawyer $30 for that.
Okay, she's citing rap lyrics. I was wondering how the rap lyrics were going to come in. I'm going to try not to pause too much. But if the evidence is going to show attempted unaliving, why not charge him, that individual, with attempted unaliving? Why the RICO BS? I was wondering where the rap lyrics.
Like they didn't.
He confessed in a rapist song.
Dave, I don't know. I have lost. I need 17 murder boards, 12 things of yarn.
That's what I was saying. Oh my God, to follow these people and what they did and who they did it to. It would be so much easier as a prosecution to say, this person that she was just talking about, I forget the name entirely, attempted to stabby somebody, and then he confessed about it in his rapist lyrics. Okay, charge him. Why?
Well, and then there's charged and uncharged co-conspirators. How do we decide who is going to be charged and who is just going to be let go? And then she talked about, okay, oh my gosh, for Flux, just for you.
Governor.
So she talked about she's like, and they had a gun or a force multiplier that shot freedom seeds 10 times the normal rate. And I was like, that is not real. I was like, you can have a semi-automatic, which goes, one pull, one freedom seed. You can go burst, which, usually has multiple freedom seeds. And then you can have, fully automatic, which, the ATF made totally hard to get, which goes just for you, Flux. But 10 times. Can all prosecutors and lawmakers be forced to go to the range?
Oh, God, I know. I've been so frustrated with this, and I've been relatively silent because I knew at some point I was going to take over, and I didn't want it to keep popping in and out. But this woman, this whole idea behind this prosecution is frustrating.
After he was released on bond for the murder.
Did you want to say something else?
No,
okay.
I am so confused as to who did what with where and how 1892 is even allowed. I'm just
of Diamond Thomas. And before he actually took the life of Chanel Drinks. The evidence will show that the young man on the left is Chanel Drinks in life. And that the photograph on the right is what was left of Chanel Drinks after YSL and the crater it created in the middle of the Cleveland Avenue community took that life from his family, friends, and loved ones.
Oh, I felt so bad. I thought
I said
Chanel
a
was
lot,
a girl.
and I'm not the only one you get to hear from today. So you might be happy. I'm about to sit down. I want to ask
I'll be
you
very happy.
to make use of those notepads and those pencils that you have in your possession.
All
The court's already given you the instruction to take notes.
all day, Brandon.
Rely on your memory. Use the notes to document and help you remember after you've heard weeks and weeks and weeks and scores of witnesses who said what. I expect that as you listen to and evaluate witnesses who come in to testify, there will be witnesses who you discover change their stories from the time they first made a statement to the time they actually have to appear here in court, in public, and telling folks. I expect that the evidence will show that there are some witnesses you will assess are just scared. Some are embarrassed, some are intimidated, some don't want to remember, some just plain don't remember. The court alone gives you the law on how to deal with and how to assess those witnesses.
Does anyone have this woman's
I only
name?
ask that you follow closely the instructions that the court gives you.
Last name Love. I don't know the first
Look
name.
at who the witnesses are. Look at who they look at while they're on the stand. They don't look at or won't look at while on the stand. Look at how they answer questions posed to them from the state versus questions posed to them from the defense. And if the occasion arises that you find that a witness as presented in court says something different than what they said previously, you determine why it is you believe that they said something different once they got in court. Words and actions. The defendant's actions coupled with their words. They prove the existence of the enterprise. Their actions and their words, the evidence will show, proves their agreement to participate in this enterprise through these illegal activities outlined in the indictment. Preserving, protecting, enhancing the reputation, power, and territory of the enterprise through acts including murder, assault, and threats of violence are what the evidence will show these defendants did over the last 10 years. The evidence will show that the violence didn't stop in 2015. Preserving, protecting, and enhancing the reputation, power, territory of the enterprise by the posting of messages, images, videos, and songs demonstrating their allegiance to the enterprise and a willingness to engage in violence on its behalf are what you'll see evidence of over the course of the next several weeks. Maintaining armed individuals.
I don't want to screw up Nick's settings and all that stuff, but I do like Brandon's idea. I just want to zoom in on the court reporter and the judge while this woman is talking.
And willing to preserve, protect, and enhance the reputation, power, and territory of the enterprise through the use of violence. It's what the witnesses and the evidence you will see proves to you. Obtaining money and other property through illegal activities like robbery, theft, and illegal drug sales and distribution. And obstructing law enforcement, killing 12 shit. Investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. You'll see it for yourself. The children whose innocence this organization claimed as its own. And in the end, the evidence is going to show you that YSL is a RICO enterprise, nothing fancy about it. The evidence is going to show you that it's also a criminal street gang. Those two are not mutually exclusive. That these defendants participated in this enterprise in a way that had nothing at all to do with the record label, except maybe their actions as reflected in their songs made their music more real and perhaps more appealing to somebody. The evidence will show that the defendants, they talk about YSL while they talk about the crimes they committed. And while they talk about the crimes they're going to commit, you'll see that this
Didn't we address this with Marilyn Manson like 30 years ago?
It's a criminal organization. The
We don't
defendants have been
remember
associating
history.
together for many years, committing crimes together against the general public, against rival gang members, as the evidence will show, against law enforcement, and against each other. The evidence will show they agreed, they willingly participated in these activities. In the end, the court has told you and will tell you again that you are to evaluate the evidence and apply that the law the court gives to you to that evidence and render a verdict that speaks the truth. I expect that at the close of this evidence, you'll see that the defendant's presence, companionship, and conduct during
She is filibustering
all of these
her own
illegal
opening,
activities,
isn't she?
Their words and their actions not only show the existence of the criminal enterprise called YSL, it also shows the conspiracy. And in the end, we're gonna all come back and make our arguments to you. But the one thing that I'm gonna be doing, our team will be doing, is asking you to uphold your duty and render a verdict, the only verdict that speaks the truth, and find these defendants guilty of each and every crime.
Come on,
listed this
get there.
indictment alleged against them. Thank you.
Oh God, it was like.
Ladies and gentlemen, we've been going a minute. You want to take a comfort break? Anyone? All it takes is one. Okay, all right. 2, see, and then everybody else will go through that.
I only hear. It's weird. I only hear the court audio in my right ear. Is that just me?
Oh, wow. Well, I only ever put one earbud in, so I don't know.
Okay. It's like really loud in the right ear and then like nothing on the left. See, it's like, oh yeah, we were behind. Now we'll get caught up. Oh, good. Let's get caught up to live where we're still looking at the seal of justice. By the way,
moderation. Georgia doesn't know moderation. 784,000 witnesses.
When the judge, by the way, turns to somebody and says, "Do we need a comfort break?" He needs one, right? He wants coffee, has to go to the bathroom, do something. The judge wants a break. So just FYI. But I broke my Lady Justice the other day.
Oh no.
And if you guys don't know Lady Justice, it's the blind statue holding the scales and the sword. And so I want to reconfigure her as like Shattered Justice to represent a lot of what we've been watching lately. I think that'd be a good opportunity.
Yes.
I got no court report.
I understand.
All right.
Your Honor, if it's all the same to you, it doesn't need to be on the record to mine.
It does.
Oh, for the love of Lemmy, what are we doing now?
I don't know. Of course, after I get on stream, the court follows up with my email, and now I need to respond.
Okay, well,
I'll be distracted for a minute. Yeah.
Okay, well.
It's real work stuff.
Yes, the judge has a service dog. I'm not sure why, but I do believe that we should demand a service dog cam.
I saw that.
All right, starting to everybody back, present, sir. Can I get all our attorneys to please kind of start making way toward your seats, please?
I noticed that there's so many people involved that the attorneys and their parties,
Jurors, are they all ready, sir?
Yeah.
some of them are sitting in the audience.
Mr. App, what do you need?
Yeah, it's.
My understanding, I planned my opening arguments around I'm not using any PowerPoints. I didn't turn anything over the state because I'm planning my opening arguments around using just paper and notes to speak to the jury off of, with the understanding that I was going to have a lectern to speak, to put those papers on in front of the jury. And my understanding was from Mr. Steele that there was a conversation with Captain Kendall last week that a lectern, which is in the hallway, would be allowed to be placed up there so that then those papers could be used. I understand.
Oh my God, man. You're a trial attorney. Just roll with it.
There's some disagreement or understanding about whether a lectern that's out there can be used or not.
I wasn't involved in that particular conversation, but I want to say that also, in order for us to for you to be heard, my suggestion is you probably use the podium. And there's plenty of room on the podium. That particular podium that's immovable, and it's also got a microphone. And you're welcome to walk back and forth. So you can walk around the well. I'll give you permission to do so. You won't bother me.
So I can tilt this.
There's a sign on. Do not move. Do not move. Do not. Yeah, because it's part of our evidence presentation system.
Well, and that, I mean, there is a lectern on wheels that's 20 feet away from here that if we could just move it into the. Well,
you've also got the challenge of you guys from jurors that are available. So jurors that are sitting there closer. So I prefer you not do that. Okay. You have to do the best you can with the table you have. Like I said, you can walk around. You can even put some of your stuff on the edge of the state's table if you'd like to. And also related to that, if there's anybody in the media that is zooming in on any of the things that's involved in any council table, please do not do that. Okay? If you are, don't do it. So just please, I just wanted to make you all aware of that. All right? So, Mr. App, if you'd like to, since all this furniture belongs to me, technically, you are free to put your whatever you need on the edge of the state's table.
Can I use the witness stand when I'm giving my?
Yeah, sure. Absolutely. Absolutely.
I prefer a lectern, but I'm just.
Yes, Mr. Sharp.
This is the person who spent most of this morning trying to procure a lectern. There's also.
You didn't tell me though, and we could have gone through this earlier.
I spoke to Captain Kendall last week. I spoke to numerous members of the sheriff's department this morning, and I was going
Oh
through
my
every procedure that I
God,
was
who
supposed to go
cares?
through.
Ultimately, it's my decision, right?
I understand.
Okay.
There is a much smaller lectern that can easily be picked up and placed here in courtroom 1D. It will literally take 2 minutes.
So I want to move the presentation as evidence. We could have discussed this weeks ago, and we could have gone ahead and planned it. I could have brought it over here and test drove it, but you didn't give me that opportunity. So let's move on.
Okay.
Thank you.
So ridiculous.
Okay, can you bring in the
Anybody else?
packages?
Do you know what time?
No, I don't know what time we're going to, but I'll let you know as soon as I'll figure that out in just a little bit, Mr. Steele. Okay. All right. Who's making the opening statement, Mix? If so. Okay. All right. Let me know when you're ready, sir.
We're just going to set up on Zoom.
Okay. All right. Let me know when you're ready.
Your Honor.
Yes, Miss Act.
I'm gonna see you see.
Kokomo is helping me with this.
That's fine. That's fine. That'll work out.
Fry, quit interrupting.
And Ms. Weaver will yield some space to you, so, okay.
Being most accommodating.
There you go. We aim to please.
Oh, man.
Come on, people. This is like the most disorganized fiasco I've ever seen of a trial. I don't even know what to say about it. It's nobody seems to be prepared. Okay, so this defense attorney, let's say he has sat there all day waiting for his chance to give an opening statement, and he waits until his opportunity to say, "Oh wait, where's my lectern?"
Well,
Why are you not looking at that at 9 a.m.?
That are, again, I'm so type A. I would have, as soon as I came in, say, hey, I like to, do my opening statements with a lectern. Is there going to be one available?
Well, you had all the breaks. You had the lunch break. You had all these other times. You had to think about it ahead of time and then arrange it. If it's that big of a thing to you. Plus,
I think he said he's ready.
You're a trial attorney. Move on the fly, man.
Can we summon our juror sergeant, please? All right.
Oh, for the love of all that is holy. No, we can't. We're going to be here till 2073.
Over under on the number of pew-pews in the peanut gallery? 5.
I'm going to go 6.
All right. You playing the Price is Right game? The Price is Right. You always like the last person to go just bids $1 more. Oh, for a second, it scared me. It looked like a man's head was growing out of Nick's arm in his logo. Oh, I have control of all the Nick stuff now. This is cool. Does he have it? Yeah, see, I could just do this. Oh, wait. Whoop, that's the wrong one. There we go. I am the captain now.
All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, does any member of the defense wish to make an opening statement this time?
I would, Your Honor, on behalf of Mr. Still.
All right, Mr. Sharp, you may proceed, sir.
Thank you, Your Honor. May it please the court. Good afternoon. My name is Max Shaw, and along with my co-counsel, the gentleman with the white hair back there, his name is David Botts.
Hey, Vahala.
Together, we have the honor and privilege of representing Shannon Stillwell.
Shannon Stillwell is an innocent man. He's been accused of the murder of Donovan Thomas in 2015. He is not guilty. He's been accused of a murder of Shamal Drinks in 2022. He is not guilty. He has been accused of conspiring to violate the Georgia State RICO law. He is not guilty. Now, I am going to deliver an opening statement that will preview what I believe and what I believe the evidence will show in this case and the evidence that will come in trial. But before I even start previewing what I believe the evidence will be, I want to discuss with you some preliminary matters regarding this case. The first preliminary matter that I wish to discuss is my client's name. Okay? On the indictment, you will see, when you look at the indictment, that my client is listed as Shannon Stillwell, also known as Shannon Jackson. Okay, and there's a simple explanation for that. You will learn that his mother was a Stillwell, but he was raised by his paternal grandmother, Betty Jackson. So at times, he's been a Stillwell, at times he's been a Jackson. He's indicted as Shannon Stillwell. I know him as Shannon Stillwell, but throughout this trial, some people may say Shannon Jackson, some people may say Shannon Stillwell. I may slip up and say Shannon Jackson. But we're talking about the same person, Shannon Stillwell. Second preliminary matter. It has not been lost on me that my client, it's not lost on any of us, that my client is charged with 2 murders in this case. He's charged in 2015, and the evidence will show that he was wrongfully accused. And that case never went to court. He was accused in 2022, wrongfully, based largely on assumptions made about the 2015 case. We plead absolutely not guilty. With our backs straight and our eyes wide open, we plead not guilty to those charges. And
Well, at least you
finally,
aren't
ladies and
slouching.
gentlemen, as far as preliminary matters, as you probably have realized through jury selection and the fact that we have some visitors from the prison.
Did everyone freeze or is it just me?
Wait, am I good?
I think you're good now.
Okay,
Is the
I don't know
trial-
what happened. No, see, I'm working. I'm just trying to do too many things. Okay, let me just focus on this.
Drawn some attention. But the thing I want to stress is that this case
Cranberry
is
wine
no different
for the
than
win.
any other case in the state of Georgia or the United States of America as far as criminal cases go. And it has the same ground rules as any other case tried in this great union. The ground rules of this case are that the defendant, Shannon Stillwell, and all the other defendants are presumed innocent. The state bears the burden of proving their case against all the accused individually. And the state's burden of proof is the highest burden in our system, beyond a reasonable doubt. Beyond a reasonable doubt.
I like this opening so far. Has the audio been mixing up like this all day?
Yeah. No, just now because it's going in and out.
Ladies and gentlemen,
one by one.
the state started talking in their opening about about colors. About colors and hand signs and different markers and gang activity and all the rest. And I anticipate that the state will attempt to bring in colors and their belief about what
They're not be
colors
black and
mean
yellow.
in this case. Throughout this case, I'm going to ask you to focus on a couple colors as well, just to keep in mind as you hear the evidence. Okay, the first color is dollar bill green. Dollar bill green, as you may guess, is the exact shade of green that the U.S. government uses when printing U.S. currency. And the evidence in this case will show that many of these young men grew up without dollar bill money. The evidence will show, and you'll learn about different areas of Atlanta, Capitol Homes, Jonesboro South, places that have since been revitalized in some ways, but back 15 years ago were not nice places, places in despair, lack of opportunity, poverty, lack of positive role models. You'll hear about Shannon and his upbringing. You'll hear that he grew up in the Forest Cove Apartments, which has since been condemned. And he was raised by his paternal grandmother, Betty Jackson. He couldn't live with his mother who had succumbed to drug addiction, and it was his paternal grandmother, Betty Jackson, who raised him. She raised him in the Forest Cove Apartments, and you'll hear that she loved him, poured love into him, called him her sweet thing, and he called her mom because she was mom. You'll hear that despite the love and guidance that Miss Jackson tried to pour into Mr. Stillwell, at the age of 14, without other people providing him guidance, he dropped out of school. And he decided that he wanted to be a rapper.
I believe it's pronounced rapist.
You'll learn about the rap industry in this case. And you'll learn, and you probably already know this, but becoming a rapper is not the same as signing up for a job at Home Depot, where you work for 2 weeks and you get your first paycheck. When you're chasing superstardom in the rap game, those paychecks might not come for a long time. And sadly, they may not come at all. It might be a dead end to nowhere. You'll learn about the vast numbers of young men with the same dream as Shannon and how the supply of potential rappers greatly exceeds the demand for superstar rappers. I was really a bad occupation to try to get into when it really comes down to it. But Shannon was 14. And you'll hear how he tried to hone his skills and try to make it in the rap game. But you'll hear that Shannon, like many other young men chasing this same dream, weren't making any money. And bills have to be paid.
I can see that as Nick on both.
Kids have to eat, and rent becomes due. In this case, and we're not going to hide from it, the chase of dollar bill green turned into a different shade of green for Shannon and many others. That type of green, that shade of green is called bud green, which is actually a color. You can paint your house bud green. But in this case, of course, bud green stands for marijuana. And you'll hear,
for God's sake, David, stop it.
How Shannon,
what is this guy
trying to make it in rap? So
wait, what was that?
Devil's lettuce green? Are you kidding me?
Bud green.
Also, I'm making Mr. Mo paint his room bud green now.
Definitely bud green. Why are these colors so important? I don't. If you got to go to the colors that they're painting their house or whatever, you've got a weak case. I'm sorry, State.
Because this is the dumbness that we have had to deal with all day today. It's, young, successful life. It was the rock game. Now it's to slime someone. There's, substantiated conspirators and TPing houses and the Jungle Book. I am not kidding you. She started off with quoting the Jungle Book. I
heard her pontificating quite a bit. It's been interesting.
Oh Lord.
You got a dictionary and it goes this.
The state has alleged in their overt acts, okay? These are acts that they claim prove that there's some RICO conspiracy afoot.
You'll hear that on August 23rd, 2013, Shannon was charged with possession of marijuana with intent to distribute approximately 1 ounce over 10 years ago. And you'll hear that he pled guilty and did his time. You'll hear that in 2015, in July of 2015, he was charged with possession of marijuana with intent in possession of a firearm. And you'll hear he pled guilty, took responsibility, did his time. You'll hear that in September 25th of 2019, he was arrested and charged with possession of a firearm. And he took responsibility and he did his time. We're not hiding from the fact that Shannon Stillwell has sold drugs. We're not hiding from the fact that he's been found in possession of marijuana. We're not hiding from the fact that he's been found in possession of a firearm, which is always synonymous with selling drugs.
Don't say that.
These are his past, his truth, and they were his decisions. His motivation was to make money for him, to live, to pay rent, to eat. Ladies and gentlemen, we're not hiding from the past, but the evidence will show that Shannon's decisions, starting over 10 years ago, had nothing to do with YSL or any other organization. You won't hear evidence that Shannon was selling marijuana and then calling someone from YSL saying, hey, I got some money to support the organization, or calling Jeffrey Williams and saying, hey, I got some money for you, man. No, it was for him. He was a drug dealer. He pled guilty. He did his time. Just like thousands of other people in Atlanta. This has nothing to do with YSL, has nothing to do with the January 10th shooting of Donovan Thomas, and it has nothing to do with the 2022 shooting of Jamal Drakes.
Well, I mean,
on count one on this indictment, the state charges Shannon Stillwell with conspiracy to violate the RICO Act. They say on or between January 24, 2013 and the 8th day of May 2022, he and others unlawfully conspired to acquire, maintain directly and indirectly an interest in and control of United States currency and other personal property through a pattern of racketeering.
It's not horrible.
The state in their opening said, further the interests of YSL.
Look, his head is in Bibbidi. He can pull off the bald look, and he doesn't look like he needs Make-A-Wish.
They also said they endeavored to do a lot of stuff to get them a lot of stuff. Okay, it's a little bit more complicated. And in RICO, the actions need to be part of a racketeering organization, not a drug dealer selling drugs to put food on his own table.
I'm reserving
for studio time.
I want to hear it all.
Is a wrap. I'm going to ask you, as a close of evidence, to find Shannon Stillwell not guilty. Count one. Okay. The other color, besides dollar bill green and I guess bud green, that I'd like to talk about is Fulton County blue. Now, Fulton County blue refers to the Fulton County Jail, 901 Rice Street, where people are taken when they're arrested for felony charges in Fulton County. And Fulton County blue refers to the jumpsuits that these individuals wear, the county-issued jumpsuits that are
Just the
typically
hard
navy
color.
blue,
Is
deep
that what
navy
we're
blue,
gonna
with a
say?
Fulton County inmate on the back. You'll hear about the conditions of jail life and Fulton County jail life in particular. And common sense dictates some of this. You're confined to a cell, sometimes with another man sharing that small cell with you. You have no privacy. Use the bathroom in front of men, shower in front of men. You're in fear, danger,
You're separated from your family and your loved ones. But most importantly, the men wearing blue, Fulton County blue, they've lost control of their lives. They've lost control of their destiny. Their destiny is now in the hands of the judicial system, in the hands of prosecutors. Ladies and gentlemen, Fulton County blue is going to be a very important color in this case.
Are they locked up?
The state's key witnesses in this case.
Oh, okay, we're gonna get it now.
They're going to call to testify, that I anticipate that they will call to testify against my client Shannon Stillwell. When they became involved in this case,
Snitches. They got snitches.
they were all wearing the Fulton County blue. When Darius Zachary, Kenneth Copeland, Sammy Davis, Tremont Stillwell, Spencer Wright will hear them testify if they're called. You'll hear what they've said previously, perhaps. But what you should keep in mind is, when did these men say what they have to say? Did they say it when they first got the information to share? Or when they claim they first got the information to share? Or did they share it when they found themselves wearing the Fulton County blue?
Do I look more like
when they
Nicholas
no
now?
longer had control of their destinies,
I am in love.
and they needed a favor. And they
That might be
decided to
the
insert
best ad ever.
themselves into a high-profile case that could solve.
Are you the
all their
treehouse
problems.
shaman?
Yes. That's it. That's exactly what it is. It's in my Viking hat. Won't fit over my headphones.
Let's talk about January 10, 2015. That's the case involving Mr. Thomas. And the evidence will show that this was a high-profile case.
Okay, fine.
And the reason,
Brandon, give me one second.
This is not me talking. I anticipate the evidence will show. I anticipate the state's own witnesses, the state's own gang investigators will tell you, not me talking. I anticipate they will tell you that Donovan Thomas was a big deal, that he was a gangman, that he was the leader of the Inglewood family Bloods in Atlanta, that he was high.
Berry cider.
And that's
Just
what
for
made
you,
this
Brandon.
case a big deal. on
Berry
the street.
cider.
You'll also
You
hear
have
that this
beer. Beer is gross.
case is shooting.
If I wanted to
of Donovan
eat bread,
Thomas
I'd eat bread.
was caught on
Red
surveillance
water
video.
is gross.
Now, I'm not going to suggest that it's the highest quality surveillance video, but it was caught on surveillance video. And you'll be able to watch the surveillance video. And you'll see McDaniel Street in downtown Atlanta at about 7:20 p.m. on January 10, 2015. Remember, winter, it's cold, dark. And you'll see a car zoom down McDaniel Street towards Northside Drive, headed northwest, I believe. And you will see and you will hear testimony that Mr. Thomas was with other individuals. What they were doing, I don't know, but he was with other individuals in a parking lot in between two barbershops, one being Mr. George's barbershop and one being Mr. Bernard's barbershop.
Take care, Gigi.
And you will hear
Have
that
a
this
wonderful rest of
car
your day. Hopefully it gets better for
zoom
you.
down this dark street on that January 9th, and it appears from the video that you will see that an individual starts shooting out of the sunroof in the direction of Donovan Thomas and others. And you'll see that surveillance video for what it is and what it isn't. And you will also see how quickly everything occurred that night. A matter of seconds. Detective Thorpe is the Atlanta Police Department detective that was assigned this case in January 2015, and you'll hear that he gathered the evidence from the crime scene. There was no DNA, there was no fingerprints of value. You'll hear that there were shell casings all along the street, but you won't ever hear that these shell casings were linked to any particular gun or Shannon Stillwell or anything else. And there were no eyewitnesses on January 10, 2015 coming forward saying, yes, I was here and this is what I saw. And I saw this person do this. There was none of that. And you'll hear that this case remained unsolved. No one had been charged for 9 months and 9 days. On October 19th, 2015, 9 months and 9 days after the Donovan Thomas shooting, a man named Nicholas Robinson was arrested on the streets of Atlanta and brought to Fulton County Jail for various pending charges. And you will hear evidence that Mr. Robinson decided he needed help. He didn't want to wear the Fulton County blue. You'll hear that he contacted Atlanta Police Department and got in touch with Detective Thorpe. And Detective Thorpe came out and interviewed this Nicholas Robinson. You'll hear what Nicholas Robinson said in this interview, how he gave his vantage point to Detective Thorpe, how Nicholas Robinson said that he was seated at the MARTA bus bench right across McDaniel Street from the barber shops. And you'll hear that Nicholas Robinson told Detective Thorpe that he saw it all, and he saw the people that were inside the car. And he gave names. Nicholas Robinson said, I saw Antonio Sledge. He came out the sunroof shooting. I saw Kenneth Copeland. He was in the front passenger seat. I saw Demetrion Garlington. He was the driver of this car. Quindarius Zachary, he wasn't there, but he supplied the gun to Antonio Sledge. And yes, I saw Shannon Stillwell, my client, in the back passenger side shooting a handgun. So Detective Thorpe, after taking this information from Nicholas Robinson, who just broke the case, created photo lineups. And you'll learn what a photo lineup is. It's essentially 6 photos that contain a picture of a suspect and then 5 what we call fillers. And you'll learn about that. And Detective Thorpe showed these photo lineups. A photo lineup with Antonio Sledge and a photo lineup with Kenneth Copeland. Each person had their own photo lineup just to ensure that Nicholas Robinson could pick these people out of a photo lineup. And Nicholas Robinson did. And he signed his name, Nicholas Robinson, next to the picture of Antonio Sledge, and next to the picture of Kenneth Copeland, and next to the picture of Demetrion Garlington, and next to the picture of my client, Shannon Stillwell. Nicholas Robinson signed his name and said, these were the people in the car. Ladies and gentlemen, why am I telling you this? Well, Detective Thorpe had 2 small problems. First, you will see the surveillance video.
The only witness that places those people in the vehicle?
Watch the surveillance video.
Yeah, I think
out there, and the fact that there's gunfire
very sus.
going every which way.
See, I like this guy's opening. He's going through the weaknesses of the case and he's spelling it out. I could follow this. I couldn't follow the state's
even
opening.
believable that someone could see 4 people inside a car under those conditions? But there was
No
a bigger
objection to
problem.
the argument there being made there.
You see, you'll learn that during this interview with Nicholas Robinson, it wasn't only Detective Thorpe, there was another investigator there, an investigator Gaither. And while Detective Thorpe was talking to Nicholas Robinson, Detective Gaither was doing some investigation of her own and looking
You
into
do better
Nicholas
than that,
Robinson
Brandon.
and who this guy was who had just been arrested. And after Nicholas Robinson picked out all these people, including my client, Detective Gaither had to
tell Detective Thorpe a little secret. Detective Gaither had to tell Detective Thorpe, that guy in there who just signed those photo lineups that just helped our case, his name isn't really Nicholas Robinson. He lied to us about his name. His name is actually Spencer Wright.
Yes, I can.
So,
Yes, definitely.
case
I
was
have all
solved
the
by someone
controls.
who lied about their name.
He is the
So-
captain now.
What was Detective Thorpe's solution? Well, this is what the evidence would show. Detective Thorpe completely overlooked the lie about the improbability of a man spotting 4 different individuals in the car moving at a high rate of speed in the middle of the night. He overlooked those things. And he said to Nicholas Robinson, or said to Spencer Wright, yeah, I've come to learn that your name is not actually Nicholas Robinson, it's Spencer Wright. Could you look at these photo lineups again? And instead of writing a fake name, Nicholas Robinson, could you actually sign it your real name, Spencer Wright?
I hope this turns
And
out to be
Spencer Wright
true
did.
on examination.
Why did he use that fake name? Everyone knows every fake name should be Rusty
Detective Thorpe
Stafford.
on October 19th,
Yeah.
2015, based on the word of Spencer Wright, the man who had just claimed to be Nicholas Robinson. Detective Thorpe took out warrants for Antonio Sledge, Demekion Garlington, Kenneth Copeland, and my client, Shannon Stillwell, based on what Spencer Wright said. Okay. Since October 19th of 2015, people have had an opportunity to review some things on this case. The surveillance video that you will see, it's interesting because not only does it show McDaniel Street, catch the incident, but it also shows the MARTA park bench right across from the barber shops on McDaniel Street. And know who's in the know who's in the park bench? The bus MARTA bench across from the barber shop? No one. It was all fabricated. It was all made up. It was all a lie. We've been able to review Spencer Wright's jail phone calls to associates made around that time. All but admitting, I'm lying. I need to get out of here.
You think the judge is watching himself on TV,
myself
on YouTube?
into a case so I can get favorable treatment so that others get arrested.
I don't think he's the kind of judge to do that.
The state
I don't
has
think he
since
He's Christmas
dismissed
shopping.
the charges against Antonio Sledge,
Probably.
Kenneth Copeland, and Demekion Garlington. They continue to push
It's
forward
Cyber
against
Monday.
Shannon
You know
Stillwell.
he is.
Why is Spencer Wright so important? Why have I spent so much time talking about someone who clearly lied, who clearly wasn't there, who clearly made things up?
That is a good
Well,
question.
Spencer Wright gives us the blueprint. He tells us what to look out for. What was Spencer Wright wearing when he fabricated his story? Fulton County blue. What did he want? What was he in search of when he fabricated his story? Control of his destiny. He didn't want it to be left in the judicial system. He wanted to use something to get a deal. He wanted to take back control. That's what Men in Blue do. Okay. In this case, I anticipate the state will bring 4 witnesses forward. All 4 have certain things in common, as I stated. When they supposedly came upon information that was relevant, never shared it with law enforcement. But once they were wearing blue, and they needed something, that's when they came up with their stories. I anticipate the state will call Quindarius Zachary, ironically, one of the people accused by Spencer Wright. You'll learn that he claims he knew information from January 10, 2015. January, February, March, April, May, never shared this information with anyone. But lo and behold, you'll hear he found himself in custody for serious charges on August 5th of 2015. Then all of a sudden he had a story to tell. You'll hear he gave a second statement to law enforcement approximately a year later, where he was in a room with the gang investigators, with prosecutors, including the prosecutors that were handling his case and had control over his destiny, his future, and his attorney. And you'll hear that he gave a second statement and was looking for a deal. Quindarius Zachary is no longer wearing blue. Quindarius Zachary is not charged in this case.
I'm liking his opening.
He got his deal.
It's concise. It makes sense to me. I know
You'll hear
exactly
about
his
Kenneth
arguments
Copeland.
that he's going to be making.
Again, someone ironically accused by Spencer Wright. You'll hear that Kenneth Copeland hates jail more than anything. The problem is, for someone that hates jail more than anything, he does a horrible job of avoiding it. And you'll hear that throughout this investigation, he's repeatedly arrested by Atlanta Police Department and other jurisdictions. And you'll hear 2 of those arrests were on June 10th of 2015 for
Jail just
guns,
leaps out and catches
felon
them every
possession of
time.
guns. October 28, 2021, guns, felon possession of guns. And he makes it very clear about what he thinks about wearing the blue. But the interesting thing about him is, as you will hear, is every time he's arrested, law enforcement runs out to talk to him. And he goes to the same song and dance without having to do anything. Just don't don't make me wear that blue.
Hello, hello.
Kenneth Copeland is no longer wearing blue. And he's not charged in this case. I anticipate you may hear from a man named Sammy Davis who claims he was at the scene on January 10, 2015. January through December 2015, never once went to law enforcement. 2016, never once went to law enforcement. But then in March 17, 2017, when he's in jail wearing blue, law enforcement comes out and talks to him.
Hello, hello.
You'll hear his story. His story about how 2 cars were driving down McDaniel Street, and the first car sent a signal to the second car saying Donovan Thomas is just leaving the barber shop, as a signal like it's time to shoot. And how the second car pulled up in front of the barber shop and stopped in the middle of the street. Just stopped. And then people started shooting at Donovan Thomas. You'll hear Sammy Davis' story. You'll also see the video. You'll see that there's no first car, second car. You'll see that there's no signal. You'll see that Donovan Thomas wasn't just leaving the barbershop, that he had, in fact, like the state had already stated, been hanging out with friends in that parking lot for quite some time prior to the shooting. And most importantly, you'll hear, or you'll see on the video, that Sammy Davis's claims that this car stopped are 100% wrong. The car never stops. The car drives on by. Bullets flying everywhere. You'll be able to listen to Sammy Davis's story and compare it to the surveillance video. Figure out
Is this taking place in the nice part of Atlanta?
His story. And finally,
I'm
I
guessing
anticipate you may
not.
hear from a man named Teron Stillwell.
And I keep wanting to add
A man
Sammy
who
Davis
curiously
Jr.
claims he's my client's uncle. Not sure what that's about. You'll hear that he claimed
to come across important information in January of 2015. And he claimed he came across this important information while talking to someone with his wife, Vanetta Guffey, right there. You'll hear throughout all of 2015, never said a word to law enforcement. Wasn't until March 22nd, 2016. Guess what color Tremont Stillwell was wearing at that time?
Blue.
You got it?
Blue.
Green.
Blue. I say
He
blue.
was in jail for serious
Black
charges,
and yellow.
and he
They,
needed
they're
help.
end caps.
He needed help from law enforcement to start to reclaim his destiny, control over his life, to escape the monotony and the filth
Don't
of the
trust those
Fulton
blue
County
boys.
jail. And you'll hear that he claims to have information. You'll hear that the state, to their credit, went to try to corroborate whatever Tremont Stillwell was talking about and talked to his wife, who is now deceased. Her name is Vanetta Guffey. She's now deceased. But you'll hear that she was interviewed on May 11th of 2016 when she was still alive. And you'll hear what she had to say about Tremont Stillwell's claims. That what he's saying happened, never happened, A, and that Tremont Stillwell is a effing liar.
Did he say
Those are the
evidence or did he say the real word?
Those are the men in blue.
My ears are not garbage cans, sir.
Count 2 of this indictment is the count that charges my client, Shannon Stillwell, along with a whole new group of individuals,
Oh, new one.
with the murder of Donovan Thomas. There'll be no forensic evidence, there'll be no ballistic evidence. There'll be no eyewitnesses that presented themselves at the scene to say, I saw this occur. The surveillance video will not give insight as to whether Shannon Stillwell was there or not. The state's case will rest entirely on the word of men in blue. When the evidence is done and trial is done in this case, I'm going to ask that you return a verdict of not guilty to count 2, murder. Okay. Hold on one second, Shannon. Now, I would like to preview a little bit about my client's life after the Donovan Thomas murder. Remember, on October 19th, 2015, the Atlanta Police Department, Detective Thornton, and the news broadcast to the world, and more specifically to the streets, and more specifically to the Inglewood family blood gang that Donovan Thomas was the head of, that my client was responsible. Based on the word of Spencer Wright, based on the word of someone that even the state is saying lied. First they said wasn't completely accurate.
He's grown
No, it was
up.
a lie.
But I've also
Based on
started
that,
drinking,
they
so.
broadcast to everyone that my client was responsible. And there has
And I
been
do have a
repercussions.
type, tall, lanky, a little bit nerdy.
You'll hear in 2015, people pulled up to my client as he stood outside a store, shot a gun at his head, and grazed his forehead. Thankfully, he's still with us.
On his hair.
You'll hear that later in 2015, my client went to go get a fish dinner with the mother of his child and another young lady named Tiara Jones at JJ's Fish at the corner of University and Pryor. And members of the gang spotted them there, stalked that car, drove behind the car, and unleashed bullets upon that car, hitting that poor lady, the driver, Tiara Jones, in the face, killing her, causing the car to crash and spin, breaking bones in my client's body, collapsing his lungs.
The streets have not cared that Spencer Wright is a liar. Since that time, my client's life has changed in some small ways and some big ways that I've made sense. Shannon Stillwell, since that time, has been careful about his surroundings. He tends to back into parking spots. He tends to run red lights at intersections, not to be a
Oh, well,
sitting
that's
guy
safe for the rest of us.
for IFA members or anyone else. He habitually changes residences. And yes, he does habitually rent cars, including a white Audi. He does this, the evidence will show, so no one can associate him with any particular car. None of
Okay,
the
I'm
IFA
sorry, but if you're
members
doing that,
can know where he is.
you're up to something no
And
good.
yes, when he rents cars, he does tint their windows, so no one can see in. That's the life he leads since 2015. And yes, when he leaves the house late at night, he does conceal his identity. It was during COVID, but he does wear a mask.
He sounds like a prepper.
He
during
sounds
COVID.
like, I'm
That's been
confused.
Shannon Stillwell's life since 2015.
Is he in Mission
I'm gonna ask you-
Impossible?
I mean, all of this sounds really bad. He's not doing a good job explaining why his client does all of this, other than he's up to no good.
He was listening to Anthony Fauci. He was being a good citizen.
Holy Jesus. This guy is going to run into. Okay, this is what's going to piss me off. This guy's going to run a red light and run into a family of like 8 Catholics, you know, going to church because he's, you know, trying to run away from another bunch of, you know, young slime life people, or I don't know, Corner Street 8 or whatever.
Yeah.
Because he's afraid. So he's going to run into, you know, the church bus with all the kindergarten nursery kids. And, you know, because he was afraid, and little Timmy just had to go because he was all afeared for his life. And he's going to get what, probation or something from a judge.
Yep.
I'm
Best.
about done.
Thank you for the 199 super chat. So many people run red lights in Atlanta. I mean, so many people run red lights everywhere. It's in downtown Detroit. It's a suggestion. Red lights are. It's not at all a requirement. And yes, that would be since my infamous ferry tour with Nick and Baker.
And into account as you consider the evidence as it's presented.
That's what
Now,
I'm getting,
7
Lou.
years later, March 14, 2022, remember, Shannon has been publicly accused, but no one has ever taken that case to court. No one has ever even tried to actually prove the case. They just accused the case. And Shannon has remained a wanted man. Not by the police, but by someone scary.
That was a dig at the
On March
cop.
14, 2022, the evidence will show that Shannon, Quamarvius Nichols, Nikion Garlington, and Miles Farley were planning on going to the music studio to work on music. Still chasing him.
You got to live that thug life where the music doesn't come out
Mr.
genuine.
Garlington was a passenger in Mr. Stillwell's and Shannon's rented white Audi with tinted windows.
Because the judge is allowing it.
Mr. Nichols was with Mr. Farley in Mr. Nichols' white Ford Fusion. The evidence, and you'll see
Serious question.
in
On a
this
big
case,
case
you'll
like
see
this,
Yep.
does the jury
Where they did, like, one created her own binder and then went home. I think it was the Rittenhouse case. the one juror like created a binder and wanted
yeah.
like jury instructions and extra copies and take it home and stuff. Yeah.
The final day.
Mhm.
And that was, she was on the fence. She was one of the holdouts.
Apparently.
And
But yeah, I mean, you'd have to in this case. You'd have to have the whiteboard, the murder board, as we say.
Yes.
There's several different surveillance videos that you'll see in this case. The first being the BP footage. That's from the BP at the corner of Fulton Street and Windsor Street in Atlanta. And you'll see the video.
I'm going to go
You'll
there.
see Mr. Stillwell. No, we will never deny that he was at the BP. We will never deny that. We'll never deny that he was in a rented white Audi. And you'll see Mr. Stillwell pull up on that camera and back into a parking spot right in front of the BP. And you will see Mr. Nichols shortly thereafter in his white Ford Fusion pull up at the gas tank so he can purchase gas to get to the studio. You'll see footage from inside of the store. That's Mr. Nichols. You'll find out that that's Mr. Nichols purchasing an item, and that's Mr. Stillwell, my client, wearing a Pink Floyd hoodie with a pink wool cap on. And you'll be able to observe them on video, and you'll see Miles Farley, a third person in their group, a shorter individual, come in, and you'll see them playing around and pushing each other in a playful manner as friends do.
Well, it's only
I'm gonna
25
ask
here,
you
Wim.
to observe them on a video and ask yourself, does that appear to be men on a mission? Or does it appear to be friends just planning on going to the studio? The video will reveal that at some point, a gentleman by the name of Shamal Drinks pulls up in a red car at another, and in fact, I believe that's a picture of it right there at that gas pump. And he enters the store. You'll be able to see the video of him entering the store from the parking lot, and you'll be able to see him enter while my client's car was.
You still see the spinning wheel of death. What the hell?
I can.
On Rumble, it's working. Okay, on Rumble, it's working. We're going to keep going.
No, it's working now. No, it's working on YouTube.
So this March 14, 2022 case, what I anticipate is you will not hear any eyewitnesses say that Shannon Stillwell. And let's be clear, the state is accusing Shannon Stillwell. I mentioned that there's 4 people in this party. They are accusing Shannon Stillwell of shooting Mr. Drinks out of that white Audi. The state will not present to you any witnesses that saw this occur. The state will not present to you any forensic evidence that proves that this occurred. The surveillance I submit to you, and you'll be able to see and judge for yourself, points to the exact opposite, that the shots did not come from Mr. Stillwell's car, nor did, and I'm not suggesting they came from Mr. Nichols either, it came from neither car. So why was Shannon Stillwell arrested? Well, they had video of Shannon at the BP. Okay, that's fine, we don't deny that, never will. They made certain assumptions about what would be on that FedEx video that you will be able to look at and determine what it shows and what it doesn't show. And I'm sure they assumed that it would show some shooting, but it doesn't. And finally, they made assumptions about Shannon Stillwell. Remember what the state said in open about how Detective Hogan had his case, and he had people on the video at the BP, which is near where the shooting occurred, but not where the shooting occurred. He had people on his video.
Hearing
and then he talked
not
about
BP, but something else.
Yeah, I know. Yeah.
another detective, Viverito, and Viverito said, "Oh, that's Shannon Stillwell. That's Shannon Stillwell. Oh, that's Marcus Nichols." And they just ran with it. Yeah. Shannon Stillwell was at the BP that night.
Hey, Moni Money.
He didn't shoot Shamal Drinks. None of his friends shot Shamal Drinks. They went to the studio. Since these warrants were taken out for Shannon Stillwell, and I'll tell you, the warrants were taken out and Shannon Stillwell was arrested in that same white Audi on March 17th, 2022, 3 days later. Since those warrants have been taken out, some other information has come forward. First, I'm going to ask you, and this will be entered into evidence, I'm going to ask that you consider the rental agreement for the white Audi. You will learn that on March 16th, 2 days after this alleged shooting, where every other person who has a guilty conscience, anyone who has a guilty conscience is trying to get out of the rental car, Shannon extended his lease. I'm going to ask you to consider and really think about that. Extending a lease of a car that you supposedly just killed someone. Are those the actions of someone who's guilty of that crime? You're going to hear about the wiretap on Demekion Garlington's phone. Remember, Demekion Garlington was in Mr. Stillwell's car. And the state hinted at it a little bit. They were talking about Jaden Myrick and people wanting to attack a man named Lucci. And based on these concerns in the jail, the state applied for it, and you'll learn what a wiretap is. They applied for a wiretap and received a wiretap for Demekion Garlington's phone. The phone of the person who was with Shannon Stillwell on March 14, 2022. And you'll learn what a wiretap is.
Brandon.
And how a wiretap really consists of law enforcement sitting and listening in on all your phone calls, incoming and outgoing, and recording all the relevant and pertinent phone calls and conversations that occur. You'll learn that this wiretap on Demekion Garlington's phone began on March 10th, but certainly well before March 14th, the date of the Shamala Drink shoot. So it was in place that night. Who knows about the wiretap? You'll learn that too. Do you think the government tells you that your phone is being wiretapped? Of course they don't.
I would hope
It's
they would.
secret. No one knows. That's the point. And you'll learn about who Demekion Garlington is and what type of guy he is. I would submit, if you have a secret, you wouldn't want to tell Demekion Garlington. You'll hear him on the wiretap, drunk, high, talking about everything under the sun. Pills, weed, guns, girls, robberies, all stuff that he's involved in, completely against his interests to discuss, but he doesn't know he's being listened to now. But one thing that's interesting, of all the things that this loudmouth talks about, all the crimes, and they said they bragged about this stuff. They said Demekion Garlington was bragging about this stuff. All the things they brag about, no, it never comes up. Shooting anyone on March 14, 2022. All the crimes he discusses, that never comes up.
The court reporter looks really angry.
She's looked like that, but she's happier.
Most importantly,
That's not the
the
prosecutor.
science about this March 14, 2022 case. We're going to learn about gunshot residue.
Oh, goodies.
Gunshot residue testing that tests for microscopic particles that contain a combination of lead, barium, and antimony. Particles that come from the explosion of a gun and the gunshot primer that causes it. Synonymous with a firearm that has been fired.
Case in the Mondays.
Who does gunshot residue testing?
Of course, you would say that, Salvador.
Georgia Bureau of Investigation, ACD, all sorts of agencies to build cases against defendants. You'll learn how gunshot residue is collected. How you take a surface or a body part
or an object, you take these adhesive stubs, these official gunshot residue kits, and you dab the surface of an item as much as you want. You can use multiple stubs. And then you take these stubs and you place them under an electron microscope. And a scientist can look under this microscope and see if there's any particles of gunshot residue that are on
What's a
said
microscope?
No
You'll
idea.
hear that Shannon Stillwell was arrested on March 17th in that same white Audi that he was in on the 14th. And you will hear that the crime scene technicians, in this case, made a specific decision to pick the best place on a car to test for gunshot residue. When the gun is fired, the gunshot residue would plume upwards. And so they take the best part of the car, the headliner. And for all of you that don't know what the headliner is, that's the cloth top of the car, as pictured right there. You'll hear about Alexander Coven, a scientist, a man in search of the truth, a man who works for GBI, not for me, not for Shannon Stillwell. And you'll hear how that headliner that was collected from that white Audi on March 17th was brought to Alexander Coven at the Georgia Bureau of Investigation. You'll hear he's an expert in gunshot residue collection and analysis and detection. And you'll hear how Mr. Coven, as he was trained, took that gunshot residue kit, took those adhesive tabs, and dabbed that headliner again and again and again and again and again and again, dozens of times. And then he wanted to make sure what he did was sufficient, so he took a second tab, adhesive tab, a fresh one, and continued to dab that headliner again and again and again and again and again to pick up any particles that would be on the headliner from that white Audi. And he took those tabs, those adhesive tabs, and he put them under his microscope that he uses when he's building cases for the state. And he looked at those tabs under that microscope for any particle of gunshot residue, any at all. Looking for 15, 10, 5, 3, 1, whatever he could see. You'll hear that on June 3rd, 2022, 77 days after the state, after Detective Hogan, Investigator Viverito, and the state made their decision that Shannon Jackson fired a gun, Shannon Stillwell fired a gun from that white Audi. 77 days after they made that decision, you'll hear that scientist Coven released his report. Not that headliner.
Scientist
there was not a single
I don't know what he just said.
gunshot residue to be found. That's the science.
But he's not going to trust the science in other spots.
Ladies and gentlemen, regarding the March 14, 2022 case, the state has made 5 charges, 5 different counts against Shannon Stillwell, my client. First is count 49 on this indictment. It is murder, alleging that he shot out of the white Audi his child, Shamal Drinks. The science belies those accusations. I'm going to ask you to find Shannon Stillwell not guilty of that count. Now, count 50 and 51 deal with violations of the Criminal Street Gang Act, Gang Activity Act, and they are essentially charges that say that Mr. Stillwell committed murder to further the interests of YSL, and he committed murder on behalf of YSL for the purposes of increasing his standing within the gang.
Y'all are smart people. Obviously, I don't need to say it, but it'll make me feel better if I say it. If he's not guilty of count 49 murder, he cannot be guilty of count 50, and he cannot be guilty of count 51. Counts 52 and 54 similarly charge Shannon Stillwell with possession of a firearm by a convicted felon
Isn't this argument?
March 14th of 2022.
Yeah, but no one's
on the
objecting.
belief
He's
that he
argued a few
used a
times.
firearm to kill Shamal Drinks. If the state does not prove that case beyond a reasonable doubt, he cannot be found guilty of count 52. And in count 54 charges Shannon Stillwell with possession of a firearm during the commission of a felony, that felony being murder. Obviously, if he didn't commit the murder, then he cannot be in possession of a firearm during the commission of said felony.
Nope.
Well, there you go. I have who was he supposed to have killed?
That
Do y'all
Dimitri
remember?
guy? I don't know.
Someone?
My client has been charged with 2 separate murders.
There's like 50
He's been
counts. This
wrongfully
guy has got
accused
2 of them.
2 separate murders. We plead absolutely not guilty. He's been charged with conspiracy to violate the RICO Act. And while now, he has sold marijuana in the past.
That's what I thought, Harold.
Those were his decisions. For his benefit.
Is it over 100?
And had nothing to do with YSL or anyone else.
I saw the
involved in this case.
indictment earlier.
Maybe even way more.
He's pled guilty to those
I only
charges.
got up to like
He's
50
done his
some.
time.
I thought I was close to the
That
end,
makes
but maybe
him
not.
an ex-drug dealer. It doesn't make him a conspirator. It doesn't make him guilty of violating any RICO acts. The ground rules.
No, he's just an
Shannon Stillwell is
ex-drug
presumed
dealer.
innocent. State bears the burden of proof, and the standard of proof is beyond a reasonable doubt. I believe in this case, if you focus on where the state's evidence comes from, you will find that primarily it comes from the stories of men wearing blue. I'm going to ask you to focus on things like science instead of
Not
stories.
science.
Compare the credibility of a scientist like GBI scientist Kobe, who followed all the
Thank you for the
rules
$5 super
and
chat.
determined there was absolutely 0 gunshot residue in that outlet.
I should pause to read this. Sal, everyone is too stunned to object to the story of Detective Burrito pinging Dr. COVID. Yes.
I'm so confused. I can't even understand.
Spencer Wright,
Farrell,
who said his name
it's
was
for
Nicholas Robinson,
7 or 8 people
who
now.
lied.
Originally,
Get out
there's
of
like
jail.
24.
Yeah, how many is this trial covering?
7, I think. Donna
7?
says 6.
No, six. I
Okay.
think everyone else, because it was 24, I think
Yeah.
everyone else has either pled or
Plead,
turned state's evidence, and they have
These are
just
class 6. Okay.
yeah.
And this is expected to go 6 months. Anticipate a year worth of
I
trial.
thought it was going to be a lot quicker with only 6 defendants, but
No,
Look,
well
I have
they cut the
I have a
defendants
dollar.
in half or a quarter of them, and then they quadrupled the number of witnesses.
which makes sense.
Would you say, Mo?
I said I have a dollar that we will still be on, opening statements next year.
I think we're going to be done for the day. I can't imagine. It's 5:30
This is the
now.
first witness for first opening for defense, right?
This is the first defense
Yeah.
opening. Yeah. 5 more.
So yeah, I'm there with you. That tie does not invoke confidence.
You
Even
don't
though
even
I-
notice. Let me see.
On
David's
October
gonna love it.
19th
It's terrible.
of
Probably gonna love
2016.
it. I love
And
to.
that is on
I have some
Detective
ties I'm
George.
sending you, David.
I am
demand you
going
wear
to do
them.
my best to make sure that the truth comes out in this case. Make sure that no one wearing blue will be
Or this
able to
tie.
dupe anyone during this trial. My client, Shannon Stillwell, is not.
I forgot his
guilty.
client's name for a
Thank you very
second.
much.
No, it's okay. It could be doable. I'm not a huge fan of it. Looks too much like a snake.
Ladies and gentlemen, how you doing? It's 5:30. Consistent with my earlier promises to you, I think it might be a natural stopping point for us to put a pin in today and for us to come back tomorrow unless you all object to my suggestion. Hearing no objection, I think we're going to go ahead and do that. So let's go ahead and kind of review a couple of things to begin with. All right, first thing is when you go back into your headquarters jury deliberation room, dump your notepads, okay? Hopefully everybody's written their name in the inside cover of those freaking ones like I told you earlier. But if you haven't done so, go ahead and do so. Take a juror sticker and put it in your pocket, your purse, or whatever carrier device you have, so that when you come back in tomorrow morning, we'll go ahead and you can put that on as soon as you get into as you come in through the being screened in the courthouse, okay? All right. You kind of figured out already for tomorrow, if you need, and I think I mentioned to you this earlier, a lot of you wearing jackets and everything else. It's easier, like I said, for you to put on a jacket or for you to take off something than it is for me to kind of regulate the temperature. So please bring whatever it is that'll make you comfortable tomorrow, your jacket or otherwise. Okay, that's kind of the administrator. And if you're running late tomorrow, as I mentioned earlier, let Ms. Umana know. But remember, I can't start until I've accounted for all 18 of you. So it's very important you, again, as I mentioned earlier, only you know how long it takes for you to get down here to Fulton County from wherever you live in our great county. So just plan accordingly, leave a little bit earlier. It's always easier for you to sit back there and just kind of relax and don't be so stressed than it is for you to kind of leave late. That just kind of just puts you in kind of a position that you probably are stressed already when you get here. So I'd advise you to do that. Okay, you remember all my ad nauseam admonitions? They still apply, okay? So very important. I mean, that you not talk about the case amongst each other as you're walking out. Do not talk about the case as you're in your headquarters jury deliberation room. Don't go on any social media sites. Do not let anybody friend you. Do not do any of the other things that I told you earlier, like research anything, go buy any scenes, take any photographs, or otherwise try and educate yourself to some things that you may have heard in the courtroom today. Remember, the only things you can consider are what's lawfully presented within the four walls of this courtroom. So it's very important that you consider and keep the court's admonitions, which I know you will continue to do so.
I mean, I'm feeling confident that the defense
what happened in court?
has a decent case.
Are you supposed to respond?
My feelings are,
no, you're not.
why are we being punished? We didn't join a not gang.
Because remember,
Holy crap, that woman, is she a lawyer?
We found out about it. Would affect your ability
Well,
to
she
have a fair
didn't
trial,
join a
lawful trial,
nunnery,
lawful
so
please
she's that lady that throws cats in Simpsons.
and all the others. Okay?
Now you can't unsee it.
This poor gangster. Oh, your lawyer's here to see you. Come here. And then this little old lady walks into the room.
If anybody should try and do so, okay?
Hi.
And consistent with my instructions,
Hi there,
when
sir.
you're here before, we'll
She's
go ahead and
glowing.
get you squared away for those of you that are taking the shuttle.
Okay,
and for
the
those of you
houndstooth
that
suit,
make other
David.
alternative arrangements. We have.
I can't pull it off,
He'll go ahead.
but it's not
and coordinate that
bad.
for you,
I just
okay?
can't pull it
All
off.
right. So you're probably wondering what time are we gonna start tomorrow morning?
The purple
I need
suit?
you all
No.
here to be here by 10
Okay,
o'clock,
and
okay?
Gray on gray on
Start
gray? No.
Somewhere between 10 and 10:30 tomorrow morning.
So they each have
And
one
I'll do
attorney?
that, try and give that to you every single
Yeah,
night that
well,
we conclude. Take
at
what
least
time
one.
in
They
the
have a
morning
couple.
You need to come to be here. That's your target or mark time you need to be here in the morning. Try and get here a little bit earlier because then, like I said, you'll be a whole lot more at peace. And then as soon as we, at 10 o'clock, are they around? I can find out if all 18 of you are here and I don't have to look for anybody. And then I can go ahead and we can get started.
Redirecting Ukraine.
Ready to pick up from where we left off from today. Okay, so $1,000 tomorrow. You need to be in your headquarters. Okay, I think I've gone through all the things I need
No,
to
the
with you.
jury is.
Any ministerial inquiry
Holy
we need this
crap.
time, ladies and gentlemen. Anything from me?
The jury got like 3 hours of testimony today, or
Oh, not even
argument.
testimony. We haven't even made it. Haven't even made it through openings.
We still have 5 more openings to do.
The patience that you've given us are giving us today and will continue to give us throughout the consideration of this matter.
You
So
missed
unless you
these.
have any other query or questions from me,
Yes.
I will release you until tomorrow morning.
Really, how old was that woman? Like,
we'll see you in the
I'm
morning.
here.
We'll start up when you all
She's
get
like
here
the
at,
old lady in
at
the
10
airplane
okay?
who speaks
All
jive.
right, so with that, ladies and gentlemen, have a good evening.
That is a
She's an
great
expert on
movie.
games.
Oh my gosh.
At least 2 hours of sidebars tomorrow, guaranteed. All right. Let's see if the judge has anything to address.
I don't know what's happened to it, but yeah.
Turn it up.
Anyways, Mr. Happ? Okay, all right. So we'll start tomorrow with that, and we anticipate.
Fix your mics over the night.
After we complete opening statements, stating you're prepared to call your first witness?
Yes.
Okay, all right. Any other inquiry made at this point in time? Okay, hearing none then, folks. Appreciate your patience and diligence. I'll see you all tomorrow morning for our anticipated 10 o'clock start time. Please try and be here about 9:30, and then we'll go ahead and I'll take up Mr. Harvey's matter, and we'll go ahead and get started, okay? All right, we're in recess.
They couldn't prosecute separately. There's no real evidence.
Well, that's, I mean, that's the problem. Hang on, I got to get rid of the branding here. Yeah, that's the problem with bringing everybody separate, is that you're lacking the evidence. You're required. Well, I mean, no, they could have done it separately. They could say, oh, this person was this other defendant number 2 and 3 and 4 that aren't on trial right now, were colluding with defendant 1 that is on trial and, solicited or co-conspired or whatever, committed the unaliving that they're being charged with. But since they brought it as a RICO, I still don't think they'd have to bring it all together. I just think she chose to. And I think that was a big problem for the judge in managing this whole case. It was probably a bad idea. I don't know.
Now, I only saw the opening.
Yes, Fahala, she has a Werther's original in her pocket.
Here you go,
and a
son.
used Kleenex.
You've just been convicted of unaliving. Have a Werther's. How was the rest of the state's opening?
Nonsensical.
Okay. I didn't see that.
I mean, I couldn't follow it. I was listening to it, but I was not able to make any sense of it.
The problem with it is when you have so many people. Look, the Adelson case was confusing enough, and that was with having already gone through, the Catherine McBanawa case and kind of going through that and already knowing it and having done the pre-murder board. So having done all that, you have there are so many names, and then there are so many different things going on. And she doesn't clarify anything. She doesn't have logical things, and maybe they're spelled out on the, slides, but then the defense attorneys are saying the slides are inaccurate. So there's a lot of things that, to me, as a casual observer, it looks like cluster F. It really does. I can't put names to things, to times, to dates.
And so hopefully, Nick's been covering this a lot, right? And you too, a little bit.
I've been watching a little bit of what they've been doing. I kind of got stuck. I ship Little Bowtie Man who does the enhance and delete or whatever, because I stink too at graphical stuff. But
I'm guessing this is going to go longer than OJ.
Yeah, 6 to 9 months is what they're guessing right now. I say a year. I told Nick that he's going to be doing this for a year.
Poor bastard.
Yeah, I know. I'm not covering every night for him, but I would happily cover whenever he needs me, but it just can't be every night. But yeah, I say it's going to be a year. And the problem with this case for me is I know nothing about it. I've watched a couple of Nick's streams, but I kind of forgot the gist of it. I haven't been covering it like him. So I'm going to the state and the prosecutor for a cohesive story about what's going on. And I wasn't able to follow her. But the defense's opening statement, I was able to follow that. If it's not him and he wasn't there, and the only witness, right, is a guy who's trying to get a deal, that sounds like a pretty poor case, at least against Shannon, whatever his name is.
I gather that a lot of their evidence are state-assisted witnesses who are, currently housed in prison. And it seems like a lot of it is innuendo. They don't have concrete proof. They've got a lot of conjecture. They've got a lot of, all right, I'm going to go produce a trial. Well, I guess, good luck. Let's go, Brandon.
Yes, yeah, poor Nicholas. He's sleeping away while we're here, slaving away at his on his mess of a trial.
Taking his super chats.
Mo Jr. is always a good, strong name to give a child. Just saying.
Can you guys please grift for me? Everyone go follow Excited. Go
Yeah.
subscribe. Yeah. She had a good
He
stream
knows all
earlier
the
today.
graphical
She had a video she dropped yesterday. She's covering this Australian case.
Yes.
A politician is on trial. So those are fun. I don't know what that's like to have a politician on trial. We don't have that in the US.
We are cultured and we are civilized.
Yeah, I
And
mean,
I'm like-
according to the defense, the video is going to show something very differently than what the state says, right? And so if you have a state's witness, regardless if he's a informant or not, or trying to get a deal or not, but says something, and the video clearly shows something different, i.e. Rittenhouse, they might have a tough case.
Yeah. Can somebody
Are we not a politician?
post my
He's a
link in
government
the
agent or
chat?
something.
I'm like 56 away from
Yes,
monetization.
everyone go sub to Sal so that we can find him love after lockup.
Yes, that'll be my
Wow.
first grift stream.
When he
Love
hits
after lockup?
500.
Yeah.
Yes. We will find
Okay.
his closest parolee and
Are you going to actually start
married
sending
to
letters?
her.
Because you've been promising it with
I
Jody
know, I
Arias
haven't
for a
achieved.
while.
Yeah, I got the app actually to do that, so I just need to get the letter together.
Okay.
All
right.
I got a
Two
couple other girls.
magazines and safety scissors and stick of glue, and we will get them all together.
And make sure you subscribe to the Viking Cat, who is
Shut up, Val.
right over here, down here in the corner. This is his channel. I'm just here supervising. And yeah, so subscribe to Nick. He's going to be covering this gavel to gavel. I don't know if he's going to cover it gavel to gavel. He's going to cover a
He's
lot
gonna
of it.
try.
He's going to try. Yes, this might exhaust him. This might drive him to insanity. Who wants to take
Yeah.
bets on that?
He's
I
gonna
say
need
he
help.
lasts 3 months. And then
I
he is
give
going
it,
to
I give it 4 weeks if
4
the
weeks.
if the shenanigans continue.
Before
He's
no,
gonna
I'm
need an
thinking like he's
emotional
going to
support
completely
pet.
bow out. He's like, nope, I'm done. He either goes insane or he quits. YouTube, like quits YouTube. I give him 3 months on that.
Does Sweden have a nice mental hospital?
I think they actually do. They do
Yeah.
prioritize mental health very.
Oh,
He's
wonder
gonna
what
go
that's
do one
like.
of those polar bear plunges. Dread his hair.
Dread his hair
Oh my gosh,
before this is done.
Valhalla! If he
Yeah.
dreads his hair, I
my
will
God, like one
give
of the
you
defendants.
$1.
Yes,
If
definitely.
he goes full Coolio, I will give you
cornrows.
$2.
Can we think we can get him into some cornrows?
Oh my god!
Brandon thinks a
I
week.
would.
He can last longer than a week.
You last 60 seconds.
Yeah, he's stuck with that. What was it? The Texas.
Okay, true. He did only make it half a day. No, that wasn't Nick. That was me and Baker.
Yeah.
Oh, yeah,
That
that was a
Texas
horrible
case.
trial.
Tricked Baker
That
into
was a
taking
horrible-
the rest of it.
I gave
yeah.
up on that.
Sucker.
I love Baker's mentality of like, nope, this trial is boring. I'm done. Me, I have this urge to like, I gotta do all of
Rule
it
of
if I
completeness.
started it.
You're a completionist.
Yeah, and then I gave up on that with the Whitmer case because we already had a verdict. And
Yeah.
actually the Armstrong case too, with that Valhalla and I were covering.
Well,
It's like we got a verdict. Okay, I'm done. So
Yeah.
I'm taking Baker's lead on that. But we're not going to get a verdict anytime soon in this case.
The boy in the box case nearly broke me. I was just like, oh my God, can that be done now?
I know. Yeah, we commit to it. No, but Nick will be back tomorrow morning. So hit the subscribe button, everyone who's watching right now. And if you haven't already, and then make sure all the notifications are turned on so you get this. And then if you're watching on Rumble, which I don't have Rumble up, also hit the subscribe. And you should actually, my notifications for Rumble come through a lot better than the YouTube ones. So, but Nick will be back tomorrow morning with the rest of this day 2, which maybe we'll
I
get
don't know. Is
through.
he
Fingers
tomorrow
crossed, 1 or 2 more. I thought he was.
Oh no, maybe he has to work in the morning, but I think he'll cover the trial.
Well, his morning,
is not ours.
Is our night.
Yeah, okay.
His evening is when this starts.
Okay.
So
we'll be done with work. Okay.
Yeah.
It's a trick.
It's I'm
He's in a
planning
good
on now
spot to stream,
streaming with
actually.
someone in Japan now, so I have to add another entire freaking country.
Yeah.
It's a nightmare.
Are we going to Val's drinking stream? I don't know if he has redirects set up. I could log in and do that, but I'm not going to. I'm trying to figure out like how he ends his streams.
Okay, and guys, don't forget at 7:00 it is Newsy News. It'll be slightly boozy news tonight, but we will be having Newsy News for about an hour. I've got a bunch of stories. There have been shenanigans put around the world today, and I am going to have to figure out how to do some Newsy News in the noon for Newsy News Nooners while covering this trial with Nick. So I think we're going to have to figure that out, but
I have a swoop. I have all the controls. All right, I'm gonna figure out. I think I figured out how to end the stream the way
You hit
Nick
end
does
stream.
it. Well, yeah, I mean that part I've got down. No, I meant the video. Oh, I can end this. Okay. All right. Thanks everybody for watching Nick's stream. Thanks Mo in Salvador for hanging out with me. Well, Mo, you were hanging out more with Nick, but
Yeah.
I think I got this figured out. Okay.
I'm everyone's official side piece. I really am.
Yep.
That's good. It's
Other than
you know,
Jamie.
It's
we share.
I love your confidence in that statement.
It is. It's how you say it, really. You just have to say it with confidence. I'm everyone's side chick.
Nice.
If you say it with confidence, it's not shameful.
Good night, guys. Bye.